so then Guzman.
Yes.
And what do I do to get the interpreter?
You're gonna go add the plus button. Okay. And then you're
And then hit add.
yes.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has not been sworn yet.
All right, if you could raise your right hand. Do you swear to interpret from English to Spanish and Spanish to English to the best of your ability, so help you God?
Yes, I do, Your Honor. Theodore Leal for the record.
All right. Your name, sir?
I'm sorry, it seems like the defendant's having a bit of a hard time hearing the interpreter. Give me one more time, please.
It's not coming through the
this,
earpiece.
Can we do it without the headphones? Your name, sir?
¿Su nombre, señor?
Euclides Macario Guzman.
Euclides Macario Guzmán.
You're here in case number 20CT473.
Usted está en el caso 20CT473. Es el número de caso.
Failure to appear on a no valid driver's license.
Por una incomparecencia para un caso de no tener licencia válida.
If we give you a new court date, sir, will you appear?
Señor, si le damos una nueva fecha de comparecencia, ¿usted va a comparecer la próxima vez?
Sí, porque yo no sabía eso. Yo fui a una corte, pero estaba cerrado. Yo tengo la foto que a mí me dijo el encargado que tomara la foto.
Yes, the thing is that I didn't know. I actually went to a court, but everything was closed. I actually have the picture.
Sir, I'm going to release you without having to post a bond.
Sin fianza.
¿Pero qué?
Le voy a dar libertad sin fianza. Va a salir bajo libertad.
Ok, muchísimas gracias.
Thank you very much.
We're going to give you a court date when you're released from the jail. Make sure you go to that court date.
Le vamos a dar una nueva fecha de comparecencia en lo que salga de la corte, pero asegúrese de estar presente en esa nueva fecha.
Ok, pero ahora yo vivo en la Charles Street 144.
Right now, I live on 144 Callot Street.
We'll give you a change of address form. Make sure your address is up to date.
Le vamos a dar un formulario de cambio de dirección para que su dirección esté actualizada.
Ok.
We
All
all
right.
are.
Thank you.
Okay.
Judge, he has
Gracias.
an immigration defender.
Oh, he does? He has a hold for immigration, so once that's cleared, if and when that's cleared, he'll be released.
And Your Honor, you
Usted
appointed
tiene-
the public defender? Could you, because he might be in jail for a while?
It's fine.
Thank you.
Usted tiene una solicitud del Departamento de Inmigración. Hasta que ese asunto se resuelva, usted no podrá salir hasta que se resuelva la solicitud de inmigración.
Ok.
Ok,
Thank you.
gracias.
Mr. Interpreter, if you could ask if there's anyone that needs the services of the Spanish interpreter to please raise their hand.
Yes, Your Honor. At the court request, interpreter will make a brief announcement in Spanish.
Okay.
Si alguno de los presentes requiere servicio, levante la mano derecha.
No hands raised. Thank you.
You're very welcome, Your Honor.
Do I hit end call or do I do anything?
When he disconnects to the angle.
Okay. All right, your name, sir?
Connor Sanders. We have a private
All
attorney.
right, there we go. And then counsel, your name for the record?
Harry Vance, Your Honor?
2020 MM175AE, one count of battery. Do we have any victims here for this?
Yes, Your Honor. The alleged victim's outside. I had a chance to speak to him before we came in. His name's Jason Taft.
All right, let's bring him in real quick. Taft?
Taft?
Okay. All right, sir, your name?
Jason Taft.
All right, so you're listed as the alleged victim in this case. As the alleged victim, you're entitled to provide input with regards to conditions of his release. I know you spoke to Ms. Rentz earlier, and she could probably summarize what the discussion you guys had, because she's an attorney, she does this, but is there anything you want to tell me, anything you think I should know?
Your Honor, I'm not in fear of Connor. I've gone through the victim, pamphlet given here. My only request would be he would be released and reside at his father's house and not our house.
Okay.
And additionally, I have no issue with contact as long as it's not hostile.
Okay. Maintain separate residence, no hostile contact?
Yes, Your Honor.
Okay. Does he need to go back for any reason? To retrieve any belongings or anything?
Oh, no,
for
this
work?
is his stepfather. He also has a place at his dad's house.
Okay. So you guys are gonna live in separate residence?
Yes, sir.
Okay. All right, State, do you have any questions for him?
No, Your Honor. Thank you, sir.
Thank
All
you.
right. Any
I
questions?
have no questions
All right,
for
any
him.
input from the state?
Your Honor, the state would recommend a bond of $500, no hostile contact, and maintain separate residence, possess no weapons, firearms, or ammunition.
All right, anything from the defense?
No, we would agree with that, Your
Okay.
Honor.
All right. Does you want PTR or the bond?
The bond, please.
All right. All right, 500, no hostile contact, maintain separate residence, do not possess any guns, knives, or weapons, okay?
Yes, sir.
All right, thank you. Thank you for being here.
Thank you, Your Honor.
Is that everything for you?
Yes, Your Honor.
All
Good
right,
to see you.
Good to see you. Your name, sir?
Jimmy Rowe.
I'm sorry, one more time?
Jimmy Rowe. R-O-E.
What happened to Jamie Ewing?
He's medical, Your Honor.
All right.
Oh, Your Honor, could we address Ewing despite it being medical?
Well, let's see. So it was rolled for PC from what day? The 11th?
It's been 72 hours, and she qualifies for pretrial release, and she can't get out because it's a misdemeanor domestic violence, and they stayed the bond.
Well, has the state been able to provide anything?
Your Honor, if I may have a moment, I did not see anything.
Has it been 48 or 72?
I just know the order said reset for 72 hours, and
Yeah.
it was on July 11th, so I guess
12, 13, so it's only been 48 hours.
And Your Honor, if we may address this at the end of the session, just so that I can get in touch with the weekend.
Here's what I'll do. I'll put it on for second session.
Okay.
All right. All right, Jimmy Rowe. That's you, sir?
Yes, sir.
All right. Defense attorney, you were looking for, what does that say?
Your Honor, he was reset due to the warrant stating bond and PTR, but he doesn't qualify for PTR.
Okay.
So in order for that detainer to be
So
completed.
I'm just telling him his bond's set at 1,000.
Yes, sir.
Okay. All right, sir, 2020 CF 3219AO. Looks like the judge on your case,
She set the bond at $1,000 and she waived his appearance, so he shouldn't have been put that bond.
okay. Well, I'll just let him know. Your bond's set at $1,000 on this case, okay?
Okay.
All right, thank you.
And you're deleting the condition of PTR, right?
No PTR. Your name, sir?
Junior Alsay.
All right, sir, 20 CF 8420AO, you're here on an attempted burglary of an occupied dwelling and one count of violation of a domestic violence injunction. Reviewed the affidavit, found probable cause. Is everybody getting the PD still? All right, appoint the public defender. Any contact with the alleged victim?
Yes, Your Honor. She was given the wrong time, but she's on her way. So I don't know if you
Okay,
want
so let's roll him to the end.
Okay.
All right, sir, the alleged victim might be coming to court, so we're just going to roll this to get their input, okay? We'll call you back in a few minutes. Your name, ma'am?
Alexis Elion Nicholas.
All right, you're here in 20 CF 8422AO, aggravated assault with a deadly weapon and one count of battery domestic violence. Reviewed the affidavit, found probable cause, point the public defender. Any contact with the alleged victim?
No.
No victim contact made. Left voicemail. Anybody here on this case?
No,
All
Your
right.
Honor.
Any input from the state?
Your Honor, the state would recommend a bond of $2,500 as to count 1, count 2 at $100. No contact, maintain separate residence, possess no weapons, firearms, or ammunition.
Any input from the defense?
Yes, Your Honor, we request a significantly lower bond of $500. She has no criminal history. She is unemployed currently. The police report isn't particularly egregious. We request a reasonable bond be set.
She's got prior ag battery, great bodily harm.
I
all
believe
right.
that's an arrest, not a conviction.
I'll set your bond at $1,500 on count 1, 100 on count 2. No contact with the alleged victim, no return to the scene. Maintain separate residence, do not possess any guns, knives, or weapons. You understand, ma'am?
Yes, sir.
All right, thank you. Your name?
Jose Ianusso, Judge.
You're here in 20 CF 8423AO, one count of false imprisonment, one count of battery, domestic violence. Reviewed the affidavit, found probable cause, point the public defender. Any contact with the alleged victim?
No.
I have,
No, Your Honor.
no. All right. Any input from the state? Is he on probation?
I don't know.
Any input from the state?
Yes, Your Honor, the state would recommend a bond of $2,500 as to count 1, $100 as to count 2 as a subsidiary, no contact, no return to the scene, maintain separate residence, possess no weapons, firearms, or ammunition.
All right, any input from the defense?
No, Your Honor.
So is Osceola going to pick him up? It says he's wanted for a VOP out of Osceola on petty theft. And he's wanted on a VOP out of New Jersey. And he's wanted on a VOP out of Bradford.
No extradition for Osceola.
Yeah. Okay. All right. I'll set your bond at $5,000 on count 1, 100 on count 2. No contact with the alleged victim. No return to the scene. Maintain separate residence. Do not possess any guns, knives, or weapons. Sir, understand that you have warrants out of Bradford County, Osceola County, and New Jersey. You understand that?
Yes.
Okay. You might want to get that taken care of because the next time we might not let you out.
Thank you, sir.
Thank you.
Thank you.
Your name, sir?
Jesse Najera.
You're here in 2020 CF 8405AO, one count of battery by strangulation, dating violence, one count of criminal mischief, greater than or equal to $1,000, one count of battery, dating violence. Reviewed the affidavit, found probable cause, point the public defender. Any contact with the alleged victim? I have no contact. Any input from the state?
Your Honor, the state would recommend a bond of $2,500, count 1, $150, count 2, $100, count 3. The standard recommendations as to no contact, no return to the scene, separate residence, and no weapons, firearms, or ammunition.
Any input from the defense?
Yes, Your Honor, we asked for pretrial release to qualify.
And Your Honor, the state would object as there is no witness present to provide input.
I feel like every time I come here, the state's position as to PTR when there isn't a victim changes. Has it ever been the state doesn't object when there's no victim here?
No, Your Honor.
No?
No.
The PD, do you agree with that?
No, I've actually never heard that, but I'm not here every day, so.
Yeah, I mean, me neither, obviously. But I do. Am I right or wrong? You know,
And Your Honor, the court has ordered PTR whether or not the victim is present. The state just opposes that.
I feel like I've only ordered it if the state doesn't have a problem with it. Sir, do you want pretrial release or do you want to post a bond? I'm going to set your bond at $1,500 on count 1, $150 on 2, and $100 on 3. Do you want to post those bond or do you want to be released by PTR and be monitored like probation?
Which one is faster? Only reason.
Depends on how fast you come up with the money.
When will I be released for the pre-trial?
Before the end of the day.
The same as a bond. It has no difference.
It's just because I'm trying to get to work as the fast as I can, so.
When do you have to be at work?
I have to be at work by 6.
PM?
Yes, sir.
Like I said, just depends on how fast you're coming with the money.
Okay, and how much is the amount again? I'm sorry, I didn't.
1,500, 150, 100. Or PTR.
Your Honor, you can just order it like that.
I can
too.
do,
Yeah, well, I'm just curious if he's even interested in PTR, and if he's not, we don't have to, just like the last private attorney. A lot of people don't want PTR because they don't want to be monitored.
PTR. That's
All
fine.
right, we'll give him PTR. No contact, no return, maintain separate residence, do not possess any guns, knives, or weapons. Do you understand?
Yes, sir.
Yes? All right,
Yes.
thank you.
Thank you.
And Your Honor, they are signing the no contact orders. I can't see.
Are they signing no contact orders over there? Yes. Mr. Williams, yes? Yes. All right, ma'am, your name?
Samantha Serrano.
All right, 20 CF 8424AO, one count of false imprisonment, one count of battery, domestic violence, review the affidavit, found probable cause, point the public defender, any contact with the alleged victim. I have victim planned to attend court.
Contact was made.
Is there anybody here for Samantha Serrano? No? What time were they told to be here?
8:30.
8:30, it's now 9:24. All right, any input from the state?
Yes, Your Honor, the state would recommend a bond of $2,500, $100 on count 2, no contact with the victim, no return to the scene, separate residence, no weapons, firearms, or ammunition.
All right, any input from the defense?
Yes, Your Honor, we asked for pretrial release to be set, and we have no objection to it does say they reside together, but obviously there's no victim input, so we have no objection to separate residence and no contact.
All right, I'll set your bond at $2,000 on count 1, 100 on count 2. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons. If we get the victim to show up and they don't have any problem, then I'll order you a pretrial release, okay?
Thank you.
Based on the PC and your history, and I'm inclined to stay the bonds at this point at what I set them at. Thank you.
Thank you.
Your name, sir?
Jonathan Bradley Shingle.
All right, you're here in 20 CF 8425AO on one count of false imprisonment of a child under 13 and one count of battery, dating, violence. Reviewed the affidavit, found probable cause as to count 2, point the public defender. Do find probable cause as to false imprisonment, but not with a child under 13. So state that's 787.02.4.
It's 787.02 subsection 2.
Sub 2. Got that?
Yes.
All right.
Count 1, right?
Correct.
Yes.
Thank you.
All right. PD, is that correct?
I believe so. I did not look it up. I believe.
Well, I mean, but that's what you were.
Oh, yes, that
the
was my
PC issue.
argument.
Yeah.
Yes.
Okay. All right. Any contact with the alleged victim? I have.
The victim is the co-defendant.
Victim is the co-defendant. Do we got the co-defendant here?
Yes, we do, Your Honor, but she's not coming due to medical.
Okay. All right. Any input from the state?
Yes, Your Honor, the state would ask the court to set bond as to count 1 at $2,500, count 2, $100. No contact with the victim, maintain separate residence, possess no weapons, firearms, or ammunition.
All right. Any input from the defense?
Yes, Your Honor, we request that Mr. Shingle be interviewed for pretrial release. He's unemployed. He has been for 6 months. I believe he probably wasn't interviewed due to the nature of the original charge as he came in. And because the alleged victim can't come for medical reasons, we have no idea if she doesn't object to non-monetary release conditions. And she's also, my client's also a victim in this case as well. So we ask that be taken into consideration.
Well, everybody's the alleged victim at this point. I'll set count 1 at $1,500, count 2 at $100. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons. If you want to screen them for PTR,
he's
and if
been
he doesn't
interviewed.
bond out, we can bring it back tomorrow.
He's been interviewed.
He does?
It's just due to the first charge.
Yeah. So is the charge that prevented him?
He been offered. We couldn't qualify him.
Okay, so he qualified, but for that charge.
Usually when it's a child involved.
All right. Based on his history and the PC affidavit, I don't have any problem if he gets PTR.
So you want to do
Bond or
four?
PTR. All right, thank you.
You say bond.
Question.
Step up. Your name?
Anthony Thomas.
All right, sir. You're out on bond on 2020 MM 162 AE battery domestic resisting officer without violence criminal mischief less than or equal to 200. You're also out on bond on 2020 MM 131 AE on a petty theft. Looks like you're ROR'd on that case. You're here today in 20 CF 8427 AO aggravated assault with a deadly weapon and battery domestic via arrest warrant. According to this arrest warrant, your bond is set at no bond on each, with conditions no contact with the victim. Have we had any contact with the alleged victim?
No.
No, not you, sir. I'm sorry. I was asking the courtroom.
It
No.
says victim unknown.
All right. Any input from the state?
Yes, Your Honor. As to the current case, the state would ask the court to set bond at $7,500 as to count one, and no contact with the victim, maintain separate residence, no weapons, firearms, or ammunition. Count two at $100. The state would ask the court to revoke the bonds in 2020 MM 162 AE and 2020 MM 131 AE and allow the trial divisions to make the determination on release.
All right. Any input from the defense?
Yes, Your Honor, I wasn't able to find the police report. I have no idea what date the offense happened as to whether or not the bond can be revoked.
It can.
Okay.
The date is days after.
Okay, so the bond can be revoked. We have no arguments as to the out on bond. We just ask the bond be set, it comes in with no bond, and we ask the bond be set on the new cases.
All right. All right. On your new case, I'll set. I'll set your bond on count one at $7,500, count two at $100. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons. In your 2020 MM 162 AE, it's the same victim. Looked like you'd been released about, maybe 10 days before. So I'm going to revoke your bond on that, let the judge assign to that case determine what a reasonable bond is. In the petty theft case, has the state filed on that case? I have that he was ROR'd back at the end of May.
Your Honor, if I-
According to Odyssey, no, but I don't know if they have something else.
It doesn't look like it.
No, Your Honor, we're
So-
awaiting the judgment and sentences
Okay.
to come in.
I can either take no action on that, or I can revoke it and set him a nominal bond on it. What do you want?
Revoke the bond, please.
Okay. All right, I'll set it at 100. All right, ma'am, your name?
Destiny Cortez.
All right, 2020 MM 5074 AO, one count of battery, domestic violence, reviewed the affidavit, found probable cause, point the public defender. Any contact with the alleged victim?
No.
Any input from the state?
I apologize, Your Honor.
Cortez?
Who is the defendant?
Cortez, Destiny
Sorry?
Cortez, our first misdemeanor DV.
Oh, thank you.
Did I miss somebody? Singh?
I had Singh up, but
What happened to
Singh is on
Singh?
the interpreter list. and
Yeah.
They haven't called it yet.
Okay.
Singh's Geek Guyanese or I don't know what's happening.
The state would recommend a bond of $500, no contact with the victim, maintain a separate residence, and no weapons, firearms, or ammunition. The state will acknowledge that the victim has no history.
All right, any
I mean, the
input
defendant.
from the defense?
Yes, Your Honor, we request pretrial release. She qualifies, she has no history, no arrests, no convictions. She is also the reporter in this case, so we ask she be released on pretrial release.
All right. I'll set her bond at $250 or pretrial release. No contact, no return, maintain separate residence. Do not possess any guns, knives, or weapons. Thank you. Your name, sir?
Michael Douglas.
All right, sir. 2020 MM 5088AO, one count of battery, domestic violence. Reviewed the affidavit, found probable cause, point the public defender. Any contact with the alleged victim? No?
No, Your Honor.
Any input from the state?
Your Honor, the state would ask the court to set bond in this matter at $1,000. Order no contact with the victim, no return to the scene, maintain separate residence, possess no weapons, firearms, or ammunition.
Any input from the defense?
No, Your Honor.
All right. I'll set your bond at $500. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons. Do you understand, sir?
Yes, sir.
All right, thank you. Your name, sir?
Mark Etheridge.
2020 MM 58085AO, one count of battery, domestic violence. Reviewed the affidavit, found probable cause. Point the public defender. Any contact with the alleged victim?
No, Your Honor.
Any input from the state?
Yes, Your Honor. The state would ask the court to set bond in this matter based on, albeit arrest history, but the arrest history includes domestic violence and crimes of violence. The state would ask the court to set bond at $750. Order no contact with the victim, maintain separate residence, no return to the scene, no weapons, firearms.
Any input from the defense?
No, Your Honor.
All right, I'll set his bond at $500. No contact with the alleged victim. No return to the scene. Maintain separate residence. Do not possess any guns, knives, or weapons. Do you understand, sir?
Yes, sir.
All right, thank you. Your name, sir?
John Eugene.
All right, 2020 MM 325AA, one count of battery, domestic violence. Reviewed the affidavit, found probable cause, point to public defender. Any contact with the alleged victim?
No, Your Honor.
Any input from the state?
Yes, Your Honor. Based on a criminal history that includes crimes of violence convictions, the state would ask the court to set bond at $1,000 on this matter. No contact with the victim, no return to the scene, maintain a separate residence, possess no weapons, firearms, or ammunition.
All right, any input from the defense?
No, Your Honor.
All right. Yeah, he's got a lot of domestic convictions. The facts of this are a little worse than the last two. I'll set his bond at $1,000. No contact with the alleged victim. No return to the scene. Maintain separate residence. Do not possess any guns, knives, or weapons. Do you understand, sir?
Yes, sir.
All right, thank you.
Your Honor, next on the list is Hamilton Medical.
All right, looks like there's an order you guys want me to sign on this thing? What's going on
Oh,
here?
he has a child support writ.
So do I not sign that
Yes.
right now, even though he's medical?
You can reset it or you can sign it. He's gonna be released on that only. So it's up to you.
So this contempt of court writ, he's gonna be ROR'd on?
Yes, that's what the
Okay,
order
so
is.
I don't need to see him. I'm gonna ROR him,
He
right?
has two cases though.
What's the other case?
I think it's from the state.
Is there anybody here for Robert Hamilton? Robert Hamilton? Okay. Let's roll him to tomorrow and
Everything?
see if anyone shows up.
Okay.
Your Honor, could we do it now? I know we haven't been appointed, but he can't get out unless we address it.
And he's gonna be medical tomorrow as well.
What's his,
We've been waiting.
has he been waived before?
I don't think he'll be here tomorrow either, Your Honor.
First time, but when it's medical, we miss it. And then we still haven't signed it. No? Okay.
No, do it.
Because he's on a respiratory precaution, so they're not gonna let him go.
But they do release them if they pay their bond. They're not stuck, so.
And they'll take the no contact order up for him to sign.
All right, so DR 715330 contempt of court. That bond's set at 1,200, or that's been now set at ROR?
It's set at ROR.
Okay, and then he's got 2020 MM5077AO battery DV. Okay, give me a quick second.
Yes.
All right, review the affidavit, found probable cause, point to public defender. No contact, any input from the state?
Your Honor, the state would recommend that the court, along with all of the other standard conditions, set bond at $500.
All right, any input from the defense?
No, Your Honor.
All right, we'll set his bond at 500, no contact, no return. Maintain separate residence, do not possess any guns, knives, or weapons. All right, sir, your name?
Luis
I'm sorry?
Luis Enriquez.
All right, thank you. 20 MM 5090AO, violation of a domestic violence injunction. According to this warrant, your bond is set at no bond with conditions, no contact with the victim, no return to the scene. I'll appoint the public defender. Any contact with the alleged victim? No. Any input from the state?
Yes, Your Honor, the state would ask that bond be set at $2,500 in this matter, and the standard release conditions to include abide by the injunction.
Any input from the defense?
Your Honor, we request a $500 bond.
All right, I'll set his bond at 1,000. No contact with the alleged victim, no return to the scene, maintain separate residence, do not possess any guns, knives, or weapons, and if there are any domestic violence injunctions, you must abide by the conditions of the injunction. Do you understand?
Yeah, yes.
Yes? Okay.
Excuse me.
All right. Hold on.
I'm sorry.
Before you say anything, your lawyers here understand you have a right to remain silent. Anything you say can and will be used against you. Do you want to say anything to him before he volunteers any information?
Yes, Mr.
Enriquez.
Enriquez, is your question about your release, or is it about the facts of the case or the injunction?
Something about, I think it's about the case.
No, then you cannot discuss that at all. Do you understand you have a $1,000 bond and you have an injunction in place, so you can't have any contact with the alleged victim?
He just wanted to advise you that his victim was supposed to be on the way. That's all.
Oh. Well, it really, it's an injunction, so. It won't make any difference for the contact conditions, so
Yeah.
thank you for letting us know.
You're welcome, Your Honor.
All right, hold on, Mr. Enriquez. You're also here in 20 MO 759 on a violation of state misdemeanors. I'll set your bond at ROR on that one.
Thank you, Your Honor.
Thank you. Thank you, Madam Clerk. All right, ma'am, your name?
Betty McCarty Tillman.
2020 MM 5083AO, one kind of battery, domestic violence. Reviewed the affidavit, found probable cause. Appoint the public defender. Any contact with the alleged victim? Any input from the state?
Your Honor, the state would recommend a $500 bond, no contact, no return, separate residence, no weapons.
Any input from the defense?
Yes, Your Honor, we request pretrial release. I'm just looking at the face sheet, the PTR sheet, and I don't see she has any history of any violent crimes. So we ask you take that into consideration and set the bond at pretrial.
Looks like DUI, reckless, failure to appear from 24 years ago. All right, I'll set your bond to $500. No contact, no return, maintain separate residence. Do not possess any guns, knives, or weapons, or pretrial release, whichever you want. Your name?
Mickelson.
2020 MM 5089 AO, one kind of battery domestic. Reviewed the affidavit, found probable cause, point to public defender. Any contact with the alleged victim?
No, Your Honor.
Any input from the state?
Based on a history of domestic violence battery conviction and a separate battery conviction, the state would ask the court to set bond at $750. No contact, no return, maintain separate residence, no weapons or firearms.
Any input from the defense? All right. I'll set your bond at $750. No contact with the alleged victim, no return to the scene. Maintain separate residence. Do not possess or consume any alcohol or illegal drugs. Do you understand?
Yes, sir. Yes.
And do not possess any guns, knives, or weapons. Thank you.
Sir.
Your name, ma'am?
Denitra Willingham.
What happened to Fratzila Napoleon?
Medical, Your Honor.
Oh, that was the co-defendant. Let's roll that to the end there, and we'll do that one.
Okay.
She's medical, young.
Since we got alleged victim and everybody here. All right, I'm sorry. One more time, ma'am. Is it Denitra Wellington or Willingham?
Yes, sir.
All right, 2020 MM 176 AE. You're here on one kind of battery domestic. Reviewed the affidavit, found probable cause, point to public defender, and then, ma'am, your name?
Robin Walker.
I'm sorry. One more time.
Robin Walker.
Okay, thank you. You are listed as the alleged victim in this case. Is there anything that you want to tell me? Anything that you think I should consider in determining conditions of her release?
I don't want anything to happen to her. I chose to leave and go my separate ways. She can go to the residence. She can be, it don't bother me. We can have contact, but I chose to leave already, so everything is okay. She can go back, whatever.
All right, State, do you have any questions for Ms. Walker, right? Robin
Ms. Walker?
Yes.
Are there any children that live in the residence?
No, ma'am.
And if something like this were to happen again, if you're allowed to have contact, would you feel comfortable calling law enforcement?
Yes.
And how long have you been with Miss Willingham?
A little over 3 years.
And has there been violence in the relationship in the past?
Yes, we had problems before.
So that's yes. I have no further questions. Thank you, ma'am.
No problem.
All right, defense, do you have any questions?
Yeah.
All right, so you guys live together, but you've left the house?
Yes, we live together, but I chose to leave.
Okay.
She can go back. I don't mind. I don't care to not have. We can have contact. No hostile, however. I don't care if we don't have contact either or. But I don't want nothing to happen to her bad or anything. I left.
Well, what do you want? As far as contact?
It could be no hostile, long as she abide by it.
Okay. Has that been a problem in the past?
Not so much. We argue. Sometimes I ain't gonna lie, I provoke her. Sometimes. So long as she abide by, I don't mind having no hostile contact.
Well, you can't provoke her either, though, right?
And we're arguing though, not Okay.
All right. She's also here on 2020 MM 4641AO on violation of conditional release with a bond of $2,000 on that one. State and no contact with the victim. So she's out on bond on PTR for DV with the same victim? Yes, okay.
Yes.
All right, any input, State?
Yes, Your Honor. The state would ask the court to set bond in this matter at $1,000. The state is going to advocate for no contact with the victim, as I believe that's a no contact order in the prior, and no weapons, firearms, and maintain separate residence.
Okay, any input from the defense?
Your Honor, we agree. There is already a no contact order in place, so it would be confusing to have a no hostile contact order at this point. We do ask for the release conditions on the violation of pretrial release to be reduced. The alleged victim is here stating that she's not in fear, so we ask that be set at $500.
Why shouldn't I just revoke it and set it at 0?
So you could, but just based on the victim's testimony and the fact that she has absolutely no history. There are the 2 arrests for the battery DV, but I believe it's all with this victim.
I mean, pretty much everyone else, when they come in, if they're out on bond for battery domestic, and then while they're out on bond, battery domestic alleged to have commit another battery domestic on the same victim, we revoke their bond.
Yes, and it came in on a warrant where they already had a bond, so another judge who in the division.
And so now you want more.
Yes, but no, we're fine with the 2,000 if that's what you're inclined to keep it at.
All right. So the no contact order in the other case is actually no hostile contact.
Yes, that's what I want. Excuse me. That's what I wanted to correct. It's no contact. It's no hostile contact.
I corrected it.
Thank you. I don't want to get in trouble.
So it wouldn't be confusing.
Okay, yes, I see that.
But we seem to be having problems with contact. So I'm going to order a $2,000 bond in this case. You also have a $2,000 bond in your other case. I'm going to order no contact. So that means no matter what, no contact. Even though the other one says no hostile contact, it's no contact now. Do you understand? Ma'am?
Yes, sir.
Okay. All right, because we already tried no hostile contact and it apparently didn't work.
Can I speak?
Do not possess any guns, knives, or weapons. Maintain separate residence. You can return to this residence since Walker has moved on. I believe that's everything. Is there anything that I missed?
Can I say anything, sir?
No, Your Honor.
Understand you have a lawyer here. Your lawyer might want to give you some advice before you say anything. Hold on one second. She's in this courtroom with me right here.
Ms. Willingham, sorry this is confusing because we're, distancing, but do you have any questions about the actual release conditions? Like, for example, that the judge is allowing you to have a bond, but you will not be able to have any contact with the alleged victim.
Yes, ma'am, I understand that, but I never put my hands on her.
Okay, so Ms. Willingham, you're going to have a lawyer that you can talk to about all the facts of your case to determine how to defend it, okay? Right now, it's just about your release conditions, okay?
But what was the warrant for? I'm confused.
It was a violation of pretrial release because of the new case, from my understanding. Let me check.
I've never got
Yes.
arrested again. I've never got arrested. We haven't gotten into it yesterday.
Okay.
Ma'am, just understand that your lawyer wants you to remain silent because if you admit anything or say anything that could get you in trouble, the state attorney could use it against you. So just hang tight. Like she said, it's a little...
Yes, it's just when they came to pick you up, the police report indicates that there was an issue. Just tell your lawyer all this and they can tell you, a timeline, okay? But today, this is what we're at, okay?
All right, so I have two $2,000 bonds, or is just one?
2.
Okay, so I have if I can.
What was the second $2,000 bond for?
So you can talk to your lawyer, but you picked up a new charge. I set your bond at $2,000, and you were out on some form of release on your old charge, and you violated that, and the judge in that case issued a bond of $2,000 on that case.
But Sir, I had a witness for both of those.
All right, okay, Miss William, I'll email your attorney and they'll get back to you soon, okay?
Okay, so basically, with the bond, how much would have to be paid for her to come to
Well,
get out?
the total amount is $4,000.
For the whole, so the whole salary got to be paid for her to come out?
Or you could use the bail bondsman.
Okay, and secondly, about the no contact and, you know, with the, I do get her to work and stuff and back and forth. Like I said, I don't mind having contact.
There's no contact, because we had no hostile contact, and then she picked up another DV charge.
Okay. But we didn't really fight this time or anything. She violated.
I mean, something happened to where law enforcement responded, and then law enforcement arrested. So I don't know exactly what happened. You guys probably know best, but the people that were on the scene made that decision, and so it's for your safety and for her safety. The judge assigned to the case is going to be Judge Shoemaker. He can make any changes that are necessary, okay?
Okay.
All right.
Thank you.
Thank you for being here. All right, your name, sir?
Junior Alsay.
What happened to Koi Wen?
He bonded, John.
Bonded.
That was traffic.
King Harvey?
Your Honor, the guy that's at the podium, the defendant that's at the podium now is for the domestic for Alice. You was waiting for
Got it. All right. Junior Elsie? That's you, sir?
Yes.
Okay. 20 CF 8420AO, one kind of attempted burglary of an occupied dwelling, one kind of violation of a domestic injunction. And then, ma'am, your name?
Doubling Pierre.
I'm sorry, one more time?
Doubling Pierre.
All right. Ma'am, is there anything that you want to tell me, anything with regards to this incident that you think I should consider when determining conditions of his release?
Yes. So we do have a injunction in place. I thought he was going to jail for the violation of the injunction, but when I got a call from pre-trial or something like that last night, they told me that he had another charge.
So he's here for the violation of a domestic injunction and attempted burglary.
Yes, okay. So, yeah, I do not want to pursue with that attempted burglary. No, not at all. My point of, I don't want him to, well, how do I say this? Like, I don't want to mess up his life more. The reason for the injunction is so we could be able to better co-parent through third parties for our son. Because we cannot, we don't see eye to eye. It's hard for us to communicate. You understand? I understand he doesn't have nowhere to live, but that's not my problem. He's an adult. He need to find him somewhere else to live. We did used to share the residence, but I kicked him out. He need to find him somewhere else to live. There's plenty of resources, plenty of other opportunities that he could look into to get him somewhere to live. I'm not going to be taking care of him. That's the whole point of the injunction, so we could be able to go to paternity court for time sharing with our son to co-parent with third parties to better co-parent with our son. Because we cannot, it's hard, we can't see eye to eye when it comes to that.
Okay. State, do you have any questions for her?
No, Your Honor.
All right. Defense, do you have any questions for her?
Yes, Ms. Pierre, would you like to continue having that third-party intermediary for your, for Mr. Alsay to be able to see your child, or would you prefer no contact at all?
No, of course. I would prefer a third party, whether it's his father or my father, you know, so he could see his child. I don't want to take his child away from him.
Could you give us those two names?
Okay, so my dad name is Osner Bartol, OSNERBARTOL. His father name is Joseph Alsay.
Okay, I have no further questions for you. Thank you so much for your input.
All right, any input from the state?
Your Honor, the state would ask the court to set bond as to count 1 at $2,500, count 2 at $500. order continued no contact with the victim outside of third-party contact for the purposes of child visitation, maintain separate residence, possess no weapons, firearms, or ammunition, and if there is a DCF investigation in place, to abide by that investigation.
Any input from the defense?
Yes, Your Honor, we asked the bond count one be set at $500 due to the victim's testimony that she does not want to go forward, and just that Mr. Elsie understands at this proceeding that he cannot have any contact with Ms. Pierre whatsoever. So if that is a condition that he understands, then we request that the bond be more reasonable at $500 and $500.
I mean, he has 25 priors, 8 failure to appear. The last one was 9 years ago. Now set his bond at $1,500 on count 1, $100 on count 2. No return to the scene, no contact, maintain separate residence, and abide by the conditions of the injunction. You understand, sir?
Yes, I understand, sir.
Okay.
I got a question.
Hold on. Your lawyer's gonna give you some advice real quick.
Mr. Elsie, what's your question?
It's just about pretrial release because I work 2 jobs and like I'm gonna be...
It's you won't qualify for pretrial, so you will have these bonds. If you can go to a bondsman, it'll be a total of $250. But that's all I want you to say about the case whatsoever, because you need to talk to your lawyer about possibly getting the first charge dropped, and the domestic injunction is completely separate. And then, Your Honor, could you add on the order those 2 names that?
Yeah.
Okay,
so
thank you.
The third-party contact, and then what were those names again? Did you get them?
Asner,
And Joseph, same last name.
Okay. Yeah, we got them.
Okay, perfect. Okay, so Mr. Elsie, you're going to get a piece of paper with the lawyer's phone number on it. Please make sure you call them, and also only be in touch with your father-in-law or your Miss Pierre's dad or your dad about your son, and that is it, okay? Or else you'll be back here with no bond, most likely.
Yes, ma'am.
Okay, thank you.
Thank you for being here, ma'am. Yes.
Do I tell his father to call here for information on him? Yeah?
Yeah, or they can just look it up on the jail website.
Okay. All right. Thank you.
Thank you.
The next defendant, Your Honor, King Harvey, medical.
Your Honor, we can enter a not guilty plea.
Hold on. All right, King Harvey.
Medical.
Medical. Not guilty. PD.
Division 85, pretrial conference, August 10th at 9 o'clock, courtroom 4A.
Thank you, Madam Clerk.
Your Honor, the next defendant,
Stephen Johnson.
medical.
Medical.
Your Honor, I believe I already filed a waiver on that one.
All right. 2020 MM 127AE PD not guilty.
Let me go. I don't remember seeing
He can't just watch the video while he's in jail and have it. No problem.
We don't have a waiver on that one, but.
Oh, I'm sorry. I thought I did it.
Division 84, pretrial conference, August 6th at 10 o'clock, courtroom 4B.
All right, how about Dominique Knight Lewis?
Medical, Your Honor.
2020 MM 4949 AO.
And Your Honor, I thought I also had waived that one, but it seems like maybe I didn't. So at this point, I'll enter a not guilty plea.
Not guilty. Shoemaker, your favorite.
I did waive
Division 50, pretrial conference, August 10th at 2:30 p.m., courtroom 7C.
Is this Alberto Rodriguez?
Yes, sir. Good morning.
2020, good morning, MM 4993 AO. You're here for arraignment on a petty theft. State, do we have an offer?
Yes, Your Honor. The offer is, there's 2 options. There's an adjudication of guilt, 160 days, Orange County Jail. No return to the scene, which is the CVS on International Drive. No contact with witnesses. abide by trespass warning, restitution in the amount of $317.93. Or option 2 is that there's no offer. We are currently awaiting 2 J&S's from Broward County on 2 prior felony petty thefts. And when those come in, the case will be enhanced.
He doesn't have any time in, does he?
Yeah, he was never arrested on this case, so no.
All right, sir. So the offer in your case is an adjudication of guilt, 160 days in the Orange County Jail, no return to the scene, no contact, abide by any trespass warnings, restitution the amount of $317. Now, even though you've been in jail, you're not gaining any time on this case. Your other option is you cannot accept that offer, enter a plea of not guilty, and the state will make a determination if they're going to upgrade this to a felony. Before you make any decisions, do you want me to appoint you a lawyer, or do you want to make a decision without talking to a lawyer?
No, I'll take a decision.
What do you want to do?
You said 160-day Orange County Jail?
Yeah,
I'll take that.
without talking to a lawyer.
Yes, sir.
Okay. All right. Do we have plea forms for them or no?
Yeah, they do them over there.
Okay. All right. You understand by resolving this case today, you're not going to get a lawyer, you're not going to have a trial.
Yes, sir.
If you're not a U.S. citizen, you could be deported for this.
Yes, sir.
And if you've ever been convicted of a sexually violent or sexually motivated offense, by entering this plea today, it could subject you to involuntary civil confinement. You understand that?
Yes, sir.
Guilty or no contest?
Not contest.
Accept your no contest plea, adjudicate you guilty, sentence you to 160 days, credit for 0. No return to is a CBS.
The CBS.
And what is the address?
9188 International Drive in Orlando.
9188 I Drive, Orlando. No contact with
Any witnesses?
any witnesses. Abide by any trespass warnings and restitution in the amount of $317 to CBS at that same address.
And 93 cents.
And
Yes.
93 cents.
Your Honor.
Court costs, I'll put you on a monthly payment plan at $10 a month. Your first payment is due 30 days from your release, and whatever date that is, that date thereafter, because we're not sure when you're going to get out of jail.
Can I ask you something?
Sure.
Does the 3 months and a half that I got in, does it count?
I said no. Does that change your mind?
Yes, sir.
What do you want to do?
Your Honor, may I? No.
You want to enter a not guilty plea? You want a lawyer? Those are your only 2 options.
Attorney?
All right, you have a job?
Yes, sir.
How much money do you make?
$500 a week.
When's the last time you got a paycheck?
About 3 months and 3
Yeah.
weeks.
All right, 3 months and 3 weeks?
Yes, sir.
All right, I'll appoint the public defender. What do you want to do?
Mr. Rodriguez?
Yes.
You can also enter in a no contest plea at this time, blind. And if you do that, it's kind of a risk because you have a max of a year. Or we can just set this for a court date in front of a division judge and then see what happens there because they have already filed this case. They can get the J&Ss. I don't know what you got before. So if you got something like 160 before and they end up filing it as a felony, then you could definitely get that or more. So it's kind of up to you if you just want to wait on a court date or take a risk on a plea.
It just, I don't understand why it doesn't count 3 months and a half that I got in already.
Hold on one second.
To appear.
3 months is in on this case.
So you got picked up on a felony?
Okay, so he was never, looks like he was never served on this case. This is a felony. It's unsolved. They filed on it and they filed it as a
160 from today.
which brings us
And
here. But he's
we
not-
can always refile.
No, I know. Mr. Rodriguez, it's going to be 160 from today because you weren't in on this charge. I believe you're just getting time today. You're not even getting time unless we decide to remand you the judge decides to remand you today. So would you like to just do that and then enter a not guilty plea, or what are you thinking?
You want me to roll him to tomorrow? You get 24 hours to talk to him?
It's going to be impossible.
Okay.
Unless he's in a dorm that we can video him. Mr. Rodriguez, if you don't have a decision, we can roll you to tomorrow. Would you like to do that?
Yes, ma'am.
Okay.
All right. Thank you.
You were.
So we're not remanding
No.
today? Okay.
Do it all over again. How about Brian Smith?
Medical, Your Honor.
Medical, 2020 MM 4146 PD. What do you want to do?
Not guilty.
All right.
Division 80, pretrial conference, August 11th at 9:30, courtroom 9C.
All right, let's do Cordelia Napoleon, 2020 MM 5078. This is the co-defendant medical, right? It was a DV case from earlier. Yeah, medical, temporary.
You have to call it. It's probably not here. When you call the name, they'll let you know.
Gotcha. All right. 3-4 versus Jacqueline Bell. You know how many days Ms. Bell has in?
Your Honor, the first one on the docket, Jacqueline Bell, is medical, would not be attending court.
Okay, all right. So I'll find probable cause on Ms. Bell, appoint the public defender's office to represent her.
And then are you gonna reset it or defense? Are you appointing
I'm
PD?
appointing the public defender. I understand when they are not present because of medical, we're going to appoint the office of the public defender.
And they usually waive it.
Find probable cause, and then that would just be set for a new date.
So we're gonna
So-
ROR?
Oh, okay. So then I need to sit bond. It's like I haven't done this before.
That's okay.
I'm gonna ROR Ms. Bell. All right, next I have John Doe. Do we have any other names for Mr. Doe?
Yep. I gave you it's an update on your.
There is.
White Bay, yes, ma'am.
Okay. Where would I find the update? Do we have a name for Mr. Doe now?
His up-to-date name is Raheem Whiteby.
Yes, ma'am.
Raheem White?
Whiteby.
Oh, that's why you gave those to me right there, so I could see them. Thank you. All right, updated. All right, so this is.
And Your Honor, may the state have the updated name and information, please?
Sure. That's Raheem Whiteby or White Bay?
White Bay.
White Bay, WHITEBEY?
Yeah.
Is that one name, White Bay, or is it White Bay?
Hyphenated.
Hyphenated, okay. Raheem, R-A-H-I-M, White Bay, white as in the color, hyphenated B-E-Y.
Yes, sir.
V as in Victor, E-Y?
I did not hear you.
I'm sorry, V as in Victor, E-Y, or B as in Baker?
B as in Baker.
Thank you.
All right. Mr. White Bay is charged with disorderly intoxication and possession of alcohol on a street or sidewalk. I've reviewed the charging affidavit. I'm going to find probable cause. Are we appointing the public defender on all these cases?
Yes, Judge.
All right, I'll appoint the office of the public defender. Mr. White Bay, do you have a place to stay locally?
No, sir.
I'm sorry, I did not hear you. No? You do not?
No, sir.
Okay, all right. State?
Your Honor, if the Mr. White Bay wishes to entertain an offer, the state's offer is an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and no return to the 8574 South Orange Blossom Trail.
Okay, to the Wawa. All right. Mr. White Bay, you've got a couple of choices. One choice is I'll determine the correct terms of release to ensure that you're not a danger to the community and that you're going to return. If you want to enter a plea of not guilty, you have that right to hold the state to their burden to prove your guilt. We'll have you come back another day. If you do not want to have to come back and you want to give up your right to be presumed innocent, you can enter a plea of no contest to this charge that says, I'm not admitting I did anything wrong. I just feel it's in my best interest to resolve the case today. I would credit you the time you served in jail, adjudicate you, require you not return to the Wawa, impose court costs, and give you a year to pay.
Yes, sir.
Which of those two things would you like to do, Mr. Whitebay?
I will plead guilty to no contest.
Okay, all right. Are we using plea forms, or am I just going to do this?
They've been doing them over in courtroom too, but for these, no.
Okay, all right. All right, Mr. Whitebay, you understand what I indicated a few moments ago, which is you have the absolute right to remain silent. By entering this plea of no contest, you're giving up the right to have a trial. You understand that?
Yes, sir.
Has anyone pressured you or forced you against your will to enter these pleas?
No, sir.
Are you under the influence of alcohol or drugs this afternoon?
No, sir.
You understand that if you're not a U.S. citizen, you could be deported by entering these pleas?
Yes, sir.
Okay. And Ms. Bush, that's going to be pleas to both charges?
Yes, Your Honor.
All right, sir, I'm going to accept your plea of no contest to the charge of disorderly intoxication. I'm going to adjudicate you to be guilty of that. I'm going to credit you the 2 days you've served at the Orange County Jail. I'm going to require that you not return to the Wawa located at 8574 South Orange Blossom Trail. They don't want you back there. You don't want to go back there. No good comes of that.
Yes, sir.
As far as the possession of alcohol, I'm going to adjudicate you guilty of that, credit you the 2 days you've already served. And then the court cost should run you $273. I'll give you up to a year to pay that off. At any time within that year, sir, you can always go to the clerk's office and get on a payment plan. If you don't pay that off within a year, the DMV will suspend your driving privilege until you take care of it.
Yes,
Sir,
sir.
you have 30 days to appeal my sentence. If you want to appeal, your appeal has to be in writing. And if you cannot afford an attorney for that appeal, I can appoint one. All right?
Yes, sir. Thank you.
All right. You're welcome. Good luck.
Can I see the sheet with the proper spelling?
You sure can.
Thank you. I'll do that.
And does there need to be some sort of amendment by the state that Mr. Whitebay is the individual that just entered a plea as opposed to John Doe?
Your Honor, I have, for the record, I will, Ori Tennis, amend that he also is AKA Rahim, R-A-H-I-M, White, hyphenated Bay, B as in Baker, E-Y.
Okay, great. Thank you. Thank you, State. All right, next I have Charles Gaines. Is this Mr. Gaines?
Yes, it is, sir.
All right, Mr. Gaines, you are charged with battery. I have reviewed the charging affidavit. I'm going to find probable cause. I'm going to. So, sir, do you live in Daytona Beach?
I moved here to get a job, sir.
Okay. All right. All right. I'm going to find probable cause. I'm going to appoint the Office of the Public Defender. I'm going to set bond in the amount of $500.
Your Honor, is there
Thank
any
you,
way
Mr.
we
Gaines.
any way we can resolve this today, sir? I'm trying to, any way we can resolve this today, sir?
Okay. That's a great question. State?
No, Your Honor,
No.
because it's a victim crime.
You need
The
an opportunity to
state-
talk to Mr. Alexander?
I'm sorry?
You need an opportunity to talk to Mr. Alexander?
Yes, Your Honor. And the state would also ask for a no return order and a no contact with the victim order.
Okay. All right. All right, this occurred at a bus stop near the Florida Mall.
Yes, sir.
All right, so Mr. Gaines, I'm going to require that you not return to that bus stop.
Yes, sir. Yes, sir.
Is there any reason you need to be at the Florida Mall?
No, sir.
Okay. I'm going to extend the no contact in addition to the bus stop to anywhere near, to the Florida Mall, including all curtilage, including the parking lot.
Yes,
of the
sir.
Florida Mall.
Yes, sir.
I'm going to also require that you have no contact directly or indirectly with Alan Alexander. Having read the charging affidavit, I'm going to make an educated guess that you don't know Mr. Alexander.
I don't even know
Do
him,
not to have
sir.
any contact directly or indirectly with him. If you happen to find yourself in the same place with him, it's your obligation to retreat and stay away from him.
Yes, sir.
All right?
Yes, sir.
This weapon appeared to be a rope, so I don't know there's a need to put any condition of no ropes.
No, Your Honor.
Okay, all right. All right, good luck, sir.
Thank you, sir.
Tina Hall.
Yes, sir.
All right. All right, Ms. Hall, you're charged with retail theft.
Right, I plead guilty. I wanted to know, could you really see on my own recordings? We are staying in Orlando, but I take care of my husband that has seizures.
Okay,
And
all right. Well, hang on a second, Ms. Hall. Let me find out. State, if Ms. Hall wanted to enter a plea to this petty theft of, looks like 4 USB fans
It
from the
was
Walmart
one.
totaling $27.31. Do you have a recommendation?
Yes, Your Honor. The state's offer would be a withhold of adjudication, 2 days Orange County Jail, 2 days credit time served, no return to the Walmart on West Princeton Street, abide by all trespass warnings, and court costs. The state is not certain that the property was recovered. So the state, in an abundance of caution, would ask that the court order and reserve as to restitution for 30 days.
Okay, all right. All right, so Ms. Hall, I understand from your opening remarks to me that you want to resolve this today. Is that right?
Yes, sir, and the stuff was returned yesterday. I didn't even carry it with me. They got it back immediately.
Okay,
And
all right.
I'll be willing to pay everything I have to pay on the 3rd when I get a check. I'll be glad to. I just need to get home to my husband today because he has seizures.
Okay, all right. So, Ms. Hall, you understand that you have the right to be presumed innocent, and you don't have to enter a plea of guilty to this charge just to get out of jail, right?
I understand, but if I'm guilty, I'm guilty.
Okay. Has anyone pressured you or forced you into entering this plea?
No, but my man teaches me to be honest.
Okay. Are you under the influence of alcohol or drugs this afternoon?
No.
All right. And Ms. Hall, you also understand that if you're not a U.S. citizen, entry of this plea could result in you being deported from the United States.
Yes, I understand, but I was born in Alabama, so
Okay. All right. Last time I checked, Alabama is still in the United States.
yeah.
I'm gonna accept, Ms. Hall, I'm gonna accept your plea of guilty to the charge of petty theft, which is a second-degree misdemeanor. I'm gonna withhold formal conviction of guilt, so this will not appear on your record as a conviction. I'm gonna sentence you to 2 days in the Orange County Jail. I'm gonna credit you the 2 days that you've already served.
Okay.
I'm gonna require that you not return to the Walmart located at 3101 West Princeton Street. You're also to abide by any and all trespass warnings. If you get a warning telling you not to return, you're going to want to follow that to avoid getting in trouble. I'm going to require that you pay court costs, which should total $273. I appreciate your interest in getting this paid off as quickly as possible. I'm going to give you up to a year to pay it off.
Okay.
Next month or later this month is still within that 1 year.
Yes,
You have up to a year to pay that off. I'm also going to order restitution and reserve as to the amount. What that means is I have no reason to disbelieve what you're telling me, that they got all their property back.
Yes, sir.
If for some reason someone from Walmart steps up and says, well, we never got back our property and we provide proof of this is what was owed, that order of restitution will be entered. So I'm ordering that restitution is owed, but not as to the amount. The amount could be zero.
Yes, sir.
If you owe any restitution, you always have a right to have a hearing if you contest the amount of the restitution or whether you gave back the stuff, all right?
Yes, sir. Does that mean I get to go home today?
That means you'll be released today.
Thank you.
All right, you have 30 days to appeal my sentence. If you want to appeal, your appeal has to be in writing, and I can appoint a lawyer for that appeal
No,
if you
that's
cannot
good.
afford one.
I'll pay it.
All right?
Thank you
All right,
very
good.
much.
You're welcome. Good luck.
Thank you. Have a blessed day.
Okay, you as well. Next, I have David Orr Jr.
Yes.
Are you Mr. Orr?
How you doing?
Are you Mr. Orr? Tell me your name, sir.
Keep it up and just talk through the mask. Hey.
I can hear you through the mask. Tell me your name, sir.
Hey,
Sir, are you hearing me or understanding me?
David Orr Jr.
Okay, all right. Mr. Orr, you're charged with trespass after warning. State, if Mr. Orr wanted to resolve this case today, you have a recommendation?
Yes, Your Honor. It would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the 7-Eleven on Old Winter Garden Road, and abide by all trespass warnings, no contact with witnesses, and court costs.
Okay. All right, Mr. Orr, you have the absolute right to be presumed innocent. If you wanted to enter a plea of not guilty, you could do that, and then I would determine the appropriate conditions of your release. If you don't want to have to come back to court, you can give up your right to be presumed innocent. You can enter a plea of no contest to this charge. I would sentence you to the time that you've already served in jail. Which would you like to do, sir?
No contest.
Okay. Has anyone pressured you or forced you into this plea?
Sir?
Has anyone pressured you or forced you into entering this plea of no contest?
No.
Are you under the influence of alcohol or drugs this afternoon?
No.
You understand that if you're not a U.S. citizen, you could be deported by entering this plea?
Yes.
All right. All right, Mr. Orr, I'm going to accept your plea of no contest to the charge of trespass after warning. I'm going to adjudicate you to be guilty of that offense. I'm going to sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've already served. So you'll be released today, sir. I'm going to require that you not return to the 7-Eleven located at 3844 Old Winter Garden Road in Orange County, Florida. No one wants you there. You don't want to be there, so you're not to return. You're also to abide by all trespass warnings. You're also not to have any contact directly or indirectly with the store clerk at that location. Store clerk from that location. There are court costs that are going to total $273. I'm going to give you 30 days to pay that off. I'm sorry, a year to pay that off. You have 30 days to appeal my sentence. You cannot afford an attorney to handle that appeal. I can appoint one, and the appeal has to be in writing, all right? Good luck, sir.
Thank you.
All right, good afternoon, sir. Tell me your name, please.
Mr. Pugh?
All right, Mr. Pugh, you apparently were out on your own recognizance on a charge of trespass. You're here today on a new charge of trespass and also petty theft from the 7-Eleven on Dixie Belle Drive.
Yes, sir.
State, what are your thoughts on the original charge for which Mr. Pugh was released and the new charges from the 7-Eleven?
Your Honor, on the out on release, the state would recommend that his release be rescinded and a bond of $250 be ordered in 2020 MM 49710. And as to today's case, knowing that he has the out on release case, the state would still make an offer of an adjudication of guilt. 2 days Orange County Jail, 2 days credit time served, no return to the 7-Eleven on Dixie Belle Drive, abide by all trespass warnings, no contact with witnesses, and order and reserve restitution for 60 days, Your Honor.
Okay. Do we happen to know, Madam Clerk, on the case with which Mr. Pugh was originally released, which is the 20 MM 5091, the charge of trespass? Do we know how much time he has in on that? Any way of knowing?
1 second, Judge, I'm gonna look it up.
Sure. All right, Mr. Pugh, you had a case. Now you've picked up another case with 2 charges. So you have a total of 3 charges. Did you want to resolve all 3 of these charges today, or did you want to come back another day?
Guess come back another day.
Okay, all right. All right, I'm going to find probable cause. I'm going to appoint the Office of the Public Defender to represent Mr. Pugh. Mr. Pugh, I have an address here on the paperwork of rent.
He refused to come back, Your Honor.
Did Mr. Pugh dash on me?
Yes.
Okay. I apparently he was not interested. Okay. What I'm going to do for Mr. Pugh is I'm going to All right, I'm going to revoke his ROR on 20 MM 5091 AO. I'm going to set bond in the amount of $100. On the trespass in an occupied structure or conveyance, I'm going to set bond in the amount of $100. And on the petty theft, I'm going to set bond in the amount of $100. So he'll have $100 on the old case, $200 on the new case. Appoint the Office of Public Defender to represent him. Was he previously appointed the public defender on the old? I guess it doesn't matter.
He was.
Okay, all right. And is there any way we can put those in the same division, or is that above our pay grade today?
They usually do it later on.
Do they? Okay, all right, good. All right. All right, good afternoon, sir. Tell me your name, please.
Jordan Trent.
All right, Mr. Trent, you're charged with resisting an officer without violence. I reviewed the charging affidavit. I'm going to find probable cause. I'm going to appoint the Office of the Public Defender. I'm going to set bond in the amount of $500. Any other conditions, State?
No, Your Honor.
Okay. All right, good luck, sir.
Yes, I'm Robert Baxley.
All right, Mr. Baxley, you're charged with aggravated stalking with credible threat. You're currently set on no bond. I've read the charging affidavit. I find probable cause on that. We now need to determine the conditions of release. State, do you want to be heard on conditions of release on Mr. Baxley, who is accused of this crime to his across-the-street neighbor?
Yes, Your Honor. The state would recommend to the court a bond of $3,500 for this count and would ask the court to order no contact with the witness, with any witnesses or the victim, to maintain at least a 500-foot distance from the victim's property, and possess no weapons, firearms, or ammunition.
All right. Mr. Baxley, the address where this occurred, it looks like this was at your let me break this down. I have on my paperwork that your address is on Mallard Pond Court. Is that right, sir?
Yes, sir.
Okay. Do you have another place to stay temporarily while this case is resolved other than that address?
Yes.
Okay.
But I will have to go and get my animals and my computer, if that's at all possible.
All right. Is there somebody else that resides at Mallard Point
No,
Pond Court?
just me.
Okay, but you've got another place you can go?
Yes.
Okay, all right. All right, this is what I'm going to do. I'm going to set bond in the amount of $2,500 on this charge. I'm going to require that you not have any contact directly or indirectly with the victim, in this case, Isaac Mitchell. Also, no other, any other witnesses. I understand there was a neighbor that may have made a statement. You're not to possess any firearms or weapons. Any firearms that you possess have to be turned into the sheriff's office. I'm required that another condition of your release is you consume no alcohol or take any drugs for which you do not have a prescription. I'm required that you not return, that you not reside at the location of 5009 Mallard Pond Court. You'll be permitted to return to that location. I'm going to treat this state, unless there's some objection to this, I'm going to treat this like it's a DV case, where
No objection.
Mr. Baxley, you'll be permitted to return to this location with law enforcement to get your personal effects and to get your animals and anything that you need to do to be able to not return to that location. You're looking at probably 15 to 30 minutes max to get what you need to get. You're not going to be able to move furniture. You're going to have to pretty much tighten that place up, secure it, because I don't want you to be across the street. No good comes of that. Okay?
I understand, yes.
Oh, okay. I appreciate that you understand where I'm coming from on this. So you contact law enforcement, you'll be able to go in and get your possessions and not return to that location during the pendency of this case. Since you're not to have any contact with the individual I identified earlier, Mr. Mitchell, or any other witnesses, that means directly or indirectly, no text messaging, phone calling, having third persons talk to them, leaving anything on their door, anything at all, no contact whatsoever.
Yes.
You're going to want to be very careful that you not be accused. You're going to be very careful that it can't be, doesn't appear that you're having any contact, because that condition of your release, if violated, will result in you having your conditions revoked, and you're going to sit in jail till the case is resolved, okay? I'm also going to appoint the Office of the Public Defender. State, anything else I've overlooked?
No, Your Honor.
All right. All right, good luck, sir.
Are we done?
Yeah, we done.
Thank you, Your Honor.
All right, good luck, Mr. Baxley.
That one needs to be signed.
This one?
No, it wasn't in the stack.
Oh, okay. So let me get them all signed.
Yes. Thank you.
Whoop. There you go.
Thank you.
All right, who's next?
The next person on the docket, Erica Bianca.
Bianchi?
She's medical and won't be attending court today.
All right, I'm going to find probable cause based upon my review of the charging affidavit. I'm going to appoint the public defender's office to represent her, and I'm going to. Do we know whether she's got any prior? I don't
She
have.
has no history.
No history. All right, I'm gonna set her bond in the amount of $1,000. I'm also going to require that she not return to the Advent Health East, located at 7727 Lake Underhill Road. And she's not to have any contact with the witness Gonzalez. I'm looking for her first name. Melanie Gonzalez, the identified victim. No contact directly or indirectly.
And, Your Honor, is the court waiving her appearance?
Yes,
due to
I'll waive her
medical?
appearance and appoint the public defender and set those conditions of release. Good afternoon, sir. Tell me your name, please.
Ronnie Bridges, sir.
All right. All right, Mr. Bridges. It looks like you've got cases in Division 14, 15, 2 cases in Division 15 and a case in Division 20. Before I delve into that, let me sign this for Madam Clerk.
Okay, that's the last one.
Okay. It appears, let's take these in the order in which they are enumerated. The first one in Division 15 is 2020 CF 8415. Charges possession of cocaine. This appears to be a new charge, not a warrant. Is that right? I've got warrants on it. Looks like the other three.
Yeah, that one's the new charge.
Okay. All right. Having reviewed the charging affidavit, I'm going to find probable cause. I'm going to appoint the Office of the Public Defender. I'm going to stay the bond at $1,000.
Wasn't it 1,000 or 2,500?
That one, it says 1,000. He's got 3 more.
Okay.
Okay. The other one that we have is 2019 CF 10256 AO. That's a Division 20 case. That is a charge for which there was an arrest warrant signed by Judge Blackman. That bond shall be stayed in the amount of $2,500. Case number 2019 CF 10258 AO. That's a Division 15 case as well. That's on a warrant signed by Judge Blackman as well. Hang on a second. Let me make sure I got the right judge. Judge Blackman as well. Bond is set in the amount of $2,500. And then the last one is Division 14 case 2019 CF 10259 AO. Charge of sale of cocaine. That's also a bond from Judge Blackman. I'm sorry, a warrant signed by Judge Blackman. I'm going to stay the bond at $2,500. I'm going to appoint the public defender on all the cases.
And, Your Honor, the last case, the 10259, that was Division.
I thought Division 20. Let me see.
Division.
Should be 14.
14? You're right, Madam Clerk. It's Division 14.
Thank you.
Thank you. Okay. All right, next I have Michael Chalmers.
Yes, sir.
All right, Mr. Chalmers has got two cases. One is attempted burglary of an occupied dwelling and stalking. Mr. Chalmers is here on a warrant signed by Judge Schaefer. Bond is currently set at none. Probable cause is based upon the warrant, but I don't have any facts to make a determination of bond. Hang on one second.
Your Honor,
Yes, ma'am.
if the court wishes, I have the, I believe this is the correct one.
It
If
looks
I
like
may
we've
have
got-
just one moment.
Sure, we've got that case, and then Mr. Chalmers, that's a Division 10 case. There's also a Division 20 case for Mr. Chalmers of burglary to a dwelling with assault or battery with a weapon, and aggravated assault with a weapon. That's on a warrant also signed by Judge Strobridge.
Where did these warrants come from, Your Honor? Because I was never aware of none of these warrants until I got jumped out on by the police yesterday.
Okay. Judge Strobridge's warrant is dated July 9th and July 10th for Judge Schaefer's warrant. I do not have, Ms. Bush, were you trying to find some charging affidavits? so I
Your
can-
Honor, I'm looking to see if I can find the affidavit for the warrant, but I'm not seeing it.
I have it here.
I think Madam Clerk might be on that one
Actually,
as well.
there is an arrest affidavit, but this just says one. Madam Clerk, is that affidavit for both cases or just the?
Oh, I'm not sure. I'm just printing out the ones now. I'm trying to verify.
Because the attempted burglary, I could not find an affidavit for.
Because that creates a little bit of an issue since the warrant is a no bond. Based upon the charge, he may be entitled to a bond.
We only have the one for 8316.
Okay, well, that's a good start.
Did the PD need a copy?
And on the attempted, the court stated that he is entitled to a bond on that case.
All right, and is that on 2020 CF 8426 AO? The Division 10 case?
Yes, Your Honor. But I don't see, unless Madam Clerk has an affidavit for that one. But the state does have an argument on the
Okay.
8316.
Well, let's start with the 8316 since I have an affidavit for the arrest warrant. Let me take a moment to review that.
Nobody from corrections?
I'm looking in his documents. I don't see one.
I went for my wife and I got jumped out on by the police. And they said I had a warrant for 2 charges. Not 4. I don't understand what's going on.
All right, State, what's your argument on, I am going to find, based upon the warrant, this is on 2020 CF 8316, Division 20 case. I've reviewed the warrant. Again, this is not, so there's no confusion, that's the one executed by Judge Strobridge, for which she set bond at none on the burglary with an assault therein, and a bond on the aggravated assault. I've had an opportunity to review the affidavit for the arrest warrant, and so I'm now prepared to hear argument from the state as to conditions of release.
Yes, Your Honor. As to count one, which is an F1 punishable by life offense, the state would ask the court to take into consideration the facts contained within the sworn affidavit, facts that were provided by an identifiable witness, the victim in this matter, who is the ex-girlfriend of Mr. Chalmers. And in those facts, she provided the facts to law enforcement that she was asleep in her home. Mr. Chalmers, who does not reside there, she awoke to him standing over her with a knife in hand.
What?
He subsequently put his hands on her. The state would ask that the court find that proof is evident or presumption is great that Mr. Chalmers is the person so identified in the affidavit. The state would also point out to the court that there was an independent witness who did not know all of the facts of the case, but that witness did see Mr. Chalmers, and that witness did provide a phone to the victim. The state would also ask the court to take into consideration that Mr. Chalmers has a history that does include prior violent crimes, domestic violence, battery, and to take into consideration.
I object to that, Your Honor, because I have no.
Mr. Chalmers, let me finish hearing from the state.
Okay.
Anything that you say at this point, I want to make certain that you understand that we're being recorded. Anything that you say, even in an effort to persuade the court, anything you say can be used against you. So what may happen is you may say something that you want me to know, so that I will consider conditions of release. But later, the state will be able to get the recording and use against you in your prosecution. So at this point, you're going to want to not say anything. I also, if I have not made it clear, I don't think I mentioned yet, but I'm going to appoint the Office of the Public Defender. And so, Mr. Mazos, if you're, I'll hear from you as far as conditions of release. I guess I should have told you that before I heard from the state, so you were paying attention. But certainly I could share with you the charging affidavit. The state's arguing, I believe, well, so Mr. Chalmers, you just stay tight. I don't want you to say anything at this time. I'll give you an opportunity, should you wish to say something, advising you that you probably shouldn't. I'll finish hearing from the state, and then I'll hear from your court-appointed lawyer, all right?
Where is my lawyer?
Ms. Bush, I think I interrupted
Your Honor,
you.
the state is going to ask that he be held at no bond as to count one.
Okay.
And the state would also point out that in the other matter, that is the same victim.
May I ask, who is this
Hang on a
so-called
second.
victim?
Hang on a second, Mr. Chalmers, hang on. I'll give you an opportunity, but hold on one moment.
It is the state's understanding that it's the same victim, and I'm trying to confirm that now. But the nature of the other matter as well, coupled with his history and coupled with the facts of this case, the state would ask the court to hold him at no bond as to the burglary of a dwelling with an assault or battery therein.
And Ms. Bush, I'm looking at the, on the 8426, this is 2020 CF 8426. I have the warrant. I have the charge of attempted burglary of an occupied dwelling and stalking. Is there something contained in the arrest warrant that I'm not seeing that would lead you to the conclusion that it's the same
Your
victim?
Honor, it was the state, and that's why I said the state believes it's the same victim, because it seems to be my recollection that I've seen the facts of that case. I just am not seeing it in the clerk system right now.
Okay, all right. And then, Madam Clerk, is there any way to you've already looked and there's no
Yes, we don't have
affidavit?
it.
Okay, all right. All right, well, let's focus on the one that I have an affidavit that supports the warrant. I am going to find probable cause. I've appointed the Office of the Public Defender. Mr. Public Defender, did you want to be heard on the issues of release on the charge of burglary with an assault therein and aggravated assault with a weapon?
Can I at least know who?
Yes, Your Honor. Your Honor, before I start, can I address Mr. Chalmers?
Yes, you may. Please.
Mr. Chalmers, this is Pedro Matos. I'm going to be your appointed court defender today, but there will be another attorney appointed to you downtown. I just want you to withhold all the facts to yourself. Don't speak on any of the facts of your case in front of the court today, and you can contact your public defender downtown, and he'll be able to speak to you and clear any information or any questions you have.
Excuse me, with all due respect, I do understand what you're saying, but this is my life being held right now, and I'm innocent, first off. Second off, I don't know who no victim is. And third off, I do not have an ex-girlfriend. I have a current girlfriend who's who's waiting to bond me out as soon as I get a bond and can call her and let her know what my bond is. So with that being said, I think I am due a bond because of the simple fact I have no felony convictions. I have a no felony record, period. I have a clean record. So with that being said, I should be entitled to a bond.
Okay. Mr. Chalmers, the victim stated in the affidavit, and I'm not inviting you to have a conversation with me about it. Again, I've warned you that you're not going to want to say anything about the case. Your court-appointed lawyer has given you similar advice, but you did raise a question of who the victim is. I'm just going to give you that name. I'm going to suggest you don't say anything about it, but the complaining witness is a person named Chara Jones. C-H-A-R Jones. Mr. Matos, did you want to be heard on conditions of release?
Yes, sir. Your Honor, I asked that the court finds that the presumption of guilt is not evident and the presumption is not great. Although we do have the victim's affidavit, all we know is that they had a previous relationship, that he was inside the home. The witness from the independent witness did not see, all he saw was an altercation, a physical altercation. He did not see a weapon. He just heard her ask for help, and she asked to call the police. He does not have any other information about, there's no information from the independent witness that confirms that any of this happened. Therefore, I asked the court to find that the proof of guilt is not evident and that the presumption is not great, and to set a reasonable bond for Mr. Chalmers to go home.
All right. On the case that we're talking about, which is the 2020 CF, I want to make sure I got the right one.
8416 or
8316.
Looking at the
8316.
affidavit. Is that the 8316?
Yes, Your Honor.
Okay. On the 8316, that's the one I'm talking about right now. I have found probable cause. I have appointed the Office of the Public Defender. I've heard argument from the state and Mr. Matos on behalf of Mr. Chalmers. I am going to find proof of guilt is evident. Presumption, great. I'm going to stay the bond at none, as it is in the warrant. I'm going to stay the bond on the aggravated assault with a weapon at $2,500. Mr. Chalmers, you'll have an opportunity to file a bond motion and consult with your lawyer. On the other case, I'm a little bit stumped from the standpoint that I have a warrant that sets bond, indicates that the signing judge permits the first appearance judge, that would be me, to modify the bond. I understand there's no bond on the other case, but this is on 2020 CF 8426 AO. Attempted burglary of an occupied dwelling, I believe, is bondable. But I don't have any facts, so I can't determine what the appropriate conditions of release would be. Is there a way that we can revisit this tomorrow, permit the state to provide? Normally, I would order 72 hours to provide PC. I think the warrant establishes PC because a judge has reviewed the affidavit.
Yes, Your Honor. PC has previously been found in
Right.
that matter.
So the problem that I've got is I can't make a determination as to what conditions would be appropriate for release on that case because I don't know the facts. I know the state has indicated they believe it to be the same victim. I can make some assumptions, but I don't want to set conditions of release based upon assumptions.
And Your Honor, in the interim, the state will try to get hold of the affidavit to issue the warrant, and perhaps at some point, the affidavit that the judge used to find probable cause and issue the warrant might come up in the system in the interim. So if we can recall him as to that matter tomorrow.
Okay. Madam Clerk, there's no problem. Since he's not going to bond out today, can we have him recalled tomorrow?
Okay.
On 8426 AO.
Your Honor, I wish you would consider.
Hang on a second, Mr. Chalmers, almost done. That way, the judge can make a determination, the IA judge can make a determination as to the appropriate conditions of release. I'm not going to set any conditions of release on the, flip it back to the other case, where he does have a bond of $2,500, because he has no bond on the other.
Okay.
Your Honor, I feel that I should be entitled to a bond, being that I do not have a violent felony record.
Okay, and I understand that, Mr. Chalmers.
And being that I don't have a violent felony record, I don't understand why I'm not able to be given a bond. I haven't killed nobody, I haven't murdered nobody, or done anything like that. So with that being said, and my record is clean, I have no felony convictions. So I should be entitled to a bond based on the fact that I have no felony violent convictions on my record.
All right. Well, Mr. Chalmers, you've made your argument. I'm not persuaded by your argument. It is a compelling argument, but it's not persuasive. And I'm going to stand by. Hang on a second.
And the so-called victim is the one that's supposed to be bonding me out right now, is waiting on me to bond out.
All right. Well, this is subject to another judge on another day determining whether those conditions of release are going to be changed. I've entered the order on the case for which the 81. I'm going to get these numbers confused, Madam Clerk.
8426 is the one we're resetting.
Okay. So I've set bond on the I think 8139. 8316. And we're going to recall this tomorrow. Mr. Chalmers, you may be able to talk to your lawyer between now and tomorrow and straighten out some of this. All right? Thank you, sir. All right. Good afternoon. Tell me your name, please.
Elderly Dormill.
Okay.
Elderly Dormill.
All right.
Elderly Dormill.
Has something happened with Ms. Charlo? Did she bond? I've got Minerva Charlo.
She bonded,
Before Mr. Dormill.
Huh?
She bonded, Your Honor.
He bonded.
She bonded. Okay. Great. All right. This is elderly Dormill. Mr. Dormill was out on bond. Out on ROR, previously on a charge of petty theft and resisting an officer without violence from last month. That case number is 2020 MM 4756AO. While out on RR, he picked up a new charge, which is 2020 CF 8404, Division 14 case. Those charges are battery on a law enforcement officer, possession of drug paraphernalia, nuisances injurious to health, and trespass on property after warning. I'm going to find probable cause on the battery on a law enforcement officer, possession of drug paraphernalia, and trespassed after warning. I'm not sure that nuisance is injurious to health.
That was his spitting in the face of the officer.
Is that a lesser, isn't that a duplication of battery on a law enforcement officer?
No, Your Honor.
Really?
It's not a lesser included offense.
Well, I guess it's not a lesser, but it kind of, okay, so this is what I'm gonna do. I'm gonna find probable cause. I guess it would be its own crime, which would be a misdemeanor. I'm gonna find probable cause on all 4 charges. I'm gonna set bond on the battery on a law enforcement officer in the amount of $1,000, possession of drug paraphernalia, $100, nuisances injurious to health, ROR, and trespass on property after warning, $100. I guess, well, I shouldn't assume anything. Ms. Bush, is this something that you would make a recommendation if Mr. Dormill, who appears to be transient, wants to resolve this case today, or is it more serious?
I want to resolve it today.
Cannot resolve a felony at IAs,
Okay.
Your Honor.
That's what I figured. I would ask. All right, Mr. Dormill, so I found probable cause. I've set bonds in the total of $1,200. I've appointed the Office of the Public Defender to represent you. You can't resolve the cases today. The petty theft and resisting an officer without violence, it looks like there's a $600 and an ROR, so it's $600 on the petty theft, an ROR on the resisting, on the 2020 MM 4756.
Can I resolve it today, brother?
It was RR'd as to both counts.
As to both. Do we know why this says?
Mr. Dormill.
Hang on a second, Mr. Dormill. I'll answer your question in a sec.
That's the question for pretrial release is their form. They can verify for you, Judge.
All right.
I'm sorry.
Madam Pretrial Release Officer, I have on my goldenrod colored sheet indicating that Mr. Dormill was out on another charge. It has bond $600/ROR.
So he,
Was he ROR'd on both, or was one count $600 bond, the other was ROR? Do we know?
let me see, Your Honor. I'm checking now.
Okay. Well, the pretrial release officer helps me get up to
Both
speed.
charges were RR, Your Honor.
Both ROR? Okay. Mr. Dormill, to answer your question, this new charge is a felony. I can't resolve this charge today. You'll have another day to be able to do that. What I'm going to do is I'm going to revoke his ROR on the other charges. I'm going to set bond on the petty theft in the amount of $100 and the resisting in the amount of $100. So on 2020 MM 4756AO, $100 on each of those 2 charges. On the
So-
new charges, I've already told you what those are right now.
So what day this week I should be leaving?
Well, what I'm going to do is I found probable cause on the old charges. I've revoked your ROR on the previous charge. I've appointed the public defender's office. So you can talk to your lawyer about resolving the cases before or after you're able to post bond. On the new charge, I'm also going to require that you not return to the 7-Eleven where this occurred. And that location is 901 South Orange Blossom Trail.
So when should I be leaving?
All right, I think that does it. Good luck, Mr. Dormill.
When should I be leaving?
All right, good afternoon, sir. Tell me your name, please.
Devin Glenn.
I'm sorry, sir?
Devin Glenn, Your Honor.
Okay. All right, Mr. Glenn, it looks like you've picked up new charges on top of your old charges. You were out on release on a sale and delivery of cocaine within 1,000 feet of a school, and that was in 2020 CF 7620AO. Looks like your bond on that was $1,000, posted back in June. You've also got consecutive to that 7621. $10,000 bond on 250, 7622, $10,000 on 250. So the new charge Give me just 1 minute. Was 212? State, do you know, did they just add some charges to Mr. Glenn?
Yeah, this was all stemming from the same incident. I thought my lawyer was going to be here with me today, but
Okay.
he had said to mention that this is all one big.
Okay. All right, Mr. Glenn, I appreciate that. I'm going to advise you not to say anything else, but that's very helpful.
Okay, my bad.
I'm going to take no action on the other cases for which Mr. Glenn was out on bond. There is a warrant that has been signed by, looks like Judge Laurent, setting the bond in the amount of $50,500. I guess they added a charge, State?
Your Honor, I'm pulling his other cases up right now, and the dates are not adding up. If I may have just one moment to.
It looks like the warrants have the same date. It looks like 2/12.
Your Honor, in 7816, for instance, this begins with February 21st. And in 7815, that date was June 17th of 2020. And I'm trying to find the dates on the out on release cases as well, Your Honor.
Because the arrest warrant I'm seeing that was signed by Judge Laurent on June 25th.
Because you have two separate cases?
I have a fistful of cases that he was already charged on, for which he was on a bond. I have a new case here.
Let me see what's
Am I doing this wrong?
Yes.
It looks like they added a case.
Okay, so
Hang on one second. We'll sort all this out.
these are the out on bond cases. These
Right.
3. And then he has a new warrant here, and then he has a new warrant here.
Oh, so he has 2 new cases. Okay.
Yes. And we probably, let me see if we have affidavits for those.
All right. Well, that also shows.
I'm printing the affidavits now. I don't think it was provided.
That also, it all shows the same date as 2/12, on about 2/12. So, Madam Clerk, is what this is then, is he has the 3 new charges in this and 2 new charges in this?
Correct.
Okay.
And I'm printing the affidavits for you now, if you need those.
It looks as though the previous first appearance judge set bonds in the amount of $10,000 on the trafficking charges.
I think we have 50,000.
And Your Honor, while these are all trafficking and drug-related charges, looking at one of the old arrest affidavits to issue the warrant, I am seeing dates that go from February through June.
Okay. Well, this looks like an ongoing investigation.
If I could talk, it was an ongoing investigation.
Okay, all right.
I wasn't aware of it till the 19th either of June.
Okay. It appears as though he was arrested on some charges, bond was set, he posted bond, and then the state brought additional charges from the same ongoing, it's all the same agent. Looks like there's so at this point, I am now tasked with the responsibility of setting conditions of release. It looks like a trafficking, possession of Percocet, possession of ketamine, trafficking cocaine, and unlawful use of a two-way communication device. I do also note that it appears that Mr. Glenn turned himself in once he found out that there were warrants, additional warrants, if I read that correctly.
Yes, Your
State,
Honor.
do you have a position on the new bonds, on the new charges?
Your Honor, the state would recommend that the court take no action on his out on bond.
And I
And-
agree. I think that's the appropriate thing to do. I'm not going to take any action on the 3 cases for which bond has been posted, so I'm not going to take any action. On the 5 new charges?
And on the 5 new charges, the state would recommend that the court on 7816 stay the bond on count 1 at $50,000. Counts 2 and 3, reduce them to subsidiaries of $150 each. On 7815, the state's recommendation is that the court stay the bond on count 1 and reduce the bond on count 2 to $100.
All right, what I'm going to do is, I think consistent with the other charges, I'm going to reduce the bond. So I'm in 2020 CF 7816AO. I have 3 new offenses. On the first offense, trafficking in cocaine, I'm going to reduce the bond from $50,000 to $10,000. I'm going to set on the possession of oxycodone, I'm going to reduce that from $10,000 to $1,000. And on the possession of ketamine, I'm going to stay that at $1,000. So on that case, Madam Clerk, that total bond will be $12,000.
Yes.
10,000, 1,000, and 1,000.
Yes.
On 2020 CF 7815 AO, trafficking in cocaine, I'm going to reduce that bond to $10,000. And for the unlawful use of a two-way communication device, I'm going to stay that at $500. So on the 2020 CF 7815, that total bond would be $10,500.
Yes.
Okay. I see that Mr. Glenn is currently represented by Mr. Lindsay. Is that right, Mr. Glenn?
Yes, sir. Yes, Your Honor.
All right. Do you intend to have him handle the new charges as well?
Can you repeat that?
Do you intend to use Mr. Lindsay on the new charges as well?
Yes, Your Honor.
Okay, I'm not going to appoint the public defender because that would be unnecessary. Mr. Lindsay can handle all these cases together. Is there anything else from the state?
Nothing further.
Okay, all right. Good luck, Mr. Glenn.
Thank you.
Thank you, Madam Clerk, for those warrants. All right, good afternoon. Tell me your name, please.
Kiara Hobby.
Okay. What did Mr. Heintzmann, what happened to his cases?
He
bonded
refused
out?
court, Your Honor. He refused court.
Refused? Okay, do we roll that to tomorrow, Madam Clerk, or do we proceed in his absence?
It's up to the public defender and you judge if you want to waive it or not.
Okay. So today's the 13th. Apparently, Mr. Heintzmann has arraignment. I'm on Christopher Heintzmann. He's got new charges, and he was out on bond on a misdemeanor that's set for arraignment tomorrow. I'm going to guess that they're going to arraign him tomorrow in the jail.
Yes, Your Honor, that was a notice to appear.
Okay. Why don't we just have all this done tomorrow, since he's going to be arraigned on the misdemeanor, and he's refused court. So let's just push that to tomorrow with my apologies to the IA judge tomorrow.
Okay.
All right, and this is Ms. Hodby?
Yes, sir.
Okay, Ms. Hodby is charged with possession of MDMA. I reviewed the charging affidavit. I find probable cause. I'm going to stay the bond at $1,000 and appoint the office of the public defender. Thank you, ma'am. Next, I have Joshua Holder. Good afternoon, sir. Tell me your name, please.
Joshua Holder.
All right. All right, so it looks like Mr. Holder has a new charge. He was out on bond in the amount of $5,000 on the charge of possession of a firearm by a convicted felon and a $150 bond on the carrying a concealed firearm. That bond was posted back on June 10, it appears. He's picked up new charges, which include fleeing and attempting to elude a police officer and reckless driving. I've reviewed the charging affidavit. I find probable cause on the new charge. He also appears to have a resisting an officer without violence, and that's all right.
Okay.
Okay. Same charging affidavit. Okay. So, State, do you have a position on the? He has no bond on the fleeing and attempting to elude according to the charging affidavit. He's got a bond on the resisting and on the reckless. And then I've got the out on bond. So let's do the out on bond first. Ms. Bush, do you have any position on what should happen with the out on bond?
Yes, Your Honor. As he is to stay free of any criminal charges, the state would ask the court to revoke his bond and release and set it at none and let the trial division make the determination of what, if any, bond would be appropriate. As to 2020 CF 8428, the state would recommend a bond of $3,500. As to count one, ask the court to stay the bonds as to count two and stay the bond in the MM matter as well.
All right. I think we probably should do them in that order. I'm going to find probable cause on the new charges, which are contained in 20 CF 8428 AO and 2020 MM 5079 AO. On the fleeing and attempting to elude, I'm going to set bond in the amount of $2,500. On count two, reckless driving, I'm going to set bond in the amount of $100. I found probable cause, and I'll appoint the public defender. On 2020 MM 5079 AO, the charge of resisting an officer without violence, I'm going to find probable cause, appoint the public defender, and stay the bond at $500. On the out on bond, which is 2020 CF 7161 AO, I'm going to revoke the bonds on that case and set bond in the amount of none. And I don't know whether he already has the public defender on that other one, but I don't think I can make that finding. I'm just revoking his release.
Okay. I could talk. Can I say something to the judge?
Tremaine Holly.
I can say it. I can say it.
All right, good afternoon, sir. Tell me your name, please.
Tremaine Holly, Your Honor.
Okay. All right, I have this is 2020 CF 8265 AO, Division 11 case. I have a warrant signed by Judge Strobridge for no bond on a fleeing and attempting to elude with lights and siren. So I don't have the charging affidavit. I'm sorry, I don't have the affidavit for the warrant.
Your Honor, if
Can
the
I say
court
something?
wishes, the state
Not
has,
yet, Mr. Holly.
Okay.
the state has a copy here. May I approach?
You may. Thank you. All right, give me just a moment to review the affidavit for the arrest warrant. State, do you have a position on, I'm gonna, having reviewed the affidavit for arrest warrant, and the warrant, which I think on its own establishes probable cause, I'm gonna find probable cause on the charge of fleeing and attempting to elude a police officer. State, do you want to be heard on conditions of release?
Yes, Your Honor. The state, based on the fact that there is no significant history, the state would recommend a bond of $2,500 in this matter.
All right. All right, so Mr. Holly, what I'm doing is you're currently in no bond. I'm going to set a bond in the amount of $2,500. I'm going to appoint the Office of the Public Defender to represent you. And so you can make arrangements to be released. I know that you're dying to tell me something. I have to tell you that anything you say, right now you're being recorded. I've appointed the Public Defender's Office to represent you. It's probably in your best interest not to say anything unless there's something you want me to know.
It's okay, Your Honor.
Okay, all right, good choice. Thank you, Mr. Holly.
And Your Honor, may I just see if my first appearance information sheet was connected to that paperwork?
Okay. I can also give you the charging affidavit. I think it probably was. It is. You want to approach and
If I
retrieve
could
that?
just get that.
Thank you very much for having that for me to review. Itchy nose. All right, good afternoon, sir. Tell me your name, please.
Gene Joseph.
All right, Mr. Joseph, you are charged with two cases. You've got 2020 CF 8416, which is battery on a law enforcement officer, resisting an officer with violence, and attempted battery on a law enforcement officer. I've reviewed the charging affidavit. I'm going to find probable cause. I'm going to appoint the Office of the Public Defender.
Judge, on his FTA case, he has Roger Whedon.
Is Roger Whedon?
Yes, so is he gonna have that for both cases or just the FTA?
Is Roger Whedon appointed, or does, Mr. Joseph, do you intend to hire Mr. Whedon on all these charges?
Yes.
Okay, all right. I'm not going to appoint the Office of the Public Defender. That'll save us some paperwork. Thank you, Madam Clerk. I am going to find probable cause and stay the bonds as contained in the charging affidavit. $2,500 on the battery Leo, $1,500 on the resisting with violence, and $500 on the attempted battery on a Leo. The FTAs. So he's charged with FTA as a felony?
Yes, he has a failure to appear.
Oh, I got you. I'm looking at the KPS signed by. All right. So there's this is in 2019 CF 15024AO, Division 22 case. There's a KPS for failure to appear for trial on June 18th.
Can I say something?
So, hang on one second. I'm going to stay the bonds. $2,500 on the battery, domestic violence by strangulation, $1,000 on the tampering with a witness, and $500 on the domestic violence battery. Mr. Joseph, you have a very good lawyer representing you on all these cases. I have found probable cause and I've set bonds. You're free to tell me something, but your lawyer's probably not going to want you to say anything because we're being recorded, and whatever you say on any of these things is going to be used could be used against you by the state. I have a representative of the state attorney's office here whose pen is poised over paper to take any notes that might be helpful to her in the prosecution of your case. So, did you have a question to ask me, or did you? Are you good?
Because I never knew that I had a warrant.
Okay.
Because of my mail issue. Every time I changed my mail, she would change it back. So it was something, and I even called, and I haven't gotten any response about my court dates or anything like that. I even contacted my lawyer.
All right. All right. Well, that's an explanation, but I think you should talk to Mr. Whedon, and he may be able to help you with those. All right.
Okay.
All right. Thank you, sir.
Thank you.
All right, good afternoon, sir. Tell me your name, please.
Dalton McCall.
All right, Mr. McCall, you have a new charge of driving while without a license, causing serious bodily injury. No, wait, that's not right. You have a warrant.
The information was filed in this matter. It's a capias.
So it looks like Mr. McCall was already out on release from last October on the charge of grand theft third-degree motor vehicle.
Yes.
And then, Ms. Bush, the new charge, it looks like there's a capias from May. Was that failure to appear for arraignment?
No, Your Honor, on March 17th, we filed an information in this matter.
All right.
And I believe that a capias issued from that information. This was, I believe, an at-large matter previously.
Okay. All right, what I'm going to do is, based upon that, I'm going to release Mr. McCall. I'm going to release him ROR on the new charge, driving without license. Well, before I do that, so
And
Mr.
that
McCall,
was-
the address that's on the capias on 9th Street in Taft, is that where you currently reside?
No, sir. I am staying at 9619 8th Avenue.
And I didn't hear the last part. That address, where is that?
9619 8th Avenue. It's in Taft, Orlando, Florida 32824
In Taft?
area
All
code.
right. All right, it may very well be that this warrant was issued because they lost track of you from the 9725 9th Street address.
Okay.
Am I understanding that?
Your Honor, this capias was issued because they may not have been able to find him to serve the capias until now. But in the driving without a valid driver's license and by careless and negligent operation of the motor vehicle, he did, according to the information, cause the serious bodily injury or death of one Jacob Graham.
Okay. Are you going to request that I stay the bond at $1,000 on that capias?
Yes, Your Honor.
I'm going to stay the bond at $1,000 on the capias on the 2020 CF 3673 AO. I'm going to appoint the Office of the Public Defender. I'm going to find probable cause based upon that capias. I'm going to require that Mr. McCall update his address with the clerk. Madam Clerk, did you get that address that Mr. McCall gave us?
No, Judge.
Mr. McCall, why don't you shout that out again for us? Madam Clerk, if you'll put that in the paperwork so
Your
we make
Honor.
sure we know where it is.
Before he shouts it out, it is on the warrant, the arrest warrant affidavit.
Yes, ma'am.
Double check it.
Yes,
Oh, it
ma'am.
is?
Yes, ma'am.
Yes,
Oh, that
Your
would
Honor.
make sense because that's where they found him, right?
Yes.
Yes, Your Honor.
All right. Then there's no need to shout it out. I'm gonna take no action on the ROR on the grand theft. And I'll leave that to the trial division to see what they want to do. That's on the 3673. Okay. All right. All right. Good luck, Mr. McCall.
So, question: if I bond out on that case, the $1,000 bond, if I pay that bond, I still don't get out?
No. Yes. No. Sorry. It's been a long day already. I'm not taking any action on the original case for which you were out on your own recognizance. So you're technically still out on your own recognizance. So if you are able to make bond on the new charge, $1,000, you'll be released.
Okay, that's all I needed
Okay.
to know, sir. Because I
All
have
right.
my dad paying my bond right now. He was
Okay.
trying to. I just needed to know if
All
I
right.
pay the
Good luck,
bond.
sir. I'm certainly not as efficient as Judge McGinnis at this end.
That's okay. Judge McGinnis had the easy stuff.
He did all the easy stuff?
He left you with the felon.
Well, he'll do that. Do we have Jonathan Patrick?
Your Honor, he refused court.
Okay. Alrighty. Alright, so it looks like he was picked up on 2020 CF 8429 AO in Division 17, resisting an officer and destruction of evidence. He refused court. I'm going to find probable cause. I'm going to stay the bonds at $250 on each charge and appoint the public defender's office.
Judge, are you waiving his appearance?
I'm going to waive his appearance.
Okay, thank you.
Next, I have Tony Stanley.
He would not be attended due to his behavior.
Okay, well, that's no good. All right, so we've got, well, I'm gonna roll this to tomorrow. Maybe his behavior will improve. There's a capias. No bombs. Yeah, we'll just revisit that tomorrow, Madam Clerk. Naomi Thames.
Medical.
I'm sorry?
Will not be attended due to medical.
Okay. All right, I'm going to waive her appearance. I'm going to find probable cause. I'm going to appoint the public defender, stay the bonds on the robbery by sudden snatching at $1,500 and the petty theft at $500.
You have another case, Your
And no return and no victim contact. So does she have
There's a second
She has
case.
2 cases, all right. Then the other case is a petty theft. Well, that doesn't make sense. I'm going to stay that bond at $500, find probable cause, waive for appearance, and appoint the public defender in that case as well. Jeffrey Thomas.
Bonded.
Bonded. My job easy, all right. Anthony Williams.
Okay, here we are.
All right. Good afternoon, sir. Tell me your name, please.
Anthony Williams.
All right, Mr. Williams is charged with petty theft and trespass. I have an arrest warrant as probable cause. Mr. Williams appears to be transient according to the charging affidavit. State, did you want to make a recommendation if Mr. Williams wants to resolve these cases?
Your Honor, he can't resolve the case. It's a felony matter. It's petty theft, 2 prior convictions.
Oh, okay. That's what that means. Okay. All right, I'm going to find, based upon the warrant, I'm going to find probable cause. I'm going to stay the bonds at $500 on each for a total of $1,000. I'm going to appoint the public defender's office to represent Mr. Williams. Thank you, sir.
Thank you.
Next, I have Anthony Williams. All right, good afternoon, sir. Tell me your name.
Anthony Williams.
Are you saying anything, Your Honor? We can't hear you.
Can't hear.
The audio is gone. I don't know if you can hear me or not.
Cause I seen it in the morning, like,
We still can't hear you, Your Honor. I don't know if you can hear me, but we can't hear you. Well, he must be can't hear me because he's still. Hey, G. Can somebody go down there and tell them everyone we can't hear them and I guess they can't hear us? Yeah. We can't hear, it's like it's frozen. You know we did it.
I think that's a great idea. We're still on the record, right, Madam Clerk?
Yes, but
We
they
just can't
can't.
communicate with them.
Well,
We can hear you now, but we didn't hear anything beyond when the defendant first came up to the podium. We didn't hear
Okay.
anything else.
Okay, and which defendant is that? That's the last gentleman I just did?
Anthony Williams.
Anthony Williams?
His name is Anthony Williams? Oh, I thought we Anthony was a while ago.
I thought maybe that was Dominique.
Okay, now I have to go back.
I'm sorry, sir, tell me your name again.
Anthony Williams.
Yeah.
Maybe at the bottom, that flipped him over.
That's the last page of felony.
Yeah. We did Anthony, we did Antoine Williams, there's a Dominique. So, the ones
There was
underneath there.
3 Williams. You had one before, his name was Anthony Williams.
Okay.
And the next one is, he pronounced his name Anthony Williams.
All right.
So
No, it's
before
spelled-
we
spelled-
haven't heard anything after the first Anthony Williams. Everything beyond that, we did not hear.
Gotcha. All right, we got 3 Williamses. So Madam Clerk, can you tell me what I did on Anthony Williams? He's charged with petty theft with 2 prior convictions, which the state has pointed out to me is charged as a felony, and there was bond in the amount of $500 on that and a trespass. I'm gonna guess I found probable cause, stayed the bonds, and appointed public defender?
Yeah. What's his date of birth to make sure we have the right person?
Mr. Williams, were you born on May 7th of 1977?
No, sir. March 8th, 1997.
March 8th?
Yes.
All right, so this is
This is
Antoine.
Yeah.
He pronounces it Anthony.
His bond is stated $2,500. No contact with victim. Do not possess no weapons, firearms, or ammunition.
All right.
And the public defender was appointed.
Great. All right, thank you, Mr. Williams. So the first Anthony Williams heard me, the second
I believe he was, the other Anthony Williams was after
And
him.
I don't think that
The first
Dominique-
Anthony Williams, his birthday was 5/7/1977.
Okay, did he,
He's gone. The next William is Anthony Williams, but his date of birth is March the 8th, 1997.
right, and we just did him. Okay. All right, and that brings us to Dominique Williams. All right.
Morning, Your Honor.
Good afternoon, Mr. Williams. You are here on a violation of probation. The warrant was signed by Judge Wilson.
Yes, sir.
I'm going to find probable cause based upon that warrant, and pursuant to her order, bond, this will remain no bond. I'm going to appoint the Office of the Public Defender to represent you on that violation of probation.
Yes, sir.
All right, thank you, sir.
Okay.
Next, we have Jamie Ewing, and I think the state was ready, the state and defense were ready to address that with me.
Yes, Your Honor. And Jamie Ewing is not present. This morning, she was a medical.
Okay.
And the issue here was that the weekend judge was not certain, I believe, and if Mr. Matos will correct me if I'm wrong, I believe it was that the judge was not certain who the listed victim was in this matter.
Okay.
And at times, the court does not have the witness form on the affidavit. And the witness form includes the victim's name, Rodrigo Davis, who is listed in the body of the narrative. And also, this appeared to be a mutual combat. But that's the reason this matters before us again.
So I am looking at an order of commitment from, this looks like Judge Schaefer over the weekend found no PC and reset it for today. Actually this morning, and then it was bounced to this afternoon. So state, your argument is that the PC is based upon the charging affidavit, which identifies the victim as Rodrigo Davis?
Yes, Your Honor.
All right. I think that they're, having reviewed the charging affidavit, Mr. Matos, did you want to be heard? I don't know whether a probable cause determination not having yet been found, whether Judge Schaefer appointed the PD's office. I don't know whether you had a chance to review the charging affidavit. Do you have an argument to be made?
I have, Your Honor. The previous judge did not find who the victim was, and the victim is not identified in the police report in the charging affidavit that I have in front of me. I don't know if there was an updated one.
If there's not an updated one, but the arrest affidavit, within the four corners of the arrest affidavit, it also contains a witness form. And the state will provide it to the court and show it to defense counsel.
You could show that to defense counsel. I actually have the arrest affidavit that contains the name of the victim as Rodrigo Davis.
Okay.
If Judge Schaefer's finding or failure to find probable cause was based upon, Mr. Matos, is it your understanding that the failure to find probable cause was based upon the absence of that identified witness?
Your Honor, I feel that my understanding was that the failure to find probable cause is that they, due to when the caller was Miss Edwin, and the fact that she was also hurt, calling that Mr. Davis was the one that the aggressor, that the reason she could not find probable cause was because it could be also very possible that Mr. Davis was the actual aggressor in this affidavit.
All right, having reviewed the charging affidavit, I'm going to find probable cause. I'm also going to release Ms. Ewing ROR in order that she have no contact directly or indirectly with the alleged victim in this case, which is Rodrigo Davis. I'm trying to remember whether this was the 4640 Star Coral Drive, apartment 283. Did they reside together there, or was this
No, Your Honor. I'm showing a separate address for Mr. Davis. However, the affidavit.
Okay, it looks like this happened at Staghorn Drive.
Yes, Your Honor. And neither of them show that address.
Okay.
But the state would ask if the court would reconsider ROR and release Miss Ewing PTR as she has a recent battery conviction in 2019.
Do we know who the victim of that case is?
I do not, Your Honor. I can look it up real quickly.
Madam pretrial release officer, does Ms. Ewing qualify for PTR?
Yes, Your Honor.
Okay. All right, well, that seems like a reasonable request. I just didn't want her to stay in, she's been in 4 days now?
Yes, Your Honor.
All right.
12, 33 days.
All right. I'm going to release her pretrial release with special conditions of no contact directly or indirectly with the alleged victim in this case, Mr. Rodrigo Davis. No consumption of alcohol or drugs without a prescription, no weapons or firearms. I'm not going to get into the keep separate. I can't tell. I got two different addresses here. I don't know who lives where. So there'll just be no contact. So if they reside together,
They stay at two different addresses.
they stay at two different addresses? Okay, well then that simplifies everyone's life then. Okay. Having found probable cause and released her pretrial release, is it helpful if she qualifies for PTR?
Yes.
All right, then I don't need to complicate this any further. Okay. All right, and I think that brings us to Tulista Singh. Is this Mr. Singh?
Yes.
All right. All right, I think this was rolled from this morning, is that right?
Yes, Your Honor. Yes, sure.
All right. I have reviewed the charging affidavit. I'm going to find probable cause for the charge of aggravated battery with a
That's not me.
deadly weapon.
Your Honor,
Yes.
I apologize. Has it been determined that he does not need the interpreter? He was on our interpreter list this morning.
Okay. Mr. Singh, can you understand me?
Yes.
Okay.
They don't have that knowledge.
All right, well, I'm going to find probable cause. State, did you want to be heard on conditions of release?
No, it's. Who's signing? Okay, sorry.
I don't think he's understanding, Your Honor.
Well, the question I've got is, if he does not understand, how would this be different if he waived his appearance or had a medical situation? I mean, I'm going to find, other than he may not understand what I'm ordering, I don't need to hear from him to make a determination of probable cause, do I?
No, Your Honor, but he has the right to understand what the conditions of release are.
Okay.
I understand you, sir.
I'm sorry, sir?
I understand what you said.
Okay.
He said he
It
understands.
says he understands. All right.
The state would recommend a bond of $3,500. Ask the court order no weapons, firearms, or ammunition. No contact with the victim. Maintain separate residence. And I don't believe DCF was involved in this matter.
Okay. All right, I'm going to find probable cause. I'm going to appoint the Office of the Public Defender to represent Mr. Singh, who indicates that he is understanding of the proceedings. I'm going to set bond in the amount of $2,500. I'm going to require that Mr. Singh possess no weapons or firearms, consume no alcohol or illegal drugs, and have no contact directly or indirectly with his uncle, Conde Saram. It appears as though they both reside at 3803 Pine Ridge Road address. So I'm going to require they maintain separate residences. Mr. Singh will be permitted one return with law enforcement to collect personal effects. I think that probably should take care of that. Anything else? I've appointed the public defender to represent Mr. Singh. Anything else from the state?
Nothing further.
Mr. Matos, anything you want me to know as Mr. Singh's attorney?
No, Your Honor.
All right. All right, good luck, Mr. Singh.
No.
Okay, I'm out of paperwork, I believe. Madam Clerk, are there any other cases that I need to address?
That's everything.
Okay. State, anything else?
And nothing further from the state.
All right, anything else from the defense?
Nothing further from the defense, Your
Anything
Honor.
else from pretrial release? Is that Marshall?
Memphis State.
Memphis State. You know, I should know that. Because it's a tiger.
Yeah, it's a tiger.
Oh, yeah, Marshall is the color's wrong, too. Marshall's green.
Green.
Yeah. I was looking over, I was trying to think, M, tiger. I should have known that.
That's okay.
It's a very cool mask. All right. Okay, all right, if that is it, then we are adjourned. Thanks, guys.
That's his, no contact order, and
Okay.
there's another order for you to
Okay,
sign.
great.
Come back and visit us sometime.
Thanks for your patience with me. I get rusty at this stuff. I do it so frequently.
That's okay.
By the time I'm up to speed, then I don't have to do it for another 20 weeks or so. I'm hoping that Judge Carter will be happy with my work. All right, with that, we will be adjourned.
Beltran is mine.
I'm sorry?
Beltran is mine.
Okay.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. The interpreter has not been sworn in yet today.
All right, good morning, Mr. Morales. Do you solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability?
I do.
All right, Mr. Morales, we are here at this time in case 20 CF 183. And we are here in this case on first of all, on a motion to withdraw plea. The defendant's name is Luis Beltran. Mr. Beltran, good morning, sir. If you'll raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Buenos días, señor Beltrán. Levante la mano derecha para prestar juramento. ¿Jura solemnemente o promete que el testimonio que dará será la verdad, toda la verdad y solamente la verdad? ¿Lo jura ante Dios?
Sí, señor.
Yes, sir.
All right. Please state your name, sir.
¿Cómo se llama usted?
Luis Beltran.
Luis Beltrán.
Mr. Beltran, you had entered a plea of guilty in this case to the charge of traveling to meet a minor, attempted lewd or lascivious battery, and transmission of material harmful to minors back on June 8th of this year. And you were sentenced at that time.
Your Honor, I'm sorry, if the interpreter can get a repetition of the charges, please.
Okay, the charges were traveling to meet a minor, attempted lewd or lascivious battery, and transmission of material harmful to a minor.
Thank you, Your Honor. Señor Beltrán, usted se había declarado culpable en este caso anteriormente, donde las acusaciones eran de viajar para tratar de encontrarse con un menor o una menor, tentativa de agresión deshonesta y también de transmitir material indecente o inapropiado para un menor. Esto fue el 8 de junio de este año y se le impuso la sentencia.
And you were sentenced in this case on June 8th to 4 years in the Department of Correction, followed by 5 years of supervised sex offender probation.
Y la sentencia se la impuso el 8 de junio, donde fue de 4 años en el Departamento de Correccionales, seguido por 5 años en un régimen de probatoria, pero bajo delitos sexuales.
Your lawyer, Ms. Smith, subsequently filed a motion to modify the sentence to a period of 6 years state prison with no probation to follow.
Y posteriormente su abogada, la señora Smith, presentó un pedimento para modificar la sentencia a que se modificara a 6 años en la prisión del Estado, pero sin ser seguido por un régimen de probatoria.
Since the court cannot modify the probation to increase the sentence, absent a violation of probation, I cannot modify the sentence to increase it without a violation of the terms of the sentence. Ms. Smith filed a motion to withdraw the plea and has filed another plea form indicating you wish to then enter a plea to obtain the sentence that you are seeking.
Thank you, Your Honor. Just one quick clarification, Your Honor, if you don't mind, please. Right at the beginning, you said that the court cannot modify the sentence to increase the sentence if...
To increase the penalties.
Okay, unless there was some kind of violation of probation.
Correct.
Y bueno, señor Beltrán, el juzgado no puede modificar la sentencia para aumentar el castigo o la sanción a menos que haya habido un incumplimiento en el régimen de probatoria. Por lo tanto, la señora Smith entonces presentó un pedimento para anular o cancelar, retirar la declaración presentada, ha entregado otro formulario donde usted ahora quiere entregarlo y declararse para tratar de obtener la sentencia que usted está pidiendo.
Is that your understanding, sir?
¿Es lo que usted tiene entendido?
Sí, señor.
Yes, sir.
So, first of all, you do wish to withdraw the plea that was entered on June 8th of 2020, is that correct?
Entonces, primeramente, ¿es correcto que usted lo que quiere es renunciar o cambiar, perdón, se me fue la palabra, cancelar la declaración que usted dio anteriormente el 8 de junio del 2020?
Sí, el anterior, sí.
Yes, the prior one.
Sí, señor.
Okay, any objection, State?
No, Your Honor. I brought the order, Judge, in case you needed it. Okay.
But this time, Mr. Beltran, I will grant your motion to withdraw the plea that was entered on June 8th of 2020 and set aside the sentencing, the sentence that was imposed on that date.
I'm sorry, your voice is trailing off.
I will at this time grant the motion to withdraw the plea that was entered on June 8th of 2020 and set aside the sentencing, or the sentence that was imposed on that date.
Bien, entonces, señor Beltrán, le voy a conceder su pedimento, donde usted ha solicitado cancelar o retirar su declaración que dio el 8 de junio, y entonces se pondrá a un lado la sentencia que se le impuso en esa fecha. Yes, sir.
So we are now essentially back at square one, and you are charged in this case with traveling to meet a minor in count 1, attempted lewd or lascivious battery in count 2, and transmission of material harmful to a minor in count 3.
Muy bien, señor Beltrán. Entonces, bueno, nos encontramos nuevamente desde el comienzo, para comenzar de nuevo. Las acusaciones contra usted son del de viajar para encontrarse con un menor o una menor, tentativa de agresión deshonesta y también transmitir material impropio para un menor. Cargos 1, 2 y 3 respectivamente.
Ms. Smith has submitted a written plea form that indicates you wish to resolve the case by again entering a plea of guilty to each one of those charges. Is that what you want to do?
La abogada Smith nuevamente ha entregado un formulario aclaratorio donde indica que usted quiere resolver estas acusaciones declarándose culpable a cada una de ellas. ¿Es eso lo que usted quiere hacer?
Sí, señor.
Yes, sir.
Okay. All right, we had this conversation back in June, but we'll go through it again, just to make sure you understand your rights.
Aunque hablamos de esto en el mes de junio, vamos a volver a repasarlo para asegurarnos de que usted comprende cuáles son los derechos que usted tiene.
The charge of traveling to meet a minor is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000.
Bajo la acusación de viajar para encontrarse con un menor o una menor, esto es un delito mayor de segundo grado que conlleva una posible sentencia máxima de hasta 15 años en la prisión, 15 años en régimen de probatorio y una multa de hasta $10,000.
Each of the other two charges is a third-degree felony punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000.
Y en los otros dos casos, cada uno es un delito mayor de tercer grado sancionable con hasta 5 años en la prisión del Estado, 5 años en régimen de probatorio y una multa de hasta $5,000.
You understand what the charges and the possible penalties are?
¿Entiende usted cuáles son las acusaciones y las posibles sanciones?
Sí, señor.
Yes, sir.
Did you read and fully understand this written plea form?
¿Leyó y comprendió cabalmente el formulario declaratorio?
Sí, señor.
Yes, sir. Do you have any questions at all about anything on the written plea form?
¿Tiene usted alguna pregunta sobre algo que se explica en el formulario declaratorio?
No por el momento, señor.
Not at the moment, sir.
Okay. And in exchange for the pleas to counts 1, 2, and 3, the state would be, again, all processing remaining counts. Actually, it's 2, 3, and 4 are the counts being pled to. The state being all processing counts 1 and 6 through 15.
No, I think that plea form must say something wrong, Judge. Last time he pled to counts 2 through everything else. I know process count 1, which was the solicitation, since that was double jeopardy.
Okay, I'm sorry.
He was
It's
supposed to
counts
plead
4
it.
through 16. He's pleading to, so it's
He's pleading to 2 through 6.
12 counts.
Yeah, it's just count 1, which was the solicitation, that I was no processing.
Okay. Mr. Beltran, I want to clarify this, just so we're all on the same page.
Señor Beltrán, quiero aclarar algo para que todos estemos en la misma página.
The plea agreement was that you would enter pleas of guilty to count 2, traveling to meet a minor for unlawful sexual act, count 3, attempted lewd or lascivious battery, and counts 4 through 16, each of which charges you with transmission of material harmful to a minor. Is that your understanding?
Lo que quería aclararle es que usted entonces se declararía culpable al cargo 2, que sería donde la acusación es de viajar para encontrarse con un menor o una menor para cometer un acto sexual ilícito, y el cargo 3, que, I'm sorry, Your Honor, was charge 3 the attempted lewd and lascivious battery?
Yes.
El cargo 3, la tentativa de agresión deshonesta, y los cargos 4 al 16 son las acusaciones de transmitir material indecente o inapropiado para un menor. ¿Es lo que usted tiene entendido?
Sí, señor.
Yes, sir.
All right. Are you currently under the influence of any medication, other drugs, or alcohol?
¿Actualmente se encuentra usted bajo los efectos de alcohol, drogas o medicamentos?
No, señor.
No, sir.
Are you thinking clearly at this time?
¿Está pensando claramente el día de hoy?
Sí, señor.
Yes, sir.
Has any person coerced or forced you to enter the plea?
¿Hay alguna persona que lo ha obligado, presionado, coaccionado para que usted acepte esta oferta?
No, señor.
No, sir.
The recommendation is that you would be adjudicated guilty of each count to which you are pleading.
La recomendación es que se le asienta un fallo de culpabilidad en cada cargo al cual usted se está declarando.
That you be sentenced to 6 years in the Florida Department of Corrections as to count 2.
Y se le impondría una sentencia de cumplir 6 años en el Departamento de Correccionales relacionado al cargo 2.
And actually, with the score sheet as it is, it'd be 6 years as to each of the counts.
Okay.
running concurrent. So it'll be 6 years as to counts 2 through 16 to run concurrent. You'll be given credit for the time that you served, which unfolds 179 days in the county jail.
Y son 6 años, se le impone 6 años a cumplir a los cargos 2 al 16, pero se cumplirán simultáneamente y se le da crédito por el tiempo que ha cumplido en la cárcel del condado de 179 días.
Is that your understanding of the plea agreement?
¿Es lo que tiene entendido de lo que es el acuerdo declaratorio?
Sí, señor.
Yes, sir.
The court would also require that you pay fine, court costs, public defender lien, and application fee through the court's collection program. Do you understand?
Además, se le impone pagar las multas, costas, honorarios por los defensores públicos, la solicitud de un defensor público, todo a través de un plan de pagos de la Secretaría de Tribunal, ¿entiende?
Sí, señor.
Yes, sir.
Are you satisfied with your lawyer in this case?
¿Está usted conforme con la abogada?
Sí, señor.
Yes, sir.
Do you believe it is in your best interest to enter this plea?
¿Cree que lo que más le conviene es aceptar esa oferta?
Sí, señor.
Yes, sir.
You understand that if you are not a United States citizen, entering this plea will subject you to deportation.
¿Comprende que si no es ciudadano estadounidense, al aceptar esta oferta lo haría sujeto a ser deportado?
Sí, señor.
Yes, sir.
If you are sentenced to state prison at any time in Florida, and if you've ever been convicted of a sexually motivated or sexually violent crime, once you complete the prison sentence that the court imposes, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Además, si al usted cumplir con la sentencia que le ha impuesto el tribunal en el estado de la Florida, si en algún momento se le ha condenado por un delito de naturaleza sexual o sexualmente violento, al cumplir con esa sentencia que se le ha impuesto, se le podría recluir de una manera civilmente, como un depredador sexual violento al concluir la primera sentencia. ¿Entiende eso?
Sí, señor.
Yes, sir.
You have the right to have a jury trial, and if you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty unless a jury unanimously found the state had proven your guilt beyond reasonable doubt. Do you understand?
Usted tiene el derecho de llevar el caso a juicio y en el caso que llevar el caso a juicio, si es que lo llevará a juicio, se le presumiría inocente y no se podría determinar que usted es culpable a menos que un jurado creyera de una manera unánime que la fiscalía había probado su culpabilidad fuera y más allá de una duda razonable. ¿Entiende eso?
Sí, señor.
Yes, sir.
If you chose to go to trial, you would have the right to be represented throughout your trial by Ms. Smith, and you would have the right to confront and cross-examine witnesses who testified against you at your trial. Do you understand?
Si es que se llevara el caso a juicio, usted tendría el derecho a ser representado por la señora Smith y usted tendría el derecho a confrontar a los testigos que se presentaran a declarar en su contra. ¿Entiende eso?
Sí, señor.
Yes, sir.
You would have the right to present witnesses and evidence in your defense at trial, and you are entitled to have the court order any witnesses you have to be present so you could present their testimony to the jury. You understand?
Y en ese juicio usted tendría el derecho a presentar sus propios testigos, presentar sus propias pruebas y tendría el derecho de pedirle al tribunal, al juez, que le impusiera o le ordenara a esos testigos suyos a que se presentaran para hacer declaraciones a su favor ante un jurado. ¿Entiende eso?
Sí, señor.
Yes, sir.
You also have the right to testify yourself at the trial, or you could choose not to testify. If you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand?
En el juicio usted tendría el derecho a ya sea declarar o a guardar silencio. Si usted ejerciera su derecho a guardar silencio, tendría el derecho a que se le informe al jurado de que ellos no pueden tomar como una prueba de culpabilidad el que usted haya decidido guardar silencio en el juicio. ¿Entiende eso?
Sí, señor.
Yes, sir.
By entering a plea of guilty, you are giving up each one of the rights we've talked about, as well as the other rights on the written plea form, and there will not be a trial in your case. Do you understand?
Al declararse culpable, usted estaría renunciando a los derechos que le acabo de explicar, al igual que los derechos que se explican en el formulario declaratorio, y no se celebraría un juicio. ¿Entiende usted eso?
Sí, señor.
Yes, sir.
You also, by entering the plea, are waiving your right to appeal any matters at all relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Además, al declararse culpable, usted estaría renunciando a sus derechos apelatorios relacionados a este caso, con la excepción de el derecho de determinar de que este juzgado tiene la jurisdicción para tratar este caso y sobre la legalidad de la sentencia que le impongan. ¿Entiende eso?
Sí, señor.
Yes, sir.
All right. Mr. Beltran, I find that you are alert and intelligent, that you understand the nature of the charges against you as well as the penalties that you're facing.
Muy bien, señor Beltrán. Determino que usted está alerta, que es inteligente, que usted entiende la naturaleza de las acusaciones en su contra y de las sanciones a las que se está enfrentando también.
Sí, señor.
Yes, sir.
I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've told me you're satisfied.
Además, determinó que la decisión usted la ha tomado de una manera libre y voluntaria y que ha recibido el asesoramiento de una abogada capaz con la cual usted me ha dicho que está conforme.
Court previously found there's a factual basis upon which the plea can be accepted based on the arrest affidavit in the court file, and I reaffirm that finding.
Este juzgado había determinado ya o concluido anteriormente de que existía una base fáctica basado en el affidavit de arresto que se encuentra en el expediente y vuelvo a asentar o reafirmar esa opinión.
So I'll accept the plea of guilty.
Por lo tanto, acepto su declaración de culpable.
Ms. Smith, the state had earlier submitted a score sheet with 154.2 total sentence points. Is there any objection to that score sheet?
No, Judge, and we waive PSI still.
Is there anything further than from the defense as to sentence?
No, Judge.
And state you're recommending the downward departure sentence.
Yes, Your Honor.
Mr. Beltran, based upon the uncoerced plea agreement between yourself and the state, the court will impose a downward departure sentence.
Muy bien, señor Beltrán. Basado en el acuerdo declaratorio 5 acción a la que ha llegado entre usted, o se ha acordado entre usted y la Fiscalía, se va a hacer una rebaja de la pena mínima.
Will be a judge guilty of traveling to meet a minor for unlawful sexual act as charged in count 2.
Se le va a determinar culpable a la acusación número 2, que es viajar a encontrarse con un menor o una menor para cometer un acto sexual ilícito.
Attempted lewd or lascivious battery as charged in count 3.
Y tentativa de agresión sexual, agresión deshonesta, perdón, como la acusación número 3.
And transmission of material harmful to a minor as charged in counts 5 through 16.
Y por
4 through 16.
Y bajo los cargos 4 al 16, que es transmitir material indecente o inapropiado para un menor o una menor.
As to each of those counts, you'll be sentenced to 6 years in the Florida Department of Corrections with credit for 179 days that you've already served.
Así que se le impone una sentencia de 6 años en el Departamento Correccional, recibiendo crédito por 179 días que ha cumplido.
Those sentences will run concurrent with each other.
Y esta sentencia, que es para cada uno de esos casos, se cumplirá de una manera simultánea, uno con la otra.
You are required to pay court costs of $415 and a $100 cost of prosecution.
Se le impone pagar $415 de costas judiciales más $100 por las costas del enjuiciamiento.
be a fine of $500, a $100 public defender lien, and $50 public defender application fee.
Además, hay una multa de $500, también pagar honorarios de $100 por los servicios del defensor público y $50 por la solicitud.
All of that money is ordered to be paid at the rate of no less than $50 per month through the clerk's collection program.
Y eso lo va a pagar mensualmente, efectuando un pago mínimo de $50 a través del plan de pagos de la Secretaría de Tribunal.
The first payment will be due by March 1st of 2026.
March 1st,
2026.
26. Thank you. El primer pago tiene hasta el 1 de marzo del año 2026 para efectuarlo.
You have 30 days within which you can appeal the judgment and sentence was just entered. If you wish to, go ahead.
I'm sorry, Governor, go ahead.
If you wish to appeal and cannot afford to hire a lawyer, I will appoint one to represent you.
Usted tiene 30 días para apelar el fallo de la sentencia que le ha impuesto este tribunal. Si no puede contratar un abogado, yo le podría nombrar uno.
If you do not file an appeal in writing within 30 days, you waive your right to appeal.
Si no presenta dicha apelación por escrito dentro de 30 días, entonces renuncia a ese derecho apelatorio.
You understand, sir?
¿Entiende?
Sí, señor.
Yes, sir.
Is there anything further with respect to this case?
No, you're, well, I mean, count one, I'll no pros again, but I think I already filed that.
Thank you, sir. Good luck to you.
Muy bien, muchas gracias, señor. Buena suerte.
Gracias, señoría.
He is
Thank you.
designated as a sex offender. And Mr. Morales, we have one other matter, I believe, that requires your assistance, and that's an arraignment. Case 16 CF 3887, State versus David Balone de Jesus. Good morning, sir. If you'll please tell us your name.
Bueno,
David Bolone de Jesus.
All right. Mr. Balone de Jesus, you were placed on probation for grand theft in case 16 CF 3887.
Señor de Jesús, a usted se le puso un régimen de probatoria por hurto mayor en el número de causa 16F3887.
You've been accused of violating that probation.
Y ahora se le acusa de incumplir con ese régimen de probatoria.
It is alleged that you violated condition 1 by failing to report to the probation office on September 3rd of 2019 as directed.
Y se le acusa de incumplir con la condición número 1 de que usted no se presentó a la oficina del régimen de probatoria el 3 de septiembre del 2019.
It's alleged that you violated condition 3 by moving from your last approved residence on or about September 1st of 2019 without prior approval of your probation officer.
Y se le acusa de incumplir con la condición 3, que es de haberse mudado de la residencia que era la que estaba aprobada a otra residencia alrededor del 1 de septiembre del 2019 sin recibir autorización o aprobación primero.
It's alleged you violated condition 5 by committing the offense of resisting an officer without violence on or about February 22nd of 2020 in Marion County.
February 22nd, 2020 in
Marion County.
Marion County. Thank you, Judge. Y además se le acusa de incumplir con la condición número 5, que es de resistirse a un oficial sin violencia en el condado de Marion alrededor del 22 de febrero del 2020.
You understand what you've been accused of?
¿Entiende las acusaciones?
Sí.
Yes.
All right. Ms. Smith, your office has been approved in this.
We'll enter a plea of not guilty, Your Honor, or denial.
Mr. Balone de Jesus, I'll accept the denial of the violation. Your case is set for a violation of probation hearing on September the 24th with a status hearing on September the 22nd.
Muy bien, señor de Jesús, acepto entonces la negación a la acusación de haber incumplido con régimen de probatoria. Se le programa una vista el 24 de septiembre y una vista de seguimiento el 22 de septiembre.
A lawyer from the Office of the Public Defender will be in touch with you very shortly.
Y uno de los abogados de los defensores públicos se va a comunicar con usted pronto.
Thank you, sir.
Muy bien, gracias.
Thank you, Mr. Morales.
You're welcome, Your Honor. Thank you.
Okay, and unfortunately, I opened up this morning the wrong Teams meeting and skipped over the folks who are patiently waiting to join us and get a little bit of testimony before.
Yes, Your Honor.
All right, Mr. Phelps, you still there? Okay. As soon as they, Mr. Smith, you ready, Mr. Phelps?
Morning, Your Honor.
Morning. And how, is this going to be a hearing this morning?
Yes, sir.
Okay. Very well. Mr. Phelps, before we proceed, if you'll raise your right hand. You solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name, please.
James Phelps.
Okay. And we are here on a violation of probation hearing in case 15 CF 129. And David, you ready to proceed?
So I know the probation officer, I sent her the link and she said she was following it, so I'm hoping, it's Jane Johnson, I'm hoping that her face is appearing there for you. I sent her the one for the Jay, I sent a separate one for the 9 o'clock, or 9:30, I mean, for the hearing.
Let me see if I need to open that separately.
She said she was following it.
Okay.
I warned her she'd be waiting, so.
Yeah, it's set as a separate Teams meeting, so I'll pull that up. Okay, there. We have someone here. Good morning.
Good morning.
Who do we have on the line?
Probation officer, Sharmaine.
Okay, and we have someone else?
Sir, that might be Mr. Phelps.
Sharon Phelps. I saw her name, but I'm not hearing. There she is. Okay. Is this Ms. Phelps? Your microphone's off, Ms. Phelps.
Hello.
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 Good morning. Okay. As started, we are here in a violation probation hearing in case 15 CF 129, State of Florida versus James Phelps. Mr. Phelps is present via video link from the jail. Ms. Johnson, the probation officer, is present via Teams link. Ms. Phelps, the defendant's mother, is also present via Teams link. Ms. Adams and Mr. Smith are present in the courtroom. So, Ms. Adams, you may proceed.
Yes, Your Honor, the state would call the defendant as our first witness.
Okay, and he's been sworn, so you may proceed.
All right, sir, can you please tell me your name?
James Phelps.
And Mr. Phelps, are you the James Phelps that was placed on probation in this particular case?
Yes, ma'am.
When you were on probation, did you meet with your probation officer?
Yes, ma'am.
And did they instruct you on the terms and conditions of your probation?
Yes, ma'am.
Okay, including that you were not to use any illegal substances? Is that correct?
Yes, ma'am.
And that you were not to commit any new crimes? Is that right?
Yes.
Okay. Sir, on April 2nd of 2019, or actually I think maybe it was April 1st of 2019, did you meet with your probation officer on that date?
I couldn't begin to remember the date.
You remember like the last time that you met with your probation officer?
Yes, ma'am.
Okay. That last time you met with them, did they have you do a drug test?
Yes, ma'am.
Okay, and that was by asking you to provide a urine sample, is that right?
Yes.
Okay. And the urine sample that you provided was in fact your own urine, is that right?
Yes, ma'am.
Okay. And did they inform you that that sample tested positive for drugs?
Yes.
Okay. And in fact, that was MDMA and amphetamine, is that right?
Yes, ma'am.
Okay. You're aware that MDMA is an illegal drug, is that right?
Yes.
Okay. So obviously you don't have a prescription for it, is that right?
No, ma'am.
Okay, and the methamphetamine, that's also an illegal drug, is that right?
Yes, ma'am.
Okay, and you do not, of course, have a prescription for methamphetamine, do you?
No.
And sir, isn't it correct that those drugs showed up in your urine because you had in fact used them? Is that right?
Mr. Smith?
Sorry, you said that was a yes?
I think he didn't hear the question.
Oh, okay, sorry. With the mask, it's a little bit difficult. So I asked you if those drugs showed up in your urine because you in fact consumed those drugs previous to taking that drug test. Is that right?
Yes, ma'am.
Okay. Sir, were you then later arrested in Orange County for a theft offense?
Yes, ma'am.
Okay, and you pled to that offense, is that right?
Yes, I did.
Okay. And that was on, you pled to a petty theft, is that right?
Yes, ma'am.
Okay. I don't have any more questions, Your Honor.
All right, Mr. Smith, any questions?
I do, Your Honor. Should I be questioning from here or from?
You're fine there, just, you'll pull the microphone a little, maybe a little.
Yes, sir. May I proceed?
Yeah.
All right. Good morning, Mr. Phelps. Can you hear me?
Yes, sir.
I want to take you back to the period after you were released from the Department of Corrections.
Okay.
Did you obtain any employment?
Yes, sir.
Where were you working?
Shortly after I was released, I was building swimming pools for a pool company in Orlando.
And I'm going to ask if possible, perhaps it's just my advanced age, I'm having a little bit of a hard time hearing you. Is it possible you could get closer to the microphone?
Is that better?
Much better. Could you repeat your answer to the question about your employment?
Yes, sir. Shortly after I got released from prison, I was building swimming pools, operating heavy equipment.
What company were you working for?
Imperial Pools.
How much time elapsed between getting released and you getting that job?
About 7 days.
What were your specific duties and what was your job title when you first started off at that company?
Basically, operating a backhoe, laying out the area for the pool, meeting with customers, things like that.
How would you tell the court you were progressing at the job? Were things going well? Were you trusted by your supervisors? Were you getting promotions?
Absolutely. At the first job, the pool company, I got a promotion almost immediately, basically to the equipment operator and reading the blueprints and things like that.
At some point, there was an incident that took place at work where someone found out about your status as a convicted felon?
Actually, that was at Perry. That was at the following company. So I was at the pool company, and then I was able to get another job at Perry, and I believe that's the incident that you're talking about.
Correct. So before we get into the details of the incident, can you tell us what you were doing at Perry?
I was hired to basically be a carpenter, entry-level carpenter. I had switched jobs because of the available benefits, medical, and things like that for switching. So I was hired as a carpenter.
How long did you keep that job?
Only a couple of months.
What ended up happening at the job?
Shortly after I was hired, I was promoted to a team leader. I had about 8 guys under my command. Basically, was promoted from a carpenter to operating a crane, and basically just managing my team.
some point, did someone discover that you had a conviction?
Yes, sir. One of the guys on my team did.
Did you receive any harassment or threats at work?
Judge, at this point, I would object to relevance. I'm really not sure where this is going, and I let it go for a while, but
It's really not relevant unless the defendant is found guilty of violation, but I'll allow him to proceed.
Right. In Your Honor, I would say that I think it's relevant, at least on the issue of whether this is a willful and substantial violation. So, Mr. Phelps, what happened?
Basically, went into work one morning and someone had a paper with my picture and basically my charges and criminal history on it. They passed it around to my team, and after that, they were spray painting obscenities on my equipment and my projects. I found a bullet in my toolbox with my name on it. They spray painted child molester on my car. Pretty rough for a couple weeks.
And as a result of that, you no longer work there at that particular
No, I left about halfway through a particular workday. After I found the bullet in my toolbox, I left the company, basically just in the middle of the day, just walked out.
Your Honor, I have no further questions at this time.
Thank you. Any redirect?
no, Your Honor.
All right, thank you. State, you may call your next witness.
The state will call Charmaine Johnson, is on Your Honor's team link.
All right, Ms. Johnson, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I have to ask you to try to speak up if you can. I can hear you, but I don't know that the attorneys are able to very well. State your name.
Okay.
State-
Charmaine Johnson.
Okay. Ms. Adams.
Thank you, Your Honor. Good morning, Ms. Johnson. Judge, at this time, I'd ask Your Honor to take judicial notice of the affidavit for violation of probation that was submitted by Ms. Johnson.
Court will so notice.
Ms. Johnson, were you the defendant's probation officer in this case?
Can you say that again?
Were you the defendant's probation officer?
Yes.
Okay. Did you instruct him on the conditions of his probation?
Yes, I did.
Okay. On April 2nd of 2019, did you ask that he submit to a drug test?
Yes.
And when he did that, did you receive positive results for drugs in that test?
Can you repeat that?
Did the test come back positive for drugs?
Yes, it did.
Okay. Did you send that test to the lab in order to confirm those results?
Yes, I did.
Okay. And did you get back from the lab confirmed results positive for methamphetamine and MDMA?
Yes, I did.
Okay. And did you attach that to your affidavit?
Yes.
Judge, I have a copy of that I've marked with a clerk that I would seek to admit into evidence for purposes of this hearing. Can't really show it to the witness since she's online, but.
Objection, sir.
There being no objection, the exhibit, which is marked as Exhibit C for notification we received. It states Exhibit 1.
And Ms. Charmaine, when the drug test happened, did you ask the defendant why he was testing positive for drugs?
Yes, I did, but he continued to deny that he was using.
Did he tell you at first that he had a prescription?
Repeat that?
Did he tell you he had a prescription? Did he at first
Did he
tell
tell
you?
you that he had a prescription?
Yes, he did, but he would never provide the prescription to me.
Okay. Ma'am, to your knowledge, have you ever observed him to be appearing as if he was under the influence of a controlled substance? Sorry.
Did you hear the question?
No, I didn't. The phone went out.
And I'm sorry, sir, I can't hear her responses either. myself.
She didn't hear it. Ma'am, I asked if you ever observed him to be under the influence of a controlled substance. Did he ever look like he was high?
I didn't quite understand what she was saying.
Okay, Ms. Johnson, she asked if you ever observed Mr. Phelps appearing to be under the influence of a controlled substance.
Yes, I did. And I made a home visit.
And that was on April 10th of 2019?
Is that okay?
I don't have any other questions for the officer, Your Honor.
All right, Mr. Phelps, any questions?
Mr. Smith, I have no questions.
All right, thank you. Any additional evidence or testimony, state?
Judge, at this time, I would also seek to admit the arrest affidavit for the new law offense, which I've marked with the clerk, as well as the judgment and sentence showing the defendant's conviction for that offense.
I'd object to.
Sorry, he pled to the lesser.
I'd object to the arrest affidavit, Your Honor, just because my argument was that it contains an admissible hearsay. I think that the judgment and sentence are admissible, but the arrest affidavit has multiple.
I think the hearsay is admissible in this proceeding, although a finding of violation could not be based entirely on hearsay. So on that grounds, I'll overrule the objection. A and B will be received as State's Exhibits 2 and 3, respectively.
And that's it for the state, Your Honor.
All right, Mr. Smith, any evidence or testimony?
Your Honor, the only evidence that I have really is evidence that goes towards mitigation, extenuation.
Okay.
As far as the finding, nothing.
Fair enough. And any argument as to the finding?
No, sir.
Okay, well, based on the evidence presented, the court does find that the state has proved by the greater weight of the evidence that the defendant did willfully violate his probation by unlawfully consuming amphetamine or methamphetamine, as well as MDMA, I'm sorry, on or about April 1st of 2019, and further that he committed the offense of petty theft on or about April 12th of 2019. So the court will find that the defendant did willfully violate conditions 7 and 5 of the probation order as alleged in the probation violation affidavit. So, in the state, we have a score sheet.
Second approach.
All right, I've been given a score sheet with 241.2 total sentence points. Is there any legal objection to the score sheet?
No, Your Honor.
All right. Well, with respect to sentencing, are there any matters the defense wishes to offer or argue in litigation?
Yes, sir. That's why we have Ms. Phelps. Ms. Phelps, Sharon Phelps, as a witness.
Okay, Ms. Phelps, morning. If you'll raise your right hand, ma'am. If you could back away just a little bit from the camera, maybe. There we go, perfect. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, and good morning. If you'll please tell us your name.
Sharon Phelps.
Okay, and Mr. Smith has some questions for you first, and then the state will have a chance to ask you some questions if they wish. You may proceed.
Ms. Phelps, are you able to hear me?
Yes.
All right. I'm going to need you to please speak up so that the court can hear you.
Yes, I can hear you.
You please tell the court what your relationship is to James Phelps?
He is my son.
Do you recall, I want to take you back to the period when he was released from the Department of Corrections and he started working. Do you remember that time?
Yes, I do.
Would you tell the court, based upon what you observed, how your son was doing with regard to his employment?
I didn't understand you,
Mr. Smith asked if you could tell us how Mr. Phelps was doing with respect to his employment at that time.
He was doing really well when he was released from the Department of Corrections. He obtained a job very quickly. He was, he got a job and he acquired a vehicle. He was following all the rules and regulations of his probation. He was doing everything that, and he was very happy.
What type of support, financial or otherwise, was he providing you?
I didn't hear you.
What kind of support, financial or otherwise, was Mr. Phelps providing to you?
He was very supportive to me. He did what he could do for me. He had his own bills that he had to pay and whatnot, but he was always there if I needed him.
At some point, did you notice that he became depressed or withdrawn?
He started getting depressed at his job when at work there was an incident of a bullet that was found, and I noticed that he was depressed and he just wasn't himself. I didn't want to believe that he would be using drugs, but I then later on found out that he was, and it was really hard. It was hard for him because everywhere he went, he was labeled, and people didn't want to give him a break. I personally witnessed mustard wrote on the front of his hole with child molester when he went into McDonald's. He just gave up everywhere and everything that he tried to do. It went right back to his charges, and he gave up. He returned to drugs.
Ms. Phelps, we're at the stage of the hearing now where the court is taking testimony from you, and then the court will have to make a decision concerning a sentence. What is the most important thing you want the court to know about your son, and why do you believe that he should be given a second chance? And if he is given that second chance, that he'd be able to do the right thing and not violate his probation again?
I think I heard part of that statement.
Okay, well, let me try to paraphrase that. Mr. Smith will correct me if I miss it. Mr. Smith indicated that this is the stage of the proceedings where the court is hearing testimony and will be considering the sentence that is to be imposed in your son's case. And what, if anything else, did you want to say that would have bearing on that decision and whether the court should reinstate your son to probation or impose some other sentence? Is that fair?
Yes, sir. Thank you.
Thank you very much, sir. What I would like for my son is to have a chance at life again. Granted, what he did was wrong, but I'm not one to pass judgment because I never walked in his footsteps. I've never had to endure what he's had to endure. I want him to have a chance at a life so that he can be a productive citizen. He's a very talented young man, and I just wish that he had a chance to show the world his talents without relying on drugs. And I think if he just had a chance to do that without all of the labeling, that he could be a productive citizen, and he has a calling. He just needs a chance. That's all I want for him. I'm 71 and I would just like to see him have a chance at life.
Ms. Phelps, is there anything else? I don't have any other questions for you, but I want to make sure that you have a full opportunity to express yourself to the court. Is there anything else you want to tell the judge before I conclude my questions to you?
I couldn't understand you.
Essentially, Mr. Smith was asking if there was anything else you wish to say before the court makes a decision as to what sentence to impose.
I would just like to thank you for your time and the mercy that you might show my son.
Thank you, ma'am. Do you have any questions?
No, Your Honor.
Thank you. Any additional evidence or testimony, Mr. Smith?
Yes, sir, briefly. Mr. Phelps. Mr. Phelps?
Yes, sir.
You would like to be reinstated to probation. So what I'm going to do now is give you an opportunity to tell the court why you believe you deserve that chance and what your plans are to make certain that you don't have any future violations if you are reinstated.
Yes, sir. Basically, when I was released from prison, you know, I did really well for a long time. You know, I supported myself. I worked. I made a wrong decision by getting the new job at Perry. I thought it would be a good move, but there was too many politics involved. And you know, after that, I relapsed, and you know, I turned away from my family and got distant from them, and that was another nail in the coffin, you know, to why I'm here today. And I mean, if I'm reinstated to probation, you know, the things I'm going to do different is to stick with my family and, you know, not go back to those same people that, you know, in the past have drugged me down, and, you know, just work and try to get probation done with so that I can move on with my life.
We got into this briefly at the beginning, but I'd just like to expand on this, not take too much time, but how fearful were you when you saw that bullet that had been left for you at your workplace?
I was terrified. I left in the middle of the day. I couldn't tell my supervisor what was going on because they had blocked me from the office to walk that direction, so I had no choice but to walk to my car. You know, the things that led up to the bullet made me believe that there was, you know, some solidity to what they were actually threatening to do. So, yeah, it was pretty terrifying.
In conclusion, is there anything else that you want to mention to the court about why you believe you should be reinstated?
Just that mistakes that I made were not in disrespect to the court or, you know, the fact that I was entrusted to probation, because I assure you that no one could be more upset with the decisions that I made besides myself. So, you know, if I get another chance, I won't let the court down.
Thank you, Mr. Phelps. I have no further questions, Your Honor, and no other witnesses or evidence of mitigation.
Thank you. State any argument?
Yes, Your Honor, as far as argument, so, you know, the defendant obviously would be a violent felony offender of special concern based off of the charges that he was on probation for. And so it's the state's position that Your Honor sort of has to conduct a danger hearing, which I think we sort of did here, and that Your Honor would not be able to reinstate the defendant unless you found that he was not a danger to the community, which the state would argue that he certainly is, based off of the offense that he is on probation for. The defendant pled to some lesser included offenses. The facts of his convictions here involve him sexually abusing for years two of his sort of stepdaughters, essentially, girls who were between the ages of 8 and about 10, if I'm reading the affidavits correctly. Obviously, these are very, very serious offenses, and that's what we're here for sentencing on. The defendant received the benefit of a substantial, essentially very good sort of plea offer that the state entered into in order to protect these children from having to testify against him. He went to prison for about 3 years and then was placed on probation. He was released, at least from the records that probation has, from the Department of Corrections in July of 2018, and then he was violated. This violation occurred in April of 2019. So he was not on probation for very long. It looks like it was less than a year before he is before the court for violations of probation. The violations of probation include not only the defendant using at least 2 illicit substances, methamphetamine and MDMA, but also show him committing a new crime. The arrest affidavit that Your Honor has for the new law offense indicates the facts of that, which showed the defendant essentially running out of a Walgreens store with about $500 worth of merchandise. He did plead to the lesser included offense of petty theft on that. So it's the state's position that the defendant is a danger to the community. He's certainly a danger to these children, as was obviously apparent in his conviction. And he continues to be a danger to the community by not only the drug use, but the sort of theft pattern that perhaps precipitated from the drug use. I don't know. So the state's recommendation in this case is what I offered the defendant. I had offered him 15 years in the Department of Corrections to resolve the violation of probation. He does have credit, I think, for about 4 years at this point. And so that's what I'm asking that the court impose, is a sentence of 15 years in the Department of Corrections.
All right, thank you. Mr. Smith, argument?
Yes, sir. I think I'd like to start off first with the irony here, and that is a few years ago, the state of Florida, through another representative, stood before this court and for much more serious charges believed that a resolution of essentially 5 years was appropriate given the serious nature of the charges. And there's no doubt about the fact that those charges are serious. However, the court knows full well that there are many reasons why there's a negotiation and resolution. And frankly, the resolution in this case was not based solely upon the reasons offered by the state, but that's, I think, really beside the point. I point that out, though, to say that to me would be a terrible irony that for alleged sexual offenses, the state of Florida thought that a 5-year sentence was appropriate, and then for the illicit use of substances and the petty theft, that the state of Florida would believe that a sentence much longer than that would be appropriate. And I think that undercuts the whole notion, this idea that Mr. Phelps is a danger to society and thus is not worthy or eligible to be returned to probation. There's a very basic fact. No class of offenders in our society are given a tougher road to follow than people who are convicted of sex offenses. For understandable reasons, our society is very concerned, children and other people who might be potential victims. And yet on the one hand, we tell people that once they're released from the Department of Corrections, that they have to reintegrate into society, get a job, stay on the straight and narrow, get into trouble. But then we place a target on their backs through registration, publication, stigma, and the subtle promotion that they, and they alone, cannot get what any other offenders can get, and that is a true second chance. You've heard today the reason why Mr. Phelps, for several months, was a model probationer. He got 2 good jobs. You heard from him and his mother about how he was doing well. And then you heard at some point there was an issue with regard to the use of illicit substances, and then eventually a petty theft. If Mr. Phelps were here today, having been accused of perhaps prowling around a playground or maybe some bad contact with a child, then he would be that type of person that we'd be concerned about. He would be that type of person who we might say, you know what, he is a danger to children and thus needs to go back to prison. There's absolutely nothing in the new allegations that expresses any concern about the children, the victims, the first case, or any other children. When I say this, I don't mean to downplay any violation, but Mr. Phelps is sadly like the average person who ends up being on sex offender probation. He had a relapse. There was a brief period where he fell off the wagon, and I can tell you personally, in my meetings with him, he has said that, in essence, it was a blessing that he ended up getting arrested when he was, before he ended up somewhere perhaps dead from either an overdose or from a bullet. Think about his mother and what she said in terms of the support that he provided to her. Think about the fact that you have a man here who's simply asking for you to accept his sincere and honest apology for having a relapse. He's not a danger. He's a talented man with skills who, as a result of an unfortunate circumstance at work, fell back into drug use and then did what drug addicts do: take things to get money to buy the drugs. It's for all of those reasons I would ask that the court find he's not a danger and reinstate him to probation.
Thank you. All right. Well, this is a somewhat difficult case. Mr. Phelps, you were on probation for 2 offenses, which carry a maximum sentence of 45 years state prison. And since you do qualify as a violent felony offender of special concern, the court is required to consider the factors for Section 948.06 in determining whether or not you pose a danger to the community. The Criminal Punishment Code score sheet calls for a lowest permissible sentence of 159.9 months in state prison. Of course, the maximum, as indicated, is 45 years. The court, if it does find that you do not pose a danger to the community, has the ability to reinstate to probation without it constituting a downward departure sentence. A reinstatement would not require the findings that are necessary for a downward departure sentence. I note initially the downward departure was based on the uncoerced plea agreement between yourself and the state of Florida. I clearly recall this case. I clearly recall the testimony of the 2 victims in this case at the child hearsay hearing. And I know there are a number of reasons why the state and defense may reach an agreement in a case. Sometimes it has to do with the quality of the proof or the quantity of the evidence. Sometimes it has to do with trying to avoid further victimizing the victims of a crime by requiring them to live through some very intimate, embarrassing, and uncomfortable details before a courtroom of strangers, particularly children of relatively young ages. These children were a little older at the time that their testimony would have been given, but they were still young women. And I do understand, as Mr. Smith pretty eloquently argued, how difficult sex offender probation is. It's one of the most difficult situations a defendant in a criminal case can be placed in, returning to the community, the registration requirements, other restrictions of sex offender probation and sex offender sexual predator designation is very difficult. And when that designation becomes known, it can be very hard to maintain employment. It can cause a lot of setbacks. It can cause a lot of animosity towards the defendant from other members of the community. And that does make it tough. I understand that. In this particular case, the nature of the violations is not such that would require by themselves a finding of danger to the community. And we have a fallback into drug usage, perhaps due to the depression or other reasons. We have the theft in Orange County, which was basically taking some merchandise from, I believe, Walgreens and running out of the store with it, neither of which is a crime of particular danger. Still, that's serious conduct while one's on probation, particularly for charges as serious as these. I have significant question as to your amenability to non-incarcerative sanctions, that is probation or community control, in that it apparently was, at least thus far, difficult for you to handle that. Again, perhaps given the nature of the charge and the weight that that placed on you with respect to the actions of those in the community towards you. The weight of the evidence in this case is strong. It makes clear cut. There was a plea to the charged new law violation and admission to the drug usage. I do consider that you do have strong family support. Your mother is very supportive and could be a source of strength for you if you were back on probation. The court also considers that due to the nature of the underlying offenses themselves and the it does give some indication of danger to the community, although there's been no allegation that you've committed any similar offense since your release from the Department of Corrections. Taking all those factors into consideration, I don't feel that the maximum sentence of 45 years is appropriate. But I don't feel that reinstatement probation is appropriate either. At this time, Mr. Phelps, I'm going to revoke and terminate your probation. You'll be sentenced to the lowest permissible sentence under the Criminal Punishment Code score sheet for your crimes. That'll be 159.9 months in the Florida Department of Corrections. You'll be given credit for all time served since your arrest on the violation of probation, which is 453 days, plus all time previously served within the Department of Corrections and the county jail prior to being sentenced to prison. The financial obligations which were previously imposed, which total $1,237.26, are ordered to be paid through the clerk's collection program at the rate of no less than $50 every month, beginning with the fourth month following your release from the Department of Corrections. You do have 30 days within which you can appeal the judgment and sentence which just entered in your case. If you wish to appeal and you cannot afford to hire a lawyer to represent you, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
Very well. Good luck to you. Thank you. Thank you, Ms. Phelps. Sorry.
All right, just give me a few minutes. I'll have the other group up here.
All right, very well.
Thank you.
Thank you, Mr. Smith. All right, we'll be recessed for about 5 minutes while they're bringing up the next group.
Bottom line. Per Florida statute, Title 38.06, defendant qualifies as a danger. Yeah. Miss Adams? Yes, ma'am? Yes. Just one, because there were two.
Oh, yes. There you go.
Thank you.
Thank you. Any other questions for me at all? Or anything? And then you get all, you're entitled to all that. So, all of that needs done until he's in custody. And then if he was in prison, the Department of Corrections got raised out and Brace. And where you guys? Serena. I went to Barry. I've been a PE for almost 3 years now. I started here in Osceola in October. And I've been working in yeah, it's like the next county down right from me.
that both are becoming more upset, and, like my client who was incompetent, I probably wouldn't have been able to get somebody to see him, the doctor to come and evaluate him in time. Like, was doing, if I didn't, just get that already done during the last month, which is when I got it done, like, I think, beginning of June or something, so. It would have been really difficult, because he's the kind of client, he won't, I'm surprised they got him out, because he wouldn't come to, he took an isolation in the jail, and his phone rule was being away from everybody, and in order to go see him, he won't come to the door, and he won't come out, so for them to get him out was crazy, I guess. And so as far as the evaluations that we do with psychiatrists, we've been doing them over video that we haven't seen them yet. So we have that video conferencing. If I had to do a video conference with him, it wouldn't have happened. So it was really good that we were able to do it before we jumped out.
So how does that work with this,
No, so he's gonna go to the state hospital until he gets back to So we're just right now, once we get that. And then see if there's other medications that we get or whatever. He's gonna be brought back. And right now, I don't even know if the area really is. It just depends. No. Right. It's just depending on the so confident to do it, so we could be one day we could and this is in general, I'm seeing confidence situation. And so you never know. These are interns. Oh, okay. This is Cherish. She's
Sorry, Cherish.
Yeah.
Are you guys doing the complete, like, video of this patient's now?
I'm sorry?
Are you doing like video?
All right, Ms. Cronk, are you still with us?
Yeah, I'm here.
Okay. Sorry for the delay. We're waiting on the second group to be brought up, so.
No problem.
Sorry?
Thank you for your patience with the technical fun times of having people here. I've never done that, like me being here and them there. You can't hear them at all, like at all. It's terrible.
Yeah, we need to get with Navajo and try to work out a way to amplify the speaker from the.
Right. Like in my head, I mean, it makes sense because we have the jail feed. So like in my head, it was up on the screen and like everybody could see each other and I could like show the lady an affidavit and be like, this is what I'm talking about. And then I was like, oh, no, I can't do that. So good thing she attached that to her.
Actually, Mr. Baird, we had a hearing, and he was present, but he joined via Teams, and we used that cart there, and he was able to play videos and other evidence. So the defense attorneys in that hearing were on Teams at another location, and so they were able to see what he was presenting.
Oh, okay. So I was
Screen.
afraid. Okay, so I should have joined Teams then. I was afraid that if I joined it in here, that it would echo because we'd have like two of us on.
We've ran into some of that.
Yeah.
Yeah,
Anytime I've been in like that, it echoes and it's bad. Like it's usually like this infinity echo. But that's why I didn't.
I guess kind of complicated when we got multiple, we got phone, we got Teams, we got video feed. Particularly when we have the interpreter involved on top of that.
Oh God, it's like too much. It's one thing if we're all on Teams, it's much easier actually. Because then it's like one platform and we're all. It's hard to admit things, but
It works well except for the
inmate.
inmate. That makes it difficult for them.
Yeah, that's true, and that's not.
And I've been working on getting a computer that we could place there so they could be on Teams.
Good. Okay, I was gonna ask about that.
In fact, Crystal Allen was going to look into that as well. She was going to talk to Allison Chapman, I think, out of the jail.
Okay, cool. Yeah,
We would have to have the jail folks just open the Teams meeting for them, but once they did that, it's hands-free.
Then we could have Teams up on the screen and everyone's on it. It'd be nice. Huh. I like that.
Or even if we're all on our own little small screen, we could all see everybody. But the good thing, it would be the inmates then could see what's happening, because that hearing we did, they played a video. It was a bond hearing.
Right. And
I could see it here, I could see it on the cart, but the defendant, I don't know what we have Ms. Sullivan?
I have Ms. Sullivan and Gainey, sir.
Okay, well, let's go ahead and proceed with Amy Sullivan first. All right, good morning. If you'll tell us your name, please.
Amy Sullivan.
Ms. Sullivan, you're present this morning for arraignment in case 20 CF 1865. You've been charged in this case with petty theft with 2 prior theft convictions. That charge is a third-degree felony, which is punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand what the charge is?
Yes, I do.
Okay. Ms. Cronk, is this yours, or?
Yeah, Your Honor, it'll be a not guilty. I filed a motion to transfer on Friday. She
I
has
see
several
that.
other cases.
Okay.
So I don't know if you want to address that.
All right, and I don't know if you could hear Ms. Cronk. She's appearing by video. Ms. Sullivan, she has entered a plea of not guilty on your behalf. She's also filed a motion to transfer this case to Division 301, so all your cases will be in front of Judge Karsten. I'm going to grant that motion, and we'll set it for trial during the trial period, which will begin on September 14th before Judge Karsten. Pre-trial will be September the 2nd.
Okay. I've already been.
It's actually 201, so
Yeah, that's what I was-
I've got the wrong division. Just a moment.
She does have 3 cases that are set for jury trial on August 3rd. We can set it for status with that date.
We'll set this case for status on August 3rd when your other cases are set for trial before Judge Karsten.
Okay.
All right?
Thank you.
Thank you. All right, then let's proceed with Mr. Gainey. Mr. Gainey is here in cases 20 CF 1929 and 20 CF 1934. And these are your cases, Ms. Cron?
Yeah, I think what we're addressing though today, is 19 CF 4271. From what I'm told from the attorney at IA's, is that the bond was revoked on that case and he has a funeral this week.
All right, morning, Mr. Gainey. If you'll raise your right hand, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
State your name, sir. All right, Mr. Gainey, okay, you were arrested in case 19 CF 4271. The state has filed an information. Was it 4271?
That's the old case that the bond was revoked on.
Okay. We have
2 new cases.
19 CF 1929, which also Judge Karsten set for today. Very status.
He has bond on the 2 new ones. I believe the issue, like I said, it was another attorney that covered IAs that day was the one that told me about this, is that the bond was revoked on the 19 CF
Right.
4271.
No, I'm just looking, Judge Carson went ahead and set them all for today, I believe. 19 CF, excuse me, 20 CF 1929. He has a bond of $1,000 as to each count. So that's a total of 11,000 in case 19 CF 1934. He has a bond of total of $3,000. Actually, total of $2,500. He found no probable cause on the criminal mischief. So he's released on recognizance as to that count. So what you are concerned with is 19 CF 4271, which he was out on bond for, and in which the bond was revoked and discharged based on the new arrest.
That's correct, Your Honor.
Okay. Take a look at that.
What charge was that, Your Honor?
Sorry?
What charge?
What charge?
Yep.
The old case was 3 counts of false registration by a sexual offender.
And then I went down there, after I got released, I went down there and gave everything, all my information.
Okay, well, we're not there, Mr. Gainey. I understand what you're.
I'm basically being harassed about my uncle's vehicles. I had no, it's not in my name. He wanted me to get the registration to the vehicles. Now you're on diversion and kicking me out. I got to find somewhere to stay.
All right. Is there any evidence or testimony you wish to present, or just argument, Ms. Cronk?
I haven't really been able to speak with him since he just was arrested, and they just had initial appearances. I do believe, and he can correct me if I'm wrong, there is a funeral he's trying to attend this weekend. Other than that, I mean, he has no violent offenses. There's never been an issue with him not coming to court. He's always in contact with me more than a lot of my clients, so I know he's good at keeping in contact, and I don't have any concerns about him not appearing.
I do all my court days. I show everything. I register every 6 months, everything. It's just about these vehicles.
Mr. Gainey, it seems like we had trouble in the past getting you here, but that's,
Sir?
I seem to recall some trouble in the past getting you here, but let me see. State any position?
Yes, Your Honor. I do have witnesses here, Detective Kiefer. I did want to let Your Honor know, it's my understanding from speaking with the detective that defendant currently has a pending case in Georgia involving an accusation that he sexually assaulted his daughter.
That case about to be dismissed.
Excuse me, Mr. Gainey, one at a time.
Yes,
Okay,
sir.
thank you. I'll let you say whatever you want, but, okay, go ahead.
But it's my understanding, Judge, that he does have that case pending in Georgia. Obviously, that is a very serious case. So, we are concerned that he is a flight risk. And then looking at the facts here, he had the failure to register that he was out on bond on. While he was out on bond on that, he picked up another one, as well as a drug charge. And the detective had some additional concerns based off of her review of the jail calls that I wanted to let Your Honor know about. So if I can call Detective Kiefer.
You want to call your witness?
Do you want her at the podium or at the?
The podium's fine. Morning.
Good morning, Your Honor. Do you solemnly swear or affirm the testimony you're about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Detective Kiefer.
You'll state your name, please.
Detective Michelle Kiefer, Osceola County Sheriff's Office.
Thank you. Go ahead.
Sorry, Judge, I'm so used to Detective Kiefer testifying. Detective, are you one of the detectives who's been investigating the defendant in this case?
I am.
Okay. Have you had a chance to review his jail calls?
Not all of them, there's quite a few, but I listened to one on July 10th.
And did that call from July 10th give you any concerns that you want to let the court know about?
It did. In the past, we've had trouble. In fact, I have never been able to verify him at his permanent residence. For whatever reason, it could be our fault, it could be his. He said it's misconnections or whatever, but when he was talking to a lady on the jail calls, he said, "Hey, can I use your mom's address?"
To find me a new address, because my uncle doesn't want me there anymore. Because it seems like y'all coming there 6 times a week. In 1 week, he doesn't want me anymore. He's tired of being arrested, that y'all threatening to arrest him. He doesn't want me there anymore. So I asked her, can I use her mom's address for a living space? And I know she's out of school. She's out of school zone area. That's the only thing I asked her.
Detective, did the call indicate that he was legitimately living at the address of this young lady's mother, or that was sort of a decoy address?
The words he said was, "Can I use her address?" Not, "Can I stay with her for a while?"
That's basically what I'm asking. Can I use
Your
her
Honor?
to stay with her?
May I address Mr. Gainey? Mr. Gainey, my name is Zarina Hernandez. I am an attorney with the Public Defender's Office. I am a colleague of your attorneys, Kristen Cronk. We would like for you to please stop talking about the facts of your case.
Okay.
Ms. Cronk is present via video, and I'm also in the courtroom right now. Thank you.
All right, thank you.
Detective, did the caller indicate that he had permission to stay at that address, or the lady he was calling?
The caller said, "Yeah, you can use my mom's address."
Okay. As far as for the registration documents, is that what he was talking about?
Exactly.
Okay.
I don't know if his intentions are to stay there, but based on the past history, of not being able to verify him at that address through my numerous attempts and other people's attempts, it raises concerns for me.
And Detective Kiefer, was there any other concern that you had as far as him getting a bond that you wanted to let the court know about that I hadn't told him? Just want to make sure I covered everything.
Not specifically. I just know that he's out on 2 bonds already.
And that case pending in Georgia, I think you're the one who told me about that, right?
That's correct.
I don't have any more questions, Your Honor.
Well, there's a case pending in Georgia. Is there a hold on him for that?
I don't know. We were trying to look at that. I'd asked Detective Kiefer to look up the warrant. Were you able to see the warrant in the system?
He was arrested in Osceola County on the warrant from Dublin County, Georgia, and it looks like he was extradited and then released. I'm not sure the conditions of the release up there.
Okay.
So, yeah, it sounds like he's kind of on a bond or something. I don't know what their things are.
All right. Thank you. Any questions, Ms. Cronk? Or?
No, Your Honor.
Okay. Thank you. Any additional evidence or testimony stated?
No, Your Honor.
Now, Ms. Cronk, this is indicated that there's a family emergency. I haven't seen any written motion, so I don't know what the nature of or what the situation is.
Right, from what I was told from the other attorney on Friday was that there's a funeral for his sister this week that he's wishing to attend.
Okay, Mr. Gainey, when is the funeral?
This weekend.
I'm sorry?
This weekend.
This coming weekend?
Yes, sir.
Okay. I'm sorry to hear of your loss.
My mom just passed, my sister just got killed, man. I follow all the rules. I don't buck. I come to all my court dates and everything. I went down to the sheriff's office registering. I do it every 6 months. When I got released last time, I went down there and gave them my email and everything. It's all about a car registration. And every time they come, they say that every time they come, I'm not there. But
all right,
so I'm on probation or something.
Well, it's not exactly just that, Mr. Gainey.
Sir?
I said it's not exactly just that. You also have some other new charges, and you're out on bond. You've been arrested for multiple felonies since being released.
Sir? You say multiple felonies?
Yes, sir. And you've got a pretty extensive history. You got the offense that you went most recently to prison for, but before that you had 4, 5, 6, 7, 8, 9, 10, 11 prior felony convictions, including fleeing or attempting to elude law enforcement officer, multiple violations of probation. Ms. Cronk, I would consider authorizing him to be taken to the funeral. I certainly don't want him to miss his sister's funeral if that's happening this weekend. If he can make arrangements with the sheriff's department to have them escort him to the funeral. I'm not going to set bond at this time. So he can make arrangements with the sheriff's department. That's been done in the past, where he can arrange to pay for the cost of the guards to travel with him to the funeral and back. But the motion will be denied at this time. Thank you.
Thank you, Your Honor.
Thank you, Mr. Gainey. Your lawyer will be in touch with you. You'll be able to make the funeral if you want to, but you're not going to be released at this time. Thank you.
So when is my next court date?
Well, you have.
With us, he has a case with us, August 12th pretrial.
Okay, you have a pretrial on August 12th on the case you have in this division.
I can't hear anything.
Your pretrial is August 12th.
Yes, sir.
Thank you.
So I'm being denied a bond?
Yes, sir. Yep. Thank you. All right, I think that's all we have then until 2 o'clock.
Ms. Crump available?
I'm sorry?
Ms. Crump, she's there?
Ms. Cronk is here. She can call you and speak to you. You probably, it's not best to have an attorney-client conference.
Are these the same charges?
Mr. Gainey?
I don't understand right now. Are these the same charges?
Mr. Gainey, Ms. Cronk will set an appointment to come see you by video, and you guys can discuss your case, what your charges are and all that, and what maybe possibly how to make the arrangements.
Recess. Appreciate it, folks.
I've sent her a message.
There we go. Afternoon, Ms. Merced.
Good afternoon, Your Honor. My apologies.
Okay. All right, good afternoon, everyone. We're here for first appearances today. Just as a blanket announcement, my understanding is that we're currently appointing the public defenders on all cases. If you want the public defender to remain on your case, you will need to subsequently fill out an application, I do believe, and submit it for review to the clerk's office. That's my understanding. In each case, I've already reviewed the case. Unless I specifically say otherwise, I found probable cause for each of the charges, and then we'll address bond and/or other conditions of release. One case that I want to address is Diego Batista. My understanding is that Mr. Batista is currently not being brought to the courtroom because he appears to be positive for coronavirus. Madam Public Defender, under the circumstances, are you willing to waive his appearance at first appearance so that we can set conditions?
Yes, Your Honor, I would be willing to waive his appearance.
All right. He was arrested for the offense of battery, an act of domestic violence. I do find probable cause for that offense. If I understand correctly, he does not qualify for straight pretrial release, but he could qualify for bond and pretrial release. Is that correct?
That's correct, Judge.
All right. I do find probable cause. I'll set bond in the amount of $1,000. I'll order he post bond that he also release the pretrial release program with the following conditions. Number one, he have weekly check-in with pretrial release in whatever format they tell him to, whether it's phone, email, whatever it might be. Number two, that he have no contact with the identified victim. Number three, he maintain a separate residence while the case is pending. Number four, he can return one time in the company of law enforcement to recover whatever personal items he needs while the case is pending. Number five, do not possess or consume any alcohol. Number six, be subject to random testing to see if he has consumed alcohol. Number seven, possess no weapons, ammunition, or firearms while on pretrial release. That is the order of the court in regards to Mr. Batista.
Next court date is still in jail, July 23rd. If out, August 11th in courtroom 5B at 8:30 a.m.
All right, next I have Donald DeLong.
PD approved.
Afternoon, sir. Tell me your name. Mr. DeLong, you've been arrested for two offenses. The first is possession of a controlled substance, to wit, synthetic cannabinoids. And count two is possession of drug paraphernalia. I have paperwork here that indicates that they could not complete your pretrial release assessment because you weren't cooperating with them. Do you want to be considered for pretrial release, or do you want me to just set bond in your case?
Yes, for pretrial, I don't even know when that was. They said I was denying.
All right. So here's what we'll do. Your bond on count one was set at $1,000. Your bond on count two is set at $500. I'm going to stay those bond amounts. However, if the defendant qualifies for straight pretrial release, then he can release through the pretrial release program and not have to post bond. That's, do we have a date for Mr. DeLong?
Next court date on demand.
All right. You're welcome. Either or, yes. Next, I have Ali Fahad Syed.
PD approved, and the victim is outside, Your Honor.
All right. Sir, tell me your name.
Ali Muhammad Fahad Syed.
All right, sir, you've been arrested for the offense of battery and active domestic violence. I do find probable cause for that offense. My understanding is the identified victim is here. I'm going to take some testimony from her, and then I'll tell you what your conditions of release are, all right? Sir, here's the one thing I want to caution you about. First appearance is for me to tell you what the charge is, set conditions of release. It's not the day to try the case. The public defender's been appointed to represent you. You can talk to them about what did or didn't happen, and they can give you advice on how to proceed, okay? Let's go ahead and swear in.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I didn't understand exactly. Can you tell me the one more time?
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
All right, you can put your hand down. You can put your hand down. All right, ma'am, tell me your name.
My name is Shukriya. First name is Shukriya, last name Chaudhuri.
And how are you connected or related to the defendant, Mr. Fahad Syed?
He's my husband.
All right. Ma'am, I explained to him a moment ago that what we're here today for is something called first appearance. The only thing I need to do today is tell him why he's been arrested, tell him that I found probable cause for that offense, and tell him what his conditions of release are. Today is not the day to try the case, for me to hear from witnesses, to take evidence, or make any decisions about the case other than what I explained. Do you understand me so far?
I have my cell phone with me.
Okay, I'm sorry?
You asked for my cell phone?
No. Do you understand me so
Yeah,
far?
I understand.
Okay,
Just
all right.
Slowly, then I can understand more.
All right, sorry about that.
No problem.
So, normally, in a case like this, I would order the defendant to not have any contact with the victim. Do you understand that's what I would normally order?
Yeah.
Are you telling me, do you want me to do anything different than ordering him to have no contact?
I really don't want to do these things because I have the small kids, the 2 years, and then 4 years, and 5 years. I don't want anything for like the mental pressure for my kids because they love my husband, and I was mad too, and I did just make the story, I get mad, and he never did it with me. Honestly, I was with him almost 12 years, and never been problem like that. He never did it anything wrong with me, but I was mad, and then, with the aggro, and then I was really mad, and then I called the police, but this is not like that exactly true, but I don't want to do anything wrong with my kids. They love my husband,
All right, so ma'am, here's what I'm trying to figure out. Are you telling me that if I allowed him to come back to your house, are you afraid that more violence would happen?
No.
And do you want him to return to the house?
Yes, of course.
And understanding that I have the authority to order him not to come back, you're telling me you want him to come back?
Yes, of course.
All right. And if there were problems in the future and you were in fear, would you call the police again?
If like the trouble, then of course I will call, but hopefully, but I'm not, because he never did it with me last 10 years, nothing.
All right. Ms. Merced, do you want to ask any questions?
I just want to clarify, you said this has never happened before?
No.
And your children were present when this happened?
No, they were in the upstairs, my kids. And he was holding me in the room because he didn't want to hear my kids. And then, they are not here. The kids was on the upstairs. This time they were screaming in the upstairs.
I know there are also other individuals living in the home. Has there ever been any violence between the defendant and any of those individuals?
No.
And are you afraid of the defendant?
No. Is my mom there with me?
No other questions, Your Honor.
Madam Public Defender, any questions?
No questions, Your Honor.
All right. Thank you, ma'am.
Cool.
All right, Mr. Fahad Syed, here's what I'm going to order. I do find probable cause for the offense. I'm going to set your bond at $500, and I'm going to order that if you post that bond, you release through the pretrial release program with the following conditions. Number one, you'll have weekly check-in with the pretrial release office. Number 2, I'm going to order that you have no hostile or violent contact with your wife. That means no yelling, no screaming, no pushing, no shoving, no grabbing her by the arm to make your point, no threatening. Number 3, I'll order that you not possess any weapons, firearms, or ammunition while this case is pending. Sir, you need to think very carefully. If there's an incident and the police come and they believe, based on what they've heard, that hostile or violent contact has taken place, they are going to arrest you and take you back to the Osceola County Jail. If I determine that you've violated your pretrial release, you may not be getting back out until your case is over. So my free advice is, if there's a stressful situation, if there's a problem, take a breath, take a walk, find somewhere else to be. Otherwise, you run the risk of being back here. Do you understand?
Yes, sir.
All right. That is the order of the court. Do we have a court date for Mr. Fahad Syed?
Next court date is still in jail, July 23rd. If filed, August 11th in courtroom 5B at 8:30 a.m.
All right. All right, ma'am, that's the end of his case. At this point, you're welcome to go.
Then what I should have to do right now?
Well, he has to post a bond. You can contact a bondsman if you're going to be involved in that process, okay? All right.
And how he gonna bond? What, I have to do something?
Ma'am, I can't give you legal advice on the next step. Again, he has to post a bond to get out. You probably can talk to the clerk's office. They can tell you the things that you can do, and or you might want to contact a bondsman to assist you, okay?
Thank you.
You're welcome. Next, I have Miguel Garcia.
PD approved.
All right, sir, tell me your name. All right, we have 2 matters to discuss this afternoon, Mr. Garcia. The first is your arrest for violation of pretrial release conditions on a domestic violence case. I do find probable cause for that offense. I'm going to set your bond in the amount of $5,000. I'll order, if you post that bond, that you have no contact whatsoever with the identified victim in the underlying case, Jessica Johnson. I'm going to order that you maintain a separate residence. I'm going to order that you not possess any weapons, firearms, ammunition while you're on bond on that case. This, do we have a court date for that case?
Yes, for 2020, MM 1652. Next court date is still in jail, July 23rd. If filed, August 11th in courtroom 5B at 8:30 a.m.
Now, here's your second matter, sir. You were out on release in Osceola case 20 CF 955, which is in front of Judge Morgan. I find probable cause to believe that you violated your release in that case. I'm going to revoke your release, forfeit any bond, and order that you be held on a no bond status pending disposition of that case. And he probably already has court dates. Do we happen to know what his next court date is?
Let me check, Judge. For 2020, CF 955, next court date, August 12th, in courtroom 5F at 8:30 a.m.
All right. Next, I have Carlos Gardner.
PD approved.
Tell me your name, sir. All right, Ms. Gardner, you have 2 matters as well. The first is your new arrest for trespassing. I do find probable cause for that offense. I'll stay your bond in that case at $250. The second matter is, when this incident took place, you were already out on pretrial release in case number 20MM643 in front of Judge Epperson. In that case, I'm going to revoke your pretrial release at this point in time. At this point in time, I'll leave you on a no bond status until you can go in front of Judge Epperson, and he can determine what conditions of bond or release are appropriate in your case. Do we have court dates for his new arrest case?
Next court date for 2020, MM 1654, if still in jail, July 23rd. If out, August 11th, in courtroom 5B at 8:30 a.m.
All right. Next, I have Andre Glenn.
PD approved.
All right, sir, tell me your name. All right, sir, you have, make sure I'm doing this right. Says you have 2 cases. Okay. So all of your charges, with the exception of one, are on case number 20 CF 1944. In that case, as to count 1, you're charged with corrupting or threatening a public servant. Ms. Merced, I've reviewed the affidavit in that case, and there's a passing comment that the defendant made threats to the troopers, but there's no context as to what the threats were. Were they related to the performance of their duty? It just says he made threats. So I don't find probable cause in the affidavit for count 1. Are you going to ask for additional time to get a supplemental on count 1?
I'm just looking, Your Honor. Yes, if I could. I thought there was something in the affidavit that noted what the threat was referring to, but I note now that he's just talking about how he was combative and wouldn't allow them to tow the vehicle and then threatened to sue. But yes, if we could have additional time to provide a supplemental report on that count 1.
Right, and then there's a later comment about making threats. I'm not sure, I'm not sure threatening potential legal action would really fall in the gambit of what's considered a threat. So there could be some constitutional issues with that. So I'm going to say no PC on count 1. I'm sorry, do you want 24 hours to get a supplemental?
Yes, Your Honor, please.
All right. Count 2, I do find probable cause for resisting officer with violence. I'll set bond at $2,500. On count 3, I find probable cause for battery on a law enforcement officer. I'll set bond at $1,000. Count 4, I find probable cause for battery on a law enforcement officer. I'll set bond at $1,000. And then in 20 CT 1710, you're charged with operating a motor vehicle without a valid driver's license. I find probable cause for that, and I'll set your bond at $2,500. I'll order that Mr. Glenn be held for until a reset for tomorrow's first appearances to see if the state can establish a probable cause on count 1. That is the order of the court in regards to Mr. Glenn.
Are you going to stay the bond for count 1?
Well, I find no probable cause on count 1 at this point in time. So I'm giving the state 24 hours to correct that if they are capable.
You are ordering for the defendant to be held in the jail, or can he bond out?
Well, Madam Public Defender?
Well, we would object to the 24-hour stay first, as it's not there's no clear evidence that this is,
Let me ask the question this way. If he wants to, I can leave the bond that was set on count 1, which I believe is $2,000. And then it's up to him. If he chooses not to post bond because he wants to be ROR'd on that count tomorrow, then I'll address his case tomorrow. If he'd rather just post bond and deal with it down the road.
I'm not aware that he'll be able, well, I'd like to give him the option to post bond.
All right, so Mr. Glenn, come back up for a second. Sir, the way that the affidavit was written by the troopers, I don't know that there's sufficient evidence on count 1, but I've set bond on all your other counts. I'm going to set bond in the amount of $2,000 on count 1. However, if you don't post your bond, I'll bring you back tomorrow, and if the state can't give me additional information, then on count 1, I'll simply release you on your own recognizance. You understand? So it's up to you. If you post the bond because you want to get out of the jail, that's fine. If you would like me to make that determination tomorrow, then don't post the bond, and I'll see you tomorrow afternoon. I don't believe you're going to qualify for pretrial release based on...
He has a warrant out of Georgia.
Well, sir, they're saying you've got a warrant out of Georgia, so this may all get complicated anyways. I don't know what impact that's going to have on whether you bond or not. So, all right, if you post bond and Georgia doesn't put a detainer on you, then,
There's no extradition, Judge.
okay. All right, Georgia's not going to extradite, so.
What is my total bond, sir?
The clerk's going to calculate it. I handed her the paperwork already. Your total bond is $9,000 at this point. If you don't post that bond, I'll see you back tomorrow afternoon to address count 1. All right? Okay.
Next court date for 2020, CT 1710 of still in jail, July 23rd, if filed August 11th, in quorum 5B at 8:30 a.m. And for 2020, CF 1944 on demand.
All right. Next, I have Macario Rincon.
PD approved.
Your Honor, we would ask that you waive the reading of the charges today.
Okay. Okay.
Ms. Jordan, do you want it waived on both cases?
Yes.
All right. So, Mr. Rincon, tell me your full name. All right, sir, you have 2 different matters before the court. The public defender's been appointed to represent you, and they've asked to waive the reading of the charges. I have found probable cause in your new case, which is 20 CF 1947. I'm going to set bond on count 1 in the amount of $10,000, bond on count 2 in the amount of $10,000. I'm going to order that you have, if you post bond, that you have no contact with the identified victim. I'm also going to order that if you post bond, you comply with any terms and conditions of any Department of Children and Families case plan in regards to the situation. I'll also note that the state attorney's office has filed a motion for pretrial detention. I'm going to get to the Oh, okay. Got it. All right. Hold on. Let me make sure I'm announcing. 1946, count 1, bond as I. Oh, okay. I see.
It's just the PCD's not for that one.
So, Madam Clerk, let me ask you on count 1, when he was placed in custody, they set the bond at none. The state's now filed a motion for pretrial detention. So what I was inclined to do, regardless of whether I set bond now, I was going to order that he be held until the pretrial detention hearing takes place.
Yes, sir.
So ideally, I think maybe that would be the case. If pretrial detention ends up being granted, then the bond is a moot point. If it's not granted, then there could be a full exploration as to what an appropriate bond is. So on count 1, I'm going to maintain the no bond status. Count 2, I'll set bond at $10,000 with the conditions I previously announced. However, I will order in case number 20 CF 1946, the defendant be held pending a hearing and determination on the state's motion for pretrial detention. Then that takes us to 20 CF 1947. And Madam Public Defender, you want to waive in that as well?
Yes, Your Honor.
I will waive the reading of charges at the request of the public defender. I do find probable cause for each of the charges. I'm going to stay the bonds as previously set. That's $5,000 on count 1, $5,000 on count 2, $5,000 on count 3, $2,500 on count 4, and $500 on count 5. And then finally, I've been made aware that when these incidents took place, you were out on release in 20 CF 776 in front of Judge Morgan. In that case, I'm going to revoke your pretrial release and/or bond, forfeit any bond that was previously posted, and order that you be held on a no bond status pending disposition of that case in front of Judge Morgan. Madam Clerk, do we have dates for any of these 3 cases?
Next court date for 2020, CF 1946 and 1947 on demand, and let me check the previous case.
Okay.
And for 2020, CF 776, next court date, August 11th, in courtroom 5F at 8:30 a.m.
All right. That's all the court in regards to your matters, Mr. Rincon. Next, I have Antonio Rodriguez.
PD approved.
All right, sir, tell me your name.
Antonio Rodriguez.
All right, I have two matters to address with you, sir. The first is your arrest for the offense of battery and act of domestic violence. Before I set bond on that, Madam Public Defender, anything you want to address with the court?
No, not at this time, Your Honor.
All right. Sir, in that case, I'm going to set bond in the amount of $1,000. I'm going to order that if you post that bond, you have no contact whatsoever with the identified victim. You maintain a separate residence from the identified victim. I'm going to order that you not possess any weapons, firearms, or ammunition. I'm going to order that you not possess or consume any alcohol or illegal drugs while you're out on bond. So that takes care of your case where you just got arrested. I've also been made aware that you were previously out on release in 20 MM 390, an Orange County case, act of battery and act of domestic violence with the same identified victim. In that case, I'm going to revoke your bond and release, and I'm going to order that you be held on a no bond status on that case pending disposition of that case. Do we have any dates for these cases?
For the Osceola case, there's that one, 2020 MM 1655, next court date if still in jail, July 23rd, if out, August 10th, in courtroom 4A at 9:30 a.m.
All right. You're welcome. Next, I have Orlando Rosario.
PD approved.
Sir, tell me your name.
Orlando Rosario.
All right, sir, we've got two things to address this afternoon. The first is your arrest in 20 MM 1657. You were arrested on 3 charges. The first is receiving into a building for purposes of prostitution or lewdness. Ms. Merced, I've reviewed the affidavit in the case, and I'm not seeing the probable cause to support that charge.
Your Honor, there were individuals identified and spoken to by law enforcement that stated they were hired to dance topless at the party, and they also admitted that they were solicited to work the party, and then noted that some of them were there to perform acts of prostitution. And then the defendant was found with an individual in the room disclosed, and the individual admitted that they were having intercourse.
Well, I read the affidavit probably about 3 times, and then I went and read the statute. I don't think that I could read the I think when I read the lewdness statute, I do have to have some sense of what the community at large generally considers lewdness, and I'm not sure that topless dancing at this point in time is considered inherently lewd. It may be distasteful to some people, but it doesn't appear to be a prohibited or lewd activity. Had any of the individuals indicated that they had been recruited or they engaged in prostitution, then I think there's probable cause. But the way I read the affidavit is they suggested, without any type of corroborating information, that some other girls were engaged in prostitution. But there's no evidence as to how that conclusion was reached. And I understand the inference as to the fact that he was having sexual relations with someone he doesn't know. But again, there was no evidence that that was in exchange for any type of compensation. They just basically were, according to her, having sex, and they just didn't really know each other. So Based on the face of the affidavit, I don't find probable cause for count one. Do you want 24 hours on count one? All right.
Defense would object to that, Your Honor.
All right. As to count two, I find probable cause, and as to count three, I find probable cause. I will stay the bond on each of those at $500. Madam Public Defender, I can give him, like we did before, I can leave his bond on count one at $500 and readdress it tomorrow if he's not out of jail.
He's out on bond, Judge.
I'm gonna get there. So.
Yeah, in that case, I don't mind the stay.
All right, so I'll stay your bond on count five, but if you're still in custody, I will readdress probable cause on that count tomorrow. Now, the other problem you have is Osceola case 20 CF 1590. In that case, you were out on bond in front of Judge Morgan. I do find probable cause to believe that you have violated your conditions of release or bond. In that case, I'm going to revoke any bond you previously had, forfeit the bond, and order you be held on a no bond status pending disposition of that case, or until Judge Morgan enters some further order. I think that takes care of all of Mr. Rosario's matters at this point in time. Do we have court dates for the 20 MM 1657?
Next court date, if still in jail, July 23rd. If out, August 10th, in courtroom 4A at 9:30 a.m.
Is that for the new charge or the old charge?
That's for the new charge.
The 20 CF 1590, that next court date is September 15th, in courtroom 5F at 8:30 a.m.
All right, those are your dates.
Your Honor, if I may?
Yes.
Would you reconsider revoking Mr. Gardner's pretrial release in the misdemeanor case if, because I believe he was found incompetent in that case?
Well, let me ask you this. Is he currently in a incompetency status?
I believe so, yes. I can double check the message I received.
He has a competency status hearing on July 20th in front of Judge Epperson.
Do we know if Judge Epperson has, well, what's his case number again?
20 MM.
643 is the older case.
No, this is back on Carlos Gardner.
Oh.
All right, readdressing Carlos Gardner, I'm going to set aside my order revoking his pretrial release in Judge Epperson's case. I'll take no action on it at this point in time. Judge Epperson can address that when he addresses the competency status hearing on July 20th.
Thank you, Your Honor.
You're welcome. All right, so corrections, how long before I get my next group in?
It's going to be just a couple of minutes, not very long at all, sir.
Okay, I'm going to go get some water and I'll come back and do round two.
Yes, sir.
Okay.
Madam Clerk, was there a date for the motion hearing for Rincon for the PTD? No, okay.
I'm gonna give it to the clerk downstairs.
Okay,
Put it in. I don't know when it'll be though.
no problem.
Is he aggressive? No, this is the female's coming in now.
Oh.
Corrections, can you hear me?
Yes, sir, we're ready.
Oh, okay. I didn't see anybody. All right. So let me make sure I'm logged back in. All right, we're resuming first appearances. So I have an interpreter case, Veronica Cruz. Are we just using the telephonic interpreters? Okay, let me see if I've got an interpreter available.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Bar Interpreter. The interpreter has been sworn in already today.
All right, good afternoon, Mr. Morales. This is Judge Wooten down in Osceola County. I'm in my courtroom 5A, and I'm conducting first appearances with inmates at the Osceola County Jail, so they're appearing on a screen in my courtroom. I have a subject for first appearance who needs your assistance. So let's go ahead and call up Veronica Cruz.
PD approved. Case number 2020 CF 1941.
And Your Honor, if I could just request the waiving of waive the reading of the charges in this case as well.
Okay. All right, she is, Mr. Morales, I assume you can't see what I'm seeing from your vantage point. Is that correct?
That is correct, Your Honor.
All right, she's now standing at the microphone at the Osceola County Jail. Ma'am, can you tell me your name?
¿Cómo se llama usted, señora? Verónica Cruz.
Ms. Cruz, the Office of the Public Defender has been appointed to represent you.
Señora Cruz, se han nombrado los defensores públicos para que la representen.
You've been arrested for 2 crimes. The public defender has waived me announcing what those crimes are.
Usted ha sido arrestada por 2 delitos. Sin embargo, los defensores públicos han pedido que no se lean los cargos.
I do find probable cause for each of the crimes, and I'm going to set your bond and conditions of release as follows.
Y determino que sí hay motivo fundado para cada uno de esos cargos y voy a pasar a dejarles saber si hay fianza, cuánto es y las condiciones sobre su libertad.
On count 1, your bond is $2,500. On count 2, your bond is $2,500.
Sobre el cargo número 1, o relacionado al cargo número 1, la fianza es de $2,500. Y en el cargo número 2, la fianza también es de $2,500.
If you post that bond, I'll order that you have no contact with the identified victim and you comply with any requirements of the Department of Children and Families in relation to this case.
Si es que usted logra salir pagando la fianza, entonces le impongo que le está prohibido el contacto con la víctima nombrada o identificada en este caso y además que cumpla con cualquier requisito que imponga el Departamento de Niños y Familias relacionado a este caso.
Do we have a court date for her case?
Next court date on demand.
All right, that's the order of the court in regards to Ms. Cruz.
La próxima vista se anunciará cuando se programe. Es todo, señora Cruz.
Mr. Morales, before you go, I'm just going to triple check and make sure we don't have any other interpreter cases. Corrections, do you have any other inmates who need the services of the Spanish interpreter?
No, sir.
All right, Mr. Morales, thank you very much.
You're welcome, Judge. Thank you.
You too. All right, next I have Tiara Banks. All right, ma'am, tell me your name. Ms. Banks, you've been arrested on 2 cases. They are violation of probation warrants out of Orange County. The judge who issued the warrant in each of the 2 cases set your bond at none. I'll stay your bond at none on each of the 2 cases. I've already reached out to Orange County to let them know that you're down here, and they'll determine how to handle your case once the assigned judge is made aware of the situation, all right? Right, that's all for Ms. Banks.
Serrano will be appointing the public defender on our cases.
I'll appoint the public defender to represent Ms. Banks at this point in time.
Thank you.
Okay. Next is Crystal Soto.
PD approved.
Tell me your name, ma'am. All right, Ms. Soto, you've been arrested on multiple charges. The first is use, possession, or manufacturing paraphernalia to transport drugs. I believe, is it 5 or 4 counts?
5.
Second is possession of cocaine. The third is possession with intent to sell, manufacture, or deliver cocaine. The fourth is trafficking in cocaine. And I'm not actually sure what the fifth is. It's a violation of 823.13.1. And it's not a charge I'm familiar with. In any event, I've reviewed the probable cause affidavit that was submitted in this case, and I currently don't see any probable cause for any of the charges in relation to Ms. Soto. There is a reference in the affidavit to see a narrative from another trooper, but I don't see that other narrative. My reading of the affidavit is that Ms. Soto was a passenger in a vehicle that was stopped. The driver was arrested for basically all of the same charges, and the controlled substances in the case were found in containers enclosed within the trunk of the vehicle. So,
Yes, Your Honor, I was going to note the notation by the officer that there is supposed to be an attached statement of the trooper that interviewed the defendant, so we would ask for 24 hours to obtain that.
Madam Public Defender?
I would object to that extension, considering that the driver of the vehicle did make statements to the officer that he was the owner, possessor of all illegal substances inside of the car.
All right, under the circumstances, since there clearly was a reference to, I believe, an interview with this defendant, I'm going to give the state 24 hours to provide any additional information that would establish probable cause for this defendant. So I'll reset her. And again, Madam Public Defender, I don't know what her ability to post bond is, so I can leave the bonds in place and bring her back in 24 hours if she would rather get out versus deal with this, or I can bring her back in 24 hours.
Would you mind if I inquire with the defendant?
Go ahead.
Ms. Soto, would you like to have the ability to bond out of jail if you can? Or would you prefer to see if there's no probable cause for your arrest?
I didn't make that up. Ma'am, let me just put it to you slightly differently. I'm going to bring you back tomorrow. If the state can't provide additional information, I'm going to release you on your own recognizance on all the charges, which means you don't have to post any bond. If you don't want to wait till tomorrow to find out the answer to that, then I can just leave in place whatever bonds were previously set, and you can choose to post them if you wish, or you can wait to see what happens tomorrow. It's up to you. You want to wait to see what happens tomorrow? All right, I'll reset our first appearance for tomorrow to see if the state can establish probable cause. Madam Public Defender, the jail still wants to know what I did with the original bond, so I'm going to stay on pending a probable cause determination tomorrow. All right. And then I have Tessa Van Houten.
PD approved.
Tell me your name.
Tessa Van Houten.
Ms. Van Houten, you have two matters before the court. The first is an arrest on a warrant out of, I believe, Okeechobee County. The judge who issued that warrant set your bond at $1,000. I'll stay your bond at $1,000 in that matter. And then there are your new charges. Actual or constructive possession of synthetic cannabis and 2 counts of possession or use of drug paraphernalia. I find probable cause for each of those counts. I'll stay your bond as previously set in each of those counts. Madam Clerk, do you happen to have those numbers easily discernible?
Yeah, count 1 is $1,000, count 2 and 3 is $500.
All right, so it's 1,000 on count 1 on your case here, 500 on counts 2 and 3. All right, and then 1,000 on your Okeechobee County case. So you can post all those here. You don't have to wait for Okeechobee to come back and get you. All right? All right, that's the order of the court in regards to Ms. Van Houten.
Next court date on demand.
I felt like I had more. Did some people post or get reset or something?
That's all I have on my list, Your Honor.
You want to go find some more?
No, I don't think so.
All right. We're on a roll. All right. I think you're going to see Judge Morgan tomorrow. I'll be doing other matters. So, but then you'll probably see me later in the week. All right.
Thank you, sir.
All right. Have a good day. Thank you. You're welcome.
the jail fees, but we have no inmates yet. Afternoon. Can't hear you.
I'm sorry, Your Honor, the people are on the way out. We went a little long in first appearance.
No problem, thank you.
Judge, I know there was some discussion this morning about having a bond hearing as well on Rodney Blair. I just don't know if that was.
We were going to do a status hearing.
Okay.
His intention, it's a status, but what he wanted was a bond hearing.
Well, we were going to do a status hearing. I wasn't going to do a bond hearing without notice to the state.
Yes, Judge.
But I think he wanted to chat with the prosecutor anyway. Did Mr. Thompson get a hold of you?
We were speaking last week, and I saw that he had asked late Friday for a bond motion. I won't speak about the merits about it, but I thought it was a pretty quick motion if we got to it.
Is Mr. McCullough's case going to be an admission this afternoon?
Yes, Your Honor.
Has he filled out a form? Has he signed a written form?
He has been in custody and I haven't had access to him other than by telephone. But he is prepared to go forward today and admit the violation.
All right.
I did review his waiver of rights, just the general one that I use for violations of probation. I did that by telephone.
On Mr. Hatchell's case, is either side anticipating any witnesses or evidence? It's just
None
argument.
from the state, Your Honor.
Okay.
Did file an information, but that was just today, so it probably hasn't hit yet. Going forward for Arthur.
I haven't received the information yet.
It might. I literally just gave it to my assistant like at noon when I left the office, so it might not even be up yet. It's 2 counts of controlled battery of a child under 18 by a person in familial or custodial authority, and 2 counts of lewd or lascivious molestation.
Okay. All right, is this Mr. McCullough?
This is Mr. Blair, Your Honor.
Okay, Mr. Blair, we're waiting on Mr. Thompson for your case.
Your Honor, for my case, I anticipated just calling my client for some questions as far as any witnesses. I don't have any other witnesses besides my client.
That's fine. All right, Mr. McCullough,
Yes, sir.
if you'll raise your right hand, sir. Your other right hand.
Oh,
Your-
my fault.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, please state your name.
Jacory McCullough.
Ms. McCullough, you are here this afternoon in case 17 CF 435, in which you were placed on probation for 1 count of burglary of a dwelling and 2 counts of grand theft of a firearm. The burglary of a dwelling is a second-degree felony, which is punishable by up to 15 years state prison, up to 15 years probation, and/or a fine of up to $10,000. And the 2 grand theft charges are each third-degree felonies, which are punishable by up to 5 years state prison, 5 years probation, and/or fines up to $5,000. Do you understand?
Yes, sir.
You've been accused of violating your probation in this case. It is alleged that you willfully violated Condition 5 by committing the offense of driving without a valid driver's license on or about April 17th of 2020 in Marion County, Florida. Do you understand what the allegation is?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated, and you could be sentenced to anything up to the maximum sentence, which would be up to 25 years state prison. Do you understand?
Yes, sir.
Ms. Kohler is on the line. You can't see her, but I can see her on the video link up here. And she has indicated that you wish to resolve this case today by entering an admission to the violation. Is that what you want to do?
Yes, sir.
Okay. Ms. Kohler indicated that she had gone over your rights with you. Did you understand everything that she talked to you about?
Yes, sir.
Okay, I'm going to discuss some of probably the same matters with you as we go through this. If at any time you have any questions, let me know. If you change your mind and decide you do not wish to enter an admission here today, that's fine too. Just let me know. First of all, are you presently under the influence of any medication or other types of drugs or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced, pressured, or in any way forced you to enter this admission?
No, sir.
Okay. I'm going to ask Ms. Kohler to state any agreed upon resolution of the case, if she would.
Yes, Your Honor. I've been in discussions with Peter Donnelly on this case, and he was recommending that his supervision be revoked and terminated. He was recommending 200 days county jail time on this. I called the jail today to verify his credit calculations. He actually has 197 days jail credit. I can tell the court that as far as the no valid driver's license, what happened on that is he was offered diversion in Marion County, and he took care of that. He actually obtained a valid Florida driver's license, and we gave a copy of that to Mr. Donnelly. So that's based on my client taking those steps to get a valid Florida driver's license. The state is giving him some mitigation here or credit for doing that. So
All right.
just want to put that out to the court.
Okay. Madam Clerk, what's the time served you have?
I'm gonna recheck.
Okay. Clerk had a different amount of time served, so we'll check that and see where the discrepancy is.
I can give her the dates at the.
Well, hold on, let her check her figures first. And while she's doing that, Mr. McCullough, is that your understanding of the agreement?
Yes, sir.
Okay. The state, you'd be recommending the downward departure sentence?
Yes, Judge, the state is recommending a downward departure sentence. I'm interested to see what the credit time served is that the clerk has. I had it much closer to about 130 days, and the offer was for him to do about 70 days additional to that. I don't think that it would be appropriate to do essentially a credit time served offer here after he violated his probation again.
If I may just give the state, I called this morning and the jail gave me the dates. He was originally arrested February 13th, 2017. He was released March 22nd, 2017. He had a violation 3/26/2018. He was released 4/27/2018. Then he had another violation August 20th, 2018, but he was not released until 11/24/2018. And then he got arrested on this one June 15th, and he's been in until today, which is July 13th. In my calculations, it's 197 days.
Okay, showing, and I don't know what occurred before it, but when he was sentenced on July 23rd of 2019 for the violation of probation, he was given credit for 106 days time served at that time. And then he's arrested on June 15th of this year.
This is the problem. Nobody took him, on August 30th of 2018, he was sentenced to 6 months OCJ. So those 180 days are nowhere in those calculations. So I come up with
Okay.
that's why it is original 43, and we got the 180, which has assumed it to that. So 180 plus the OCJ. When they calculated, they took it out. So the original 43, which was assumed, got 6 months there. Was 63, so it's 180 plus the 29 that he has as a case, so it's 209.
Okay, the clerk is now calculating 209 days. So, Mr. Donnelly, do we have a meeting of the minds, or do you need to talk to Ms. McCullough further, or?
I don't think we have a meeting of the, I'm not denying that he has 209 days, if that's what the clerk is reading out, but we don't have a meeting of the minds of the offer at that point then. This is his 4th violation of probation. He is anti-murder because of the original crime. I do think it's appropriate to downward depart because his violations have been mostly technical in nature and then this no valid driver's license. I'd like to give him the benefit of the doubt. I'd like to get him off probation so that he's not racking up 12 points every time.
That makes sense, but if you need to talk further, we can just reset this in the next day or two. I don't know what your calendar's like, Ms. Kohler, but we could reset it for tomorrow if you have a chance to talk to Mr. Donnelly between now and then, or reset it for later in this week.
We can reset it for tomorrow if the court has time to hear it.
So we'll make time. Do we have an afternoon docket tomorrow, do you know?
You have something that you're going to address at IAs, which is the same guy from the fugitive warrants about it. You have 3 in the morning and 9.
Okay, could you be available tomorrow morning at around 8:30 to 9?
Yes, Your Honor.
Okay. You have a chance to talk to Mr. Donnelly between now and then? You can be in the office, Mr. Donnelly?
I'm not sure if I'll be in the office, but I could appear virtually.
No, but I mean this afternoon, so you all.
Yes, I'll be in the office.
Okay. All right, Ms. McCullough, we've got to work out the final details on your admission, if it's going to be an admission. So I'll reset you for tomorrow morning at 8:30, and hopefully that can be resolved and we can address it then.
Oh, okay.
All right?
Yes, sir.
Thank you. Ms. Kohler will be in touch with you as well, I believe. Thank you.
Thank you.
Let me just give you.
Keep your file.
Yeah. Receipt and file. All right, then we have Mr. Hatchell. We have Mr. Hatchell back there?
Yes.
Okay, we can bring him forward when you get a chance. In this case, 20 CF 1790.
And Judge, there's also a 20 CF 1789,
Okay.
which is actually the lower case number, and it's the one I filed the information on. They sent it in twice. I don't know why. But
Okay.
there's like a
Hold on one
duplicate.
second. 20 CF 1789.
Yes.
All right, good afternoon, Mr. Hatchell. If you'll raise your right hand, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name, sir.
John Patrick.
Okay, and the information is filed in that case, so that's, the other cases encompassed into this?
Yes, Judge, I filed them both under the 8-9 number since
Okay,
they just had one charge initially and then added others with the whole separate case later.
your
But
encompassing,
it's same, yeah.
your encompassing stamp doesn't list that it pulled in the charges from
It did.
20
Ah,
CF.
darn. Okay. Case management must be screwed then.
1790.
It was supposed to, so I'll do that.
Okay. All right, well, let's, since the information has been filed, we'll go ahead and proceed with the arraignment, then we'll address the bond. Oh, it was waived? But, okay. Oh, yeah, it's already set for trial. Okay. All right, so, and 7, 8, 9. Okay, it's a little bit confusing as to what the bonds are now, because the charges are slightly different from what the arrest charges in both cases.
Right.
The bond was set on the 2 lewd or lascivious molestation charges. In the amount of, actually, there were 3 originally, lewd and lascivious molestation charges. The bond was set at $10,000 as to each charge. And then the arrest charges were sexual battery on a person 12 years of age or younger. The bond was set at 0.
Right. She was 12, so that's why I wanted to file the information before the bond hearing, because I knew that some of the charges were a little wonky.
That's fine. Okay, so Mr. Hatchell is here and charged with 4 counts in the 2 cases which have been, I will just orally consolidate them pending
I can file a new information once I'm back in the office.
if you will, but just so that whatever we do here now will be adequately or accurately understood by the jail, I'll go ahead and consolidate 1790 with 1789. All right. So, Mr. Bano, was there any evidence or testimony you wish to present?
Your Honor, just a quick question. I have for the state, the sex battery, is that under what statute are those filed? Is it a capital or is it?
No, it's the first punishable by life. Is sexual battery with a child 12 to 18 years of age by a person in familial or custodial authority. Okay. And that's counts 1 and 4. The counts 2 and 3 are the lewd or lascivious molestation, which are both F2s.
Okay. Well, in that case, Judge, we're asking the court, just for the sake of argument clarity, on the lewd and lascivious, if the court wants to live bond is set, and then we can make arguments on counts 1 and 4. For the court set bond.
Okay. That's fine. Mr. Hatchell, you look a little confused, and I don't know if you're able to hear what's being said here. Are you able to hear me?
Yes, sir, ma'am.
Okay. Your attorney, Mr. Bano, is on the line. I'm seeing him by video. I've turned up the volume a little bit on the computer, so hopefully you'll be able to hear him. So, Mr. Bano, if you want to ask any questions you have.
Yes, Mr. Hatchell, how long have you lived in the Osceola County area for?
About 7.5 years.
He said about 7.5 years. And if you'll speak up too, we're having a hard time hearing you. Okay.
And do you own a property?
Yes, sir.
Okay. How long have you owned the property you currently have for?
About almost 4 years.
And you own a property prior to that?
Was in Bellalago.
Okay. And what do you do for a living?
I'm retired, military, and Social Security.
Okay. Who do you live with at your house prior to being arrested?
My wife, my daughter-in-law, which is the children's nanny, which is 4 great-grandchildren.
Okay. Do you have any prior arrests of any kind?
No, sir.
And if the court were to grant you bail, would you promise to appear to any and all future court appearances?
Yes, sir.
Okay. Do you have a car?
Yes, sir.
Is that a no or yes?
Said yes.
Oh, yes, okay. Do you have any medical issues that you need a doctor for that the jail is not adequately providing for you?
Not really. I mean, I have, they say I'm a diabetic, type 2, but I have high blood pressure, and I have a hard time breathing sometimes.
So did you say shoulder? I didn't hear the answer though.
All right, he said he had diabetes and he has blood pressure. He has a hard time breathing sometimes.
Okay. What about, do you have any injury with your shoulder, Mr. Hatchell, that you need to see a specialist for?
Yes, I still need to see my orthopedic surgeon.
Okay. And is it correct to say the jail is not adequately providing for those issues for you?
Say again?
Is the jail adequately providing care for those issues for you?
Yes.
The jail is providing adequate care or is not?
I didn't understand.
I was asking whether the jail was providing you with adequate medical care or not.
As far as, medical, but, they haven't done anything with my shoulder, but.
I'm sorry, I didn't hear the answer, Judge.
He said as far as his medical issues, but not with respect to his shoulder.
Okay. Your Honor, I don't have any further questions for this witness at this time.
All right, state any questions.
Sir, how much could you afford for a bond?
How much could you afford for a bond?
I couldn't understand it.
How much could you afford for a bond?
Right now, I'm very little. We've taken all the money we've had in savings and paid the attorney. We got a little bit of equity in the house, but that's it.
Sir, has anybody agreed to help you post a bond? Any friends, family?
Well, my sister up in South Carolina said she would try to, help me if she could. But she didn't say how much she could afford.
Okay. Sir, if you were not able to go back to your house, is there anywhere else that you could live?
I didn't understand that one.
If it were a condition of your release that you were not permitted to go back to your residence, could you find another place to stay?
Yes, I could.
I think that's all I have, Your Honor.
All right,
Your Honor, may I have a follow-up?
sure.
Isn't it true, Mr. Hatchell, that the children, or the child in this case, along with the other children you adopted, the DCF has them now, correct?
I don't understand that.
Do you know where the children are now?
No, I do not.
They're not in the home with your wife, are they?
No, they're not. Well, I understand they're with a pastor, but I don't know where that's at from our church.
They are with UCF right now, Your
All right, any other questions, Mr. Banner?
No, Your Honor.
All right. All right, then, argument, Mr. Banner?
Your Honor, we understand some pretty serious charges here. However, based on a review of the probable cause affidavit, the only evidence the state has is the allegations made by the 12-year-old. And I think she made some allegations that my client was abusing the 10-year-old, and the interview of the 10-year-old revealed that she denied any such abuse. So at this point, there is no physical evidence, there is no confession, there is no DNA. There's just a 12-year-old, which, based on my understanding of what's going on, she has a tendency and history of making such accusations. She's accused her father in South Carolina of similar charges, which were dismissed, which we'll get to discovery on the case. But based on the flimsy, based on a very weak, from what I see from the probable cause here, Judge, we're asking the court to consider granting a reasonable bail to Mr. Hatchell. He's 72 years old. He has never been in trouble with the law. He has ties in the area. He has lived in Osceola County for 7 years. He owns property here. He lives with his wife and his daughter-in-law, if I heard him correctly. He has a car. He promises to make any and all future court appearances. And the state has presented no testimony that the presumption is great, and that the state, and that he should have no bond. So we're asking the court to grant a reasonable bond on counts 1 and 4 of the information that was filed today.
All right, thank you. Ms. Adams?
Yes, Your Honor, I am agreeing to a bond, so I'm not going forward under Arthur, so I agree that you should set a reasonable bond in this case. I do have concerns for some other children that are in the home, so one of the conditions that I would ask is that he not have contact with any child at all. It's my understanding that the children in this case were adopted by the defendant and his. There is concern both on my part and DCF's part about whether the other children have also been abused in some way. There was a disclosure to the victim by one of the other young ladies that she was abused, but she did not disclose that to DCF. So I know there's not outright disclosures from the other children, but there's certainly concern for the other children. And given this allegation, I'd ask that he not have any contact with obviously them as well as any other child. I don't believe that his wife in this case is at supervision at all, since she does not believe the victim and literally slapped her in the face when she disclosed. So I don't think she's going to be able to protect the other children. That's the condition that I want, Your Honor.
Your Honor, I think the other children are with DC. I don't think any of the children are in the home. I think DCF took all of them. I don't represent Mr. Hatchell in the dependency case, but my understanding is that the children are all gone, are in DCF custody. It's not just this particular child.
That's fine. All right, I will set bond in the amount of $10,000 as to each count. And we'll make clear that the bonds in this case, that covers 20 CF 1789 and 20 CF 1790. It will be conditioned upon Mr. Hatchell not having any intentional contact with any child under the age of 18. So if there are children living at the home, you will have to find another place to stay, at least on a temporary basis. And you're to avoid any contact with any minor children while this case is pending, unless the conditions of bond are subsequently modified. And that would, of course, include specifically the child who's the named victim, Miss Isabel Jenkins, as well as any other child. I don't think there are any other conditions that are required, so your total bond is $40,000, sir. All right. Thank you.
Thank you.
Yes.
Every
day.
Now, question is, Mr. Thompson, are you with us? Mr. Thompson, are you there? There you are. Okay. We're having some glitches again. All right, Mr. Blair, if you want to come on up. And what's this case number?
It is 2017-3125.
1325.
3125.
3125. All right, good afternoon, Mr. Blair. Mr. Blair, this morning, just so you know, your attorney was online. He was waiting to be to address the court, but I'd pulled up the wrong Teams meeting. I'm not a pro at this, and so I didn't find Mr. Thompson until after you'd been taken out of the courtroom. And we talked briefly about your case. He had asked that this be, I guess, a status this afternoon. I don't know, you've had a chance to speak with the prosecutor since this morning, Mr. Thompson?
No, Your Honor, I have not. I have not had opportunity to do so. I don't know if he's present on, I don't see that he's present on here, but.
He's present in the courtroom, Mr. Donnelly is.
Okay. How you doing, Mr. Donnelly?
Good, how are you?
I guess what I'm looking at right now, I'm trying to see, and I'm printing out the score sheet right now, Your Honor.
Okay.
I don't know if the court has previously adjudicated Mr. Blair as a habitual violence or habitual felony offender. And I think
I don't think it requires an adjudication. I think he just has to meet if he meets the criteria pursuant to the statute, that creates a problem.
I'm trying to figure it out by looking at the score sheet. Is it because of his, I guess, the robbery?
I'm assuming it's the prior armed robbery convictions. Let me take a quick look at the statute again.
Okay. Well, Your Honor, I was hoping that we could just get him a resolution today with this. And I know the state's position may be, Mr. Thompson, I'm known to ask for a little extra, but I was hoping that we could resolve this because there's so many things going on in addition to this violation. And I just think hopefully we have some mitigating circumstances that the state would be willing to consider in addition to the things that I filed in the motion to set bond. Since he's not entitled to bond, it is my hope that we can just resolve this and just, I don't see any other way we can do this if he's not entitled to a bond other than trying to resolve this. And if that is the case, with the information that I provided to Mr. Donnelly, it is my hope that he has had opportunity to speak to the prosecuting attorney in Hillsborough and is now able to let me know or represent to the court what would be the alternative sanction that my client could be potentially considered for under the circumstances.
Okay, well, I'm just looking under 948.06 subparagraph 8B. It says, for the purposes of this section and others, the term violent felony offender of special concern means a person who is on, and subparagraph 2 says felony, probation, or community control for any offense committed on or after the effective date of this act and has previously been convicted of a qualifying offense. And for the purposes of this section, qualifying offense means includes robbery or attempted robbery. So I think that's where Mr. Blair has a problem as far as qualifying for bond, because then under section D it says, in the case of an alleged violation of probation or community control other than failure to pay costs, fines, or restitution, the following individuals shall remain in custody pending the resolution of the probation or community control violation. And it includes any violent felony offender of special concern as defined. So it does appear that under 94806, that the court at present does not have the authority to set a bond because of Mr. Blair's prior offenses. Now, I think the key is going to be, as you suggest, the situation in Hillsborough County. And you say that, I think you said earlier, those charges are still pending, but you felt there was the alleged victim was not wanting to proceed or had completed a declination. So that may convince the state not to proceed with those alleged violations. But I don't think Mr. Donnelly's in a position to make that decision today. Mr. Donnelly, have you had a chance to speak with the prosecutor in Hillsborough?
Yes, Judge. I've spoken with the prosecutor. We've discussed the strengths and weaknesses of the case. We don't have all the information at this time, but the moment I'm aware of whether or not they're able to proceed, I will inform Mr. Thompson, because I think it is just a threshold issue on the evidence. It's either there or it's not. It's not a case that I think would need to go to a hearing. So if we don't have the evidence, I'll let Mr. Thompson know right away and ask for dismissal.
Okay, well, we'll try to, it's set for a violation of probation hearing on September 24th with status hearing September 22nd. If both sides are ready, I'd be willing to move it up and we could set it specially for a time before that if it's going to be a hearing. If the state decides not to go forward as to the alleged violations of Condition 5, then that would remove the issue. I think you'd indicate there's a valid issue on the community service due to an injury Mr. Blair suffered from, or something of that nature.
We have two good issues that I think that I should speak on: the issue of his physical ability to actually perform community service, and then secondly, COVID pretty much precluded his ability to actually perform if he was even in the position to do so because of the pandemic, social distancing, and not really having a facility that was able to allow him to do so.
Well, that would cover at least part of the time, but
Yeah, that part of the time, I know, right?
he was placed on probation last October, so that wouldn't necessarily be resolve all the cases. Mr. Blair, I know you want to talk. You started to speak this morning about the community service issue. Talk to Mr. Thompson about that. Again, we're not going to resolve that matter this afternoon, but the bigger issue is the alleged new felonies in Hillsborough County. And if the state decides it's not going forward on those, then I think your case is going to be easily resolved and Mr. Thompson can get it squared away for you. If the state's going forward on those, then we will have a hearing. We'll just try to do that as quickly as we can. So pursuant to Florida Statute 948.06, I will deny the motion to set bond at this time. All right.
Thank you. Appreciate the time to be heard today. Thank you.
Okay. So, Mr. Blair, not the news you wanted to hear necessarily, but Mr. Thompson's working on it. He'll try to get it resolved as quickly as he can.
No, so I was gonna say what day I had surgery, that's it.
I'm sorry?
You put me on house arrest on 2018, October. I had surgery January 19. So I had surgery like 3 months after.
Okay, well, that's fine. That's the least of your worries at this point, but okay. Thank you. All right, thank you, Mr. Thompson.
Good to see you guys. Have a good day.
You too. Sorry to keep you waiting so long.
No worries, John. I'm okay. Thank you, Jeff.
Take care. All right.
Did we set that,
We set for a violation probation hearing.
the other gentleman that was up here, Jacory McCullough, did we set him for 2 p.m. tomorrow?
For
8:30 tomorrow.
Okay.
All right. Well, then we'll be in recess until tomorrow. Now, I am covering IAs tomorrow, so if you talk to Miss Kohler or what,
Yeah, Melanie Kohler.
you talk to Miss Kohler and you two would rather do it after IAs, we could do it tomorrow afternoon.
Yes, Judge.
1:30 or so. Right.
Remember the guy that you kicked down to Friday for Karsten? Karsten kicked it back to you.
Oh, yeah, you told me.
I get an email from Tag, you're it. It's like, we're bouncing the guy around like a ping pong.